Good morning. This is the Energy and Carbon Management Commission for the state of Colorado. It is Wednesday, November 13th at 9 a.m., and we are calling our meeting to order with a roll call.
Thank you, Commissioner Ackerman.
Here.
Commissioner Cross.
Present.
Commissioner Mesner.
Here.
Commissioner Oath.
Here.
Commissioner Ogletree. Commissioner Robbins.
Here.
Mr. Chair, you have 5 commissioners present.
Great. Good to see everybody. Welcome back to a normal Wednesday business agenda. I have a couple of matters on our agenda today. We start with commissioner comments. Does anyone have comments? Commissioner Ackerman?
Thank you, Mr. Chair. I'll just make a quick comment about the IOGCC, the International Oil and Gas Compact Commission that was in town that meets twice annually. And they met in Colorado Springs this last couple of weeks ago. And Chair, I don't know if you intended to make any comments, but the Chair had an opportunity to kind of play host and help welcome people to Colorado. And I think Colorado had a great opportunity to kind of showcase what it's doing with regard to the oil and gas space. We got a lot of questions and opportunities to communicate with fellow regulators in other states and an opportunity to talk about some of the continual ongoing expansion of opportunity, not just in our state, but in other states as well. So it was a great conference and an opportunity to both learn and to communicate with other regulators and important industry contacts. So just wanted to let you know that the chair and I were there, and I hope I didn't preempt you, Chair, from any of your comments.
Not at all. I was hoping you'd make some statements there. It was a good conference. We were pleased to have the governors of Wyoming and Alaska, as well as our own governor, Polis, able to make some presentations to the IOGCC. I felt we were pretty well received there in Colorado Springs, and looks like a lot of the states are, following our path on terms of doing other things relevant to energy development. So glad we were able to showcase our state and have folks come along. Other commissioners with comments? Move to consent agenda. Does anyone have questions on consent? Do we have a motion to approve consent?
So moved.
Second.
Motion and a second to approve consent. All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries. We now move to our first oil and gas development plan, docket 230900310, an oil and gas development plan proposed by Bison Operating. And I believe we need to elevate the attorney for Bison and their witnesses.
Good morning.
Good morning, Ms. Weslinky. Good to see you.
Looks like our witnesses are still being impaneled.
If they want to visualize themselves once they're up and running, then we'll be able to swear them in.
Thank you. If everyone could please turn your cameras on, I believe just Dawn. And I think we've got everyone.
Assistant Attorney General Mercer.
Thank you, Mr. Chair. Good morning to the panelists. I will just swear you in before we get started, and I'll go one by one and ask you to raise your right hand, state your name, and that you swear to tell the truth. I'll begin with Mr. Meyer.
My name is Bennett Meyer, and I swear to tell the truth.
Thank you. Ms. Gillen? You're on mute.
My name is Katie Gillen, and I swear to tell the truth.
Thank you. Mr. Hogan?
My name is Ian Hogan. I swear to tell the truth.
Thank you. And Mr. Koenig?
My name is Don Koenig. I swear to tell the truth.
Thank you.
All right. With that, the panel is yours, Ms. Weslinky, if you desire to move forward.
Thank you, Chair. We'll pull our PowerPoint up and then I will get started. Perfect. Let's just get that in presentation mode and then we should be good to go.
That's shown up for everybody.
It is. It's not up there. There it is. Perfect. Well, good morning, commissioners. My name's Kelsey Wazelinski with Jost Energy Law. And with Jamie Jost, we represent Bison 4 Operating LLC in the Remora OGDP before you today in docket 2309-00310. We would like to thank Arapahoe County for its support and participation in the AUSR process for the Remora OGDP, and also ECMC staff and the director for their efforts on this OGDP. Next slide. Maybe it's there. There we go. This OGDP requests that the Commission establish an approximate 4,446.49 acre OGDP for the development of 16 new horizontal wells from one new oil and gas location, the Remora 6 pad, for the development of the Niobrara, Fort Hays, Codell, and Carlisle formations. The OGDP also requests that the Commission approve 2 amended drilling and spacing units and establish 1 new drilling and spacing unit, totaling 7 sections as shown on this map. The proposed location is within Arapahoe County, and Bison submitted the AUSR in July of 2024. As Bison will describe today, the AUSR is in its final stages of review with the county, and Bison expects approval by the end of this month. Bison maintains that the Remora AUSR meets the administrative approval criteria in the Arapahoe County Land Development Code. In addition, the county supports Bison's concurrent permitting process with the county and the ECMC. And pursuant to Section 3460-1061F of the Oil and Gas Act, Bison will not commence operations without final disposition from Arapahoe County. As Bison will describe today, no Rule 304B2 ALA criteria apply to the proposed Remora pad. Specifically, the location is over 3,200 feet from the nearest RBU and over 1 mile from the nearest DIC boundary. When Bison submitted the OGDP, both the location and the proposed access road were outside of HPH. Effective November 30 of 2023, a portion of the proposed access road does fall into the Pronghorn Winter Concentration Area HPH, and therefore Bison voluntarily consulted with CPW and agrees to several BMPs, including that Bison will commit to constructing the access road between May 1 and December 31. As part of the Remora OGDP, Bison has committed to several BMPs to avoid, minimize, and mitigate potential adverse impacts, which Bison will describe today. To highlight a few, Bison is planning on a Tier 2 dual-fuel drilling rig with battery assist, Tier 4 engines for completion, an electrified production facility, and has committed to gas takeaway for all wells. Bison is planning on 2 occupations for this development plan. After the drilling of the first 5 wells, Bison commits to having oil and produced water pipeline in place for the remaining 11 wells. With respect to the spacing requests, Bison's application is supported by land, regulatory, engineering, and geology testimony. We will address one item of clarification stated in the ECMC engineering review in the presentation today. And finally, Bison has complied with all notice requirements for the Remora OGDP. No formal petitions were filed, and no public comments were received on the Form 2A. So I'll now turn it over to Katie Gillen to continue the presentation.
Thanks, Kelsey. Good morning, Chairman and Commissioners. Thank you for the opportunity to present our Remora 6 OGDP application to you. We appreciate your time and attention. My name is Katie Gillen. I am the Vice President of Regulatory Affairs and EHS at Bison. Joining me today as panel members are Ian Hogan, Executive Vice President of Exploration and Geology, Don Koenig, Executive Vice President of Reserves, and Bennett Meyer, Land Manager at Bison. Next slide. We would like to provide you all with an overview of our permitting timelines for the Remora 6 location. The Remora 6 surface location is sited within Arapahoe County, and they are the relevant local government with surface siting authority. Our Arapahoe County pre-application meeting was held July 13th of 2023. The Arapahoe County Planning Division representatives and energy specialists were present. Our AUSR application was submitted to the county on July 26 of 2024, and the application is in the final stages for review and approval. Bison obtained the director's recommendation of approval of the Remora 6 OGDP on August 1st of 2024, and there was no public comments received on the 2A. Additionally, I will note that there are no federal minerals that will be developed with this OGDP. Next slide. We would like to provide you with further insight of the Arapahoe County's permitting process and our phase of our application. The Arapahoe County pre-application meeting was held on July 13th of 2023 with Arapahoe County Energy, Planning, Building, and Engineering Departments representatives available or present. All aspects of the development were discussed at this time, including Bison's development plans, timing, operational phases, our proposed BMPs, and all county permitting requirements for review and approval under the administrative review criteria. Bison held the required neighborhood meeting on October 25th, 2023 at the Bennett Community Center. And we submitted our Arapahoe County AUSR permit application on July 26th of 2024. We have since undergone 2 rounds of staff review, and our revised application was deemed complete for review on October 24th of 2024. Staff have confirmed they anticipate final review to be completed by the end of November. Next slide. Bison would like to note for the commission that Bison received a letter of support from Arapahoe County Energy Specialist on June 13th, 2024 for pursuing concurrent permitting of our OGDP and our AUSR application. We would also like to note that no ALA criteria is applicable to this location, and therefore no ALA was required. Nothing prohibits this commission from approval of the OGDP prior to approval of the local government siting disposition, particularly as the proposed location has no ALA criteria under Rule 304 B2B. We have a letter of support from the county to pursue concurrent permitting. And furthermore, our AUSR application meets the administrative approval criteria under the Arapahoe County Code, Land Development Code. And as Kelsey had mentioned, pursuant to the section 3460-1061F, the OGDP can be approved without final disposition by local government. Bison fully acknowledges and commits to not commencing operations without final disposition from Arapahoe County and approval of our permit. Next slide. Next slide. Oh, looks like it skipped one. Arapahoe County provided this letter regarding the status of our AUSR and noted that delays to the permitting review are due to a vacancy in Arapahoe's oil and gas permitting division. However, our Remora 6 AUSR application is in the final stages of review with Arapahoe County, and we anticipate final review and approval by the end of November. Next slide. While Arapahoe County is still in the process of reviewing our application and as such could not confirm whether the Remora 6 meets the county siting requirements, we have provided a reference map here to show that the Remora 6 proposed location is compliant with the county's siting setback requirements as approved in the latest amended Arapahoe County Land Development Code. The Remora 6 location is compliant with all setbacks, including riparian, floodplains, public right-of-ways, platted parcels, occupied structures, adjacent property lines, lakes, designated outdoor areas, proposed reservoirs, and existing public water supply reservoirs. Next slide. As you can see, this map clearly illustrates that our proposed location is compliant with all the county setbacks. We would also like to note that the Remora 6 location was also slightly moved from our original proposed location from the pre-application meeting with Arapahoe County to comply with the 200-foot setbacks from adjacent property lines as depicted here. Bison believes the siting of this location reflects our efforts to avoid impacts by complying with and avoiding all ALA criteria under 304 B2B, as well as all of Arapahoe County's setback criteria. Next slide. The Remora 6 OGDP contains a single surface location where we will develop 3 DSUs totaling 4,446 acres of mineral lands and a total of 16 wells. The northern DSU will have 5 2-mile lateral wells drilled from the west to the east. The center DSU will have 6 3-mile lateral wells, and the southern DSU will have 5 2-mile lateral wells. The pad will be 20 acres during construction and will be subsequently interim reclaimed to 9.52 acres. The facility will be equipped with permanent production equipment, including 5 oil tanks and 4 produced water tanks. Given the lack of development in the area, with the nearest producing well being well over 1 mile away, Bison considers this step out an exploratory well to test the reservoir and obtain additional data to optimize our subsequent development of the remaining wells. As such, we are planning to develop the location in 2 occupations, and we'll drill up to 5 wells in the first occupation, and we'll drill the remaining wells in the second phase, once adequate data is obtained from the initial development. Bison will connect to gas pipeline at first production, and we plan to construct oil and produced water pipeline takeaway for the second occupation. Next slide. The Remora 6 is in a remote area of non-irrigated cropland in unincorporated Arapahoe County, which is zoned as agricultural by the county. The location is approximately 3 miles southwest of the town of Bennett. We have included a map depicting cultural features under Rule 304 B2B to highlight the remote nature of the location and to show that no ALA criteria are met. There are no residential building units or high occupancy building units within 2,000 feet, and the location is not within a disproportionately impacted community. The pad is also outside of high priority habitat. However, a small section of the access road is within the winter pronghorn concentration area. There are no nearby sensitive water receptors, and the location is not within a floodplain. Furthermore, the Remora 6 also meets all of the Arapahoe County's required setbacks. The location is also set back from the public road a half mile, which allows for visual screening. Additionally, the Remora 6 provides ideal access to underlying minerals and has close access to Interstate 70. Next slide. Bison will develop the 3 DSUs from the Remora 6 in 2 occupations. Pending permit approval at this of the OGDP and the Arapahoe County permit, We intend to begin construction on October of 2026, and the access road will be constructed outside of the winter pronghorn timing restrictions. We'll start drilling November of 2026. Completions will start December of 2026, and we anticipate first production to be January of 2027. Our second occupation is planned for August of 2027, and we anticipate first production to be January of 2028. Bison plans to install oil and produced water pipeline for the second occupation. Oil pipeline is over 4 miles away from the location, and there is currently no produced water pipeline infrastructure in the area at this time. Bison determined that constructing and installing oil and produced water pipeline infrastructure for the first occupation would lead to greater impacts of surface disturbance than with trucking. Our anticipated average daily trucking is expected to be 14 truck trips during the flowback phase, and 7 during oil truck trips during the production phase, and 4 water hauling truck trips during the production phase. Next slide. Bison has included best-in-class BMPs to avoid, minimize, and mitigate impacts during drilling and completions, and this includes our drilling rig is powered by CNG dual fuel with battery assist. We will utilize Tier 4 engines for completion operations, and we will utilize Group 2 drilling mud. Next slide. During the production phase, Bison will implement the following BMPs to avoid, minimize, and mitigate impacts. The facility will be equipped with gas pipeline at first gas sales, and we are planning to install produced water and oil pipeline for the second occupation. We have utility line power for the production equipment, and we will install automatic tank liquid level gauging on our production tanks to reduce associated emissions from gauging. Next slide. In conclusion, there were no opposing public comments received on the OGDP, no ALA criteria were met, and staff found that impacts to public health, safety, and welfare will largely be avoided, minimized, and mitigated by the successful implementation of our site-specific BMPs. We'll also note that Bison has agreed to construct the portion of the access road in winter pronghorn concentration area outside of the timing steps. Next slide. We would like to address engineering staff comments on our application regarding the variation in well spacing on the northern and southern DSUs with 5 well density versus the center DSU with 6 well density. Now I will turn it over to Ian Hogan, our EVP of Exploration and Geology, to explain the geology in the area and our well spacing.
Good morning, Commissioners. My name is Ian Hogan. I'm the EVP of Exploration and Geoscience at Bison Oil and Gas. The Remora OGDP is along the eastern edge of a large resistivity anomaly that defines Adams and Arapahoe productive areas. You can see that rough edge on the map, and Remora sitting out to the east. There are multiple geologic differences between the center of the anomaly and the edge of the anomaly, several of which I've got in that top right table. The center of the anomaly has been successfully developed at 8 to 10 well density, and the edge of the anomaly, which is where Remora OGDP sits, has been successfully developed at 4 to 6 well density. And I've listed those DSUs on the map, 1, 2, and 3. The Arkansas DSU, which is closest to Remora and the best analog, was drilled at 4 to 5 well density. The Fraser DSU was drilled at 4 well density. The Yellow and Crow DSU was drilled at 6 well density. So we believe the wells on the edge of the anomaly best represent Remora, and that's why we chose the analogs that we did. Thank you, and next slide, please. Turn it over to Don.
Thanks, Ian. Good morning. Chairman and Commissioners, I appreciate your time this morning. I'm Don Koenig, Bison's EVP of Reservoir Engineering. On this slide, for the Remora 6 OGDP, we modeled the various well densities based on the offset data that we had to calculate the corresponding recoveries. The results show that 5 wells in the 1280 will be optimal for efficient and economic development while preventing the drilling of unnecessary wells. 5 wells in this DSU will limit excessive development and will not create waste while protecting correlative rights. It will also minimize the surface impacts. Next slide, please. The recovery and economic models for the 1920 acre DSU show that 6 wells are necessary to effectively and economically develop the DSU using the longer laterals. Completion and artificial lift technology allows 3-mile laterals to efficiently recover the hydrocarbons. We believe that 6 wells will optimally develop the 1920 acre DSU while protecting correlative rights and uniformly draining the DSU without stranding resource. Spacing in the range of 5 to 6 wells is more efficient in this part of the field than the tighter spacing off to the west, as the reservoir changes and the recoverable oil per section is lower. I will now pass it on to Kelsey to finish off our presentation. Thanks.
Thank you, Don. Next slide. To summarize the Remora OGDP and request for approval, I'll note just a few highlights. The AUSR is nearing final disposition. Pursuant to the Oil and Gas Act, Bison will not commence operations for the drilling of a well without final disposition from Arapahoe County. However, the ECMC may move forward with approval of the Form 2A and OGDP, which protects and minimizes potential impacts to public health, safety, welfare, the environment, and wildlife resources. No comments were submitted on the Form 2A, no formal petitions were filed, and the Director recommends approval of the OGDP. And finally, the OGDP triggers no ALA criteria, and Bison agrees to several avoidance, minimization, and mitigation measures to ensure protective development. So this does conclude our presentation. We can take the PowerPoint down now, and we've got our team open for any questions.
Okay, thank you for the presentation. Appreciate the team being here. Commissioners, the panel is open for questions. Commissioner Messner?
Thanks, Mr. Chair. I guess I need a staff response to the testimony around the engineering comments, because while I appreciate that the applicant has provided a response, it really was an engineering comment, and I'm not sure that whether or not that response has met the concerns that were brought up by the engineers.
Hearings Manager Thomas, can we find some staff to be able to answer this question?
Yes, I'm looking to try and get someone from staff here as soon as I can.
While we're waiting on staff to show up, do other commissioners have questions?
I have another couple of questions.
Yeah.
So
go ahead, Commissioner Messner. Yep.
So help me a little bit here, because I understand that you're anticipating that there's going to be 7 daily truck trips associated with oil production in the initial phases of development for 6 wells with 2-mile laterals. That seems super low. I wonder if you could share any data that you have that you utilize to come up with the number of 7 truck trips for 6 wells with 2-mile laterals for oil production.
Just to clarify, it's actually 5 wells, not 6 for the initial phase of development. But we could provide our projected volumes or anticipated volumes, but I don't have that data available, but would be happy to provide that to you to confirm our volumes estimated.
I think that would be important for me to be able to provide that, mostly because I want to ensure that the accuracy of the information you're providing, both in your application and in the Form 2B, with associated truck trips, with this proposed location as it pertains to oil.
Yeah, I'm confident that our numbers are accurate and correct. I just don't have the exact projected daily production volumes for you on hand.
Okay, and then another question I have, and I guess it's more of an acknowledgement, but I understand that you're looking at a concurrent process, and I do think that our process does contemplate a concurrent process with the local government, but I also indicate, or I think we need to acknowledge that Rule 302B3, or sorry, 302C3, indicates that in this particular situation, we defer to the local government citing. And that should the local government determine that this citing process that was approved, should it be approved at this level, is different than what we approved, that may constitute a substantial change, which would require, a new application in this process. Is that understood?
Commissioner Messer, I'm happy to address that. We cited the Oil and Gas Act, which prohibits commencement of development operations without local siting, and Bison will not commence development operations without an Arapahoe County AUSR. I do think the rules allow the commission to move forward with approval today upon a finding that this application meets your requirements. Certainly if in the event for a very unforeseen reason that Arapahoe County for some reason does not approve the local disposition, which as we've reviewed with you today is not going to be the case. We're happy to have some conditional language on the Form 2A to ensure that we meet all of those requirements. But as of now, the Act does tie local disposition to commencement of development. And we do acknowledge the provision in 302C3 that the director will defer to the relevant local government citing disposition. And so I do think this can be clarified in language if needed, but we do think the permit meets the requirements of those rules.
Thanks for that. I don't know if it needs to be clarified. I just wanted an acknowledgement that you understood that, because, should even the local government determine that to shift the siting a little bit, that may constitute a significant change, which would affect this decision that is made today.
We understand that. Thank you.
Okay. So those are the questions that I have, except for wanting to hear from the engineers. And if the engineers have any perspective on kind of the volume of oil anticipated from 5 wells with 2-mile laterals and associated truck trips, that would be helpful as well.
And I see that we have Diana on the panel. If she wanted to either visualize or audioize so that we can have her provide some perspective to the question.
So I guess I'm coming in super late. Is that an average truck traffic, or is that at the front end when it's first being developed? Because I just ran the numbers on a singular 2-mile lateral that came on recently, and that one calculates for that one well, I get, higher math, 123 truck trips for 1 month for a well. So that goes to 4 for that singular well on a pad. I just got poked. So that's 1 well on 1 pad that has 4 truck trips associated with it in a month.
Ms. Gillian?
I guess I can't speak to the production of that well in reference. The projections that we are using is, based on, I might have to defer to, our reservoir engineer. However, we can provide these production volumes to you guys at a later date. I just don't have them handy.
Yeah,
So is that average or is that daily? At the
That's
front end?
average daily.
Okay, so that's not the actual impacts when it's first developed?
It would be the production, average daily production during the first occupation.
And
I
I'd
think-
jump in.
Okay, so we've got other things going on now. So that's truck traffic during drilling and completion.
No.
What about long-term in terms of, is this connect with pipeline? I'm sorry, I really am just jumping in without looking. Sorry.
Mr. Chair, can I clarify my question to Ms.
Yes,
Burns?
please.
So the question that I have, so my understanding in this application is the operator is proposing at least for a year to truck oil with the anticipation to, and that's for 5 wells on this location in the initial occupation. In the second occupation, they intend to put in oil and produced water pipelines, so there would be no longer oil transportation via truck. But the question I have is that they're testifying today that 7 truck trips total for those 5 wells in the first year of production are going to occur. And that number seems low to me. And I think what I heard you say, Ms. Burns, is that for 1 well in the first year of production, it could be anticipated that it would be 4 truck trips per day per well based on your calculations. And so I'm trying to create, I'm trying to understand whether what they're proposing is accurate or if there needs to be adjustments to what's being proposed here to ensure that not only we understand the potential impacts associated with this, but also that their Form 2B is accurate in the application.
Chair, I'd just like to clarify one thing.
Go ahead.
Thank you. And Ms. Byrne, we appreciate you and your guidance on this panel today. I believe the question directed on the engineering side was on the well count and analog wells that were flagged for clarification in the engineering review. So I do want, while we're happy to address truck traffic, I think that the issue flagged in engineering for Ms. Burns' opinion really was only tied to the engineering review item on development wells and analog wells. So I just want to make sure we're clear on the record on that.
Yeah, and Mr. Chair, I would indicate that I asked Ms. Burns both questions, both
Right.
for the truck trip and the engineering piece.
So Tricia has, I don't know what the question is at the moment. I'm sorry.
I'm not quite sure where we're at either, frankly. Commissioner Messner?
So the question was, we'll take it in 2 parts now. So the first question is, we've got an operator that's proposing that in their application that there will be 7 truck trips in the first year of production for a pad consisting of 5 wells with 2-mile laterals. And so what I'm asking is whether that seems accurate or not, based on engineering's experience in reviewing applications and their expertise. So that's first question. Second question is, engineering asked a question in the application about a topic associated with the application. the applicant has provided a response here at hearing, but I'm not an engineer, and it was the engineers that asked the question, and so I'm not sure whether or not the applicant's response satisfied the engineering's department question that they posed in the application. So those are the two questions.
So for the spacing piece, again, I don't know exactly. I think this is the one where it felt like there could have been better choices of analogs, but that the analogs that were provided gave enough data that the asked for spacing did not overproduce the area that was being spaced. So that piece, I'm fine with it going forward, or would have, yeah, I'm fine with that. As to the truck trips, I think 7 is wholly underestimating what happens during the early development of that wellbore.
To clarify that, I think, if we drill up to 5 wells, the math does work out so that it would be roughly 17 truck trips, whereas the 7 would be closer to like 2 wells. So I would estimate that it would be roughly 17 truck trips a day on average to start out with.
Okay, so the testimony's now changed. It's moved from 7 to 17. Is that accurate, Ms. Wazelinki?
I think so, Chair. I think where the confusion is this first occupation is up to 5 wells. I think some of the estimates were based on perhaps drilling not the full 5, because there is an opportunity that enough data is obtained from maybe 2 or 3 wells that 5, the rest can be committed to the second occupation. So I think some of those estimates could have been based on those figures. We have spent some time in the last few minutes digging into the data to clarify. And as Mr. Quinning noted, if it's a full 5 wells at the initial phase, that number is now 17, and we can confirm that in our testimony today.
Right, and that's what you're asking approval for. So we have to go with the more generous number to be accurate in terms of our review.
Understood.
Ms. Oates, did you have a question at some point? I think I missed you.
Yeah, thanks, Mr. Chair. I have also 2 questions on the accuracy of the truck traffic information. One of them is very much related to this point. Another is related to the numbers for the completion phase. So if I could ask for some clarification on this one while we're on this topic, I'd appreciate it. So I'm looking at table 1 in your transportation plan, which has entirely different numbers for truck traffic during production. So want to understand how that relates to the numbers that you're talking about now that started at 7 and now is 17, because in that table it indicates 2 truck trips per day.
Yeah, and I can clarify that piece. If there is in parentheses there on that table, that's assuming that for the life of the production, once we tie into the pipeline. So to clarify, for the production phase, those numbers were estimated based on pipeline takeaway.
So it's 17 for that first year before the pipelines are in place. And then after the pipelines are in place, the anticipation is that it reduces down to 2 per day. Okay.
That's right.
Okay. My other question on truck traffic for clarification is in this table, there are a lot of, and this could just be just a general understanding on my part. There's a good number of truck trips estimated during construction phase that goes down during drilling phase and then really ramps up again during completion phase. Can you help me understand what drives, pun not intended, a high number of truck trips during the completion phase? And specifically, the reason I'm asking, I guess, is because you talked about construction of the access road outside of important timing for being within the HPH. But if this is like ongoing and high volume of truck traffic during completion phase, wondering if similar considerations should be made.
So during the completion phase, we're just hauling a lot more product in during those phases than we are during the drilling phase. So just the nature of the operations require some additional hauling of the material to the location, as well as just, it's a larger crew. So you can see here, like our passenger vehicle numbers, single unit truck trips, and then our multiple unit truck trips. So it's the hauling of, the additional materials to the location as well as water to the location.
Okay. And then based on the schedule that you're anticipating, this would be happening, it sounded like in December of 2025. Is that correct?
That is correct.
Okay. Thanks.
Commissioner Messner?
Thanks. One other question. So acknowledging your timeline, and I just want to confirm because it's a little gray, but you are committing to oil and produced water takeaway via pipeline upon second occupation. Is that correct?
That's correct.
Okay. And right now, that second occupation is anticipated to be in Q3 of 2027.
That's correct.
Okay, thank you.
Further questions? Okay, seeing no further questions, if the panel can unvisualize, I'll be able to see all my fellow commissioners. We turn to whether we feel we're comfortable to deliberate at this stage on this application. And that's a question. Commissioner Messner.
Thank you. I mean, I'm comfortable deliberating. It does give me pause that there's that level of inaccuracy in the truck trips. I think that in this particular situation, the information provided around truck trips, because again, it's not very often that we see applications that are anticipating hauling oil. We do see it from produced water, but not oil. And there's not real clarity, or the argument made today was not very compelling as to why there's not oil takeaway being contemplated in the first occupation versus the second occupation. The argument being made was that it's more impactful than trucking, but it's the same level of impact whether you're putting the pipeline in Q4 of 2026 or Q3 of 2027. And so if we're going to compare the potential truck impacts associated with this against the installation of an oil pipeline, then the accuracy of those truck trips ends up being, to me, really important. I think also I'm curious about whether or not the truck trips that were being shared with CPW were in fact the 7 truck trips a day contemplation or the 17 or higher truck trips contemplation, and whether that would have any bearing on CPW's consultation or not. And I can't answer that. I do acknowledge that should this operator move forward with their anticipated timing of development, that truck traffic would last approximately a year, at which point they would be tied into an oil pipeline. And so, that's something that I think about, but I'm not sure that there's anything in this application or in the applicant's presentation that commits to that timeline. And then I think finally the things that I'm thinking about here is, and I think it was acknowledged by the applicant, but the truck traffic probably has the most potential impact to the relevant local government. And so it is important that we get the accurate information in this hearing, since this is the first hearing that's occurring on this, to get the accurate truck traffic associated with this application, if anything, to help the local government better understand the truck traffic they can be anticipating within their jurisdiction, to better inform their review process. And while it does appear that this location is sited within outside the setbacks that are required from the local government, and I think that's a good thing. No alternative location analysis was required. I think that's a good thing. In this particular situation, I think we just do have to acknowledge that should the local government decide to shift this site for whatever reason, that would affect any decision that we make here today. So those are my initial thoughts. I don't know if there's any conclusions there, but those are my initial thoughts.
Yeah, well, I would agree that any action that we take today would be contingent on the local government acting in concert with or correlating with any decision we were to make today. And agree that a lot of the truck traffic issues are more local government sort of oriented, and so that needs to be accurate. Others with thoughts? Commissioner Ackerman?
Yeah, I'll jump in as well. I had flagged the same points raised by Commissioner Messer and appreciated him raising them. And I do think accuracy of truck trips is important. It helps me that we talked with Ms. Byrne and we had some acceptance from engineering with regard to the operator's well spacing. And I also appreciate the operator's treatment of why they consider this pad exploratory. That still remains a bit difficult for me to understand. There's plenty of drilling in the Niobrara foundation or formation, and there's plenty of drilling in the area. And I do understand from the presentation of the edge issue. And I think we're getting at the reason that matters because, if there is to be a second occupation, again, that's two occupations, two mobilizations, future development potentially encroaching, and the standard issues that we have with, secondary occupations. And to Commissioner Mester's point, including takeaways from the get-go and excluding those first-year truck trips is a lot less impactful than including those truck trips and then still building a pipeline on the secondary occupation. So to me, a lot hinges upon the potential for this to not be a productive operation. If it has that potential to not be productive, it does make some sense to wildcat it and step it in without pipeline construction. And we've seen that before. If the anticipation is that it will be successful, there will be a second occupation. It makes more sense to me, certainly, to install those pipelines prior to moving towards a second occupation. So I don't have a lot of conclusions in that testimony. I'm a bit hung up on understanding the need for two occupations and what degree of potential this has to be an unsuccessful operation after a couple or 5 wells.
Thank you, Commissioner Ackerman. Other commissioners? Commissioner Cross?
Thank you, Mr. Chair. I'll start off by saying I too am, I'll say, frustrated by the concerns over the accuracy of the truck trips. For one, I think that does need to be cleaned up, and I'd love to see those updated numbers. I think that looking at the engineering testimony, I'm comfortable with the I don't even know if I'd call this necessarily a wildcat well, because it is in a somewhat developed area, but it's obviously on the edge of this development area and that anomaly that was discussed. And so I do understand the concerns with it. I'm comfortable with the desire to have the multiple occupations, as long as that multiple occupations is done in a responsible manner. And so I think the important thing here is, given the HPH, making sure that construction of everything is done outside of the timing stipulations. I do have concerns with the accuracy of the truck trips, but I also understand that if there is that potential of not having a second one, it is a lot of disruption to put it in a pipeline if there's not going to be future wells drilled. So I understand the concerns raised by Commissioner Ackerman and Commissioner Messner with respect to that. I tend to go the other way and don't think we necessarily need to dig up the ground and put in a pipeline if we aren't sure.
Commissioner Oath?
Thanks, Mr. Chair. I don't know that I have too much to add or weigh into the conversation, given the kind of levels of concern that commissioners have indicated. I don't have anything that would appease anyone. So I think I'm kind of interested in, given this, what various options we may have as a commission, given where we are in this process.
I think that's a good point. I mean, so at this point, first occupation is not planned until first quarter or fourth quarter of 2026. So, I mean, there is a little time here. They are supposed to go to Arapahoe County, I think, if I heard correctly, within the next month. We could, if we feel comfortable conditionally approving, move in that direction. If we don't feel comfortable with that, we could hold and let them finalize the Arapahoe County process, deal with the trucks there, get all that information, and come back to us with kind of a continued application with some of these uncertainties wrapped up. I think it really is up to the commission what we think is the most prudent course. Ms. Wazelinski, I generally give the lawyer a chance to respond when we think about doing things other than moving forward with something. So if you wanted to weigh in, go for it.
Thank you, Chair. And we do appreciate the deliberative comments on this. I will note on the 2B and estimates there, Bison is happy to clarify those numbers so that we've got an accurate estimates on the Form 2B. I also acknowledge that a lot of the traffic issues are a local government issue, and Bison is certainly willing to make any necessary updates on the 2A side if needed after the Arapahoe permit. I think if a continuance is on the table, I don't think Bison would oppose that. We've put a lot of work into the filing, and if it's really a continuance to confirm that the Arapahoe County permit is ultimately approved and any clarifications needed for a continuance and hearing on that, I think we would be okay with that.
Yeah, I'm sort of thinking, I'm seeing a majority of votes thinking the continuance probably makes sense. It gives you a chance to clarify things, to deal with Arapahoe County, to figure out the truck things, give us the negatives and the pros or the numbers based upon 5 or less wells. That's just me talking. What are other commissioners thinking? Commissioner Messner?
Thanks, Mr. Chair, and I appreciate you laying out the two options. I was contemplating those myself, whether I felt comfortable with a number of conditions of approval to the application, or whether it made more sense to stay the application, allow the applicant to be able to provide accurate information in their application and make adjustments as necessary, and gain the benefit of final local government determination on the application. I'm going to lean towards staying the application and allowing the applicant to provide update the application to be accurate and uh, uh, and allow the local government process to get to a point where we understand where their determination is, particularly in regards to siting, which is really where, is going to be the most important to us in our process. So I would move that we stay the application.
We have a motion to stay the application I'm going to indicate that that's to a date uncertain because we don't know exactly when that will happen, but it could be just re-notified for us to continue this hearing. I noted that Commissioner Ackerman wanted to weigh in before we go there. Ms. Wasilewski, does your client have enough direction in terms of next steps at this point if we move forward with this motion for continuance?
I believe so, Chair. I think on the issue of traffic, if that's something we can clarify on the Form 2B, we're willing to do that, sooner than later. I certainly think conditional approval based on that updated traffic is also a possibility, depending on, the Arapahoe County final disposition. So, I hate to throw another possibility out there, but we could certainly update the truck traffic information, have an opportunity for conditional approval, because we do not have a date for the Arapahoe County final disposition yet.
Okay, thanks for that. Commissioner Ackerman?
Thank you, Mr. Chair. I'm going to second Commissioner Messner's motion for the same reasons articulated by him. I did want to also point out a few things that we haven't really discussed on this application. There are some quality approaches and wanted to make sure that I note that as part of this hearing. I appreciate the drill rig approach from the get-go, and I appreciate the electrification of facilities. I particularly appreciate the operator working with CPW on an HPH issue that wasn't part of their initial application, yet they worked with CPW on that issue. And so I did just want to note that I appreciate the work done by this operator and this applicant. I do think that a stay is appropriate, and while I agree with Ms. Wasilewski that there could be a conditional approval pathway here, I do think that it's appropriate for an operator to ensure that they come forward with clear and concise information that is appropriately presented at a commission hearing in order to move forward with an approval. So I'll second the motion.
All right, we have a motion and a second. Commissioner Cross?
Thank you. I'm fine with staying this till we get the additional information. I'll just say I want to make sure this doesn't set a precedent that we have to have the local government approval first before being able to act on it. I know that's something that came up as we talked about cumulative impacts and other rulemakings, that obviously we have separate processes and operators have to deal with both processes. I think this is a bit of a unique situation with the traffic, but I just want to make sure that the public also understands this is not saying that local government approval has to be obtained before it can come to us.
Thank you. Fair point that I agree with. Any further deliberation? All those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Ms. Wasilewski, again, appreciate the application. I think there's a lot of merit here. I think it is just a teeny bit premature. I think you've got marching orders on next steps. I would encourage the applicant to try to solidify the Arapahoe County process, including the truck traffic and that sort of thing. I think we're in a better place to make a decision. Obviously, if that's running amok and you want to make another stab at it here as a conditional approval, that's your call. But I think you did get a sense of direction from the commission.
Understood. Thank you, Chair.
All right. Okay, that matter is continued. We've got another matter on the docket. It's going to take a bit. Let's take a break. Let's return. I need to take care of a matter. Let's return at 10:20. That's about 15 minutes out. And if I could get hearings manager Thomas to start to tee up the public comment for that OGDP for Draco, that would be great. I believe we're going to start with public comment, and then following that, we'd go to Mr. Raxey. See you in about 13 minutes. Okay, welcome back. Energy and Carbon Management Commission, Wednesday, the 13th of November, 10:20. We'll get back to business. We take up docket 2401-00004. This is an oil and gas development plan proposed by Extraction. It is the Draco OGDP. First, want to sort of orient ourselves to the application. I see that we've got interested parties and members of the public in attendance virtually today. We appreciate all of you taking the time to be with us. Our mission is to regulate the development of oil and gas, development and production of oil and gas in a manner that protects public health, safety, welfare, the environment, and wildlife resources. This is a location that was applied for on January 17th of 2024. It's located in unincorporated Weld County. We'll get the particulars of the application from the applicant here in a bit. Would note that we've had several rounds of public comment. The first round was open for 30 days from June 18th to July 18th. Total of 418 comments were received. We received the staff's recommendation on August 16th. And uniquely, we hosted a public comment hearing in Erie on October 28th. I would like to recognize Commissioner Oath, who ran that meeting, to provide just some general information and sort of an outline of that Rule 511 hearing for us before we move into public comment this morning. Commissioner Oath.
Sure. Thank you, Mr. Chair. Yeah, so for everyone who's listening, as Chair Robbins just noted, I did preside over that Rule 511 local public hearing at the end of last month. That was at Erie Middle School, where we really heard public comments about this oil and gas OGDP from local community members. I think it's important for us to stress just how important that stakeholder and community input is to us and how much it matters as a part of our review and a part of our deliberative process as we as a commission evaluate all of the data and all of the information that is submitted for this application. I think it's the case that many attendees at today's hearing have submitted comments to us in advance. Some submitted those in writing to us. Some did attend that public comment hearing in Erie, and I think some may also want to provide some comments today, and want to note how much we strive to be really proactive in soliciting those public comments and making our processes as easy as possible for people to access and provide those comments to us. These 511 hearings is something that we have the discretion to decide whether or not to hold when we receive a request. And we were glad to do so. Really glad that we hosted this one in Erie in person so that we could hear directly from community members. If you were there for that hearing, that my fellow commissioners and I heard you. And for those who were not there, just would note for the record, we had, I think it was over 125 people attend the public comment hearings. That the one at the end of last month for the 511, it did last. It was about 3 hours. We had 40 people who spoke to us during that time. But with that, as well as the additional written comments that we have received, we've gotten, I think, well over 271 written comments. And that's on top of kind of the ones that were initially received before we got into this formal process. So it's really informative to attend that public hearing and be in person. It's really important, I think, for us as commissioners to be in the community directly where the proposed site is located. And personally, I would just say it was really a pleasure to personally meet and see and hear from from those who were able to make it. That's all I think I would say in terms of recapping that process. Really appreciate you.
Thanks, Commissioner Oath, and would note that both Commissioner Ackerman and myself were not able to attend the 511 hearing. We had other business that we were attending to on behalf of the Energy and Carbon Management Commission. I would note for the record that I have listened to the entire audio of the 511 hearing, and so feel comfortable that I was able to obtain all the information that the commissioners obtained at that hearing. Would recognize Commissioner Ackerman for perhaps a statement along the same lines as well.
Thank you, Mr. Chair, and I appreciate the chance to do that here. I would reiterate that I listened to the meeting actually twice as well in order to make sure that I was able to go back over everything. And so appreciate the opportunity for that to be recorded, and appreciate the grace afforded to you and I to be able to be on other business elsewhere, but still engaged in this process wholeheartedly. Thank you.
Yeah. Okay, so with that, we will take up this docket. The first matter of record is public comment. I've got a list of 19 folks that have signed up for public comment, starting with Commissioner Ashley Stoltzman from Boulder County. Commissioner Stoltzman, good morning.
Good morning, Commissioners. I'm Ashley Stolzman. I'm Chairman of the Boulder County Commissioners, and I'm here today to speak on behalf of my community about the Draco application. Although the pad is beyond the borders of Boulder County and inside Weld County, there are two primary reasons that our voices need to be considered today. First, the Draco wells will penetrate Boulder County, and they threaten unstable, historic, plugged, and abandoned well that's in Boulder County on county open space. Secondly, we're greatly concerned about the cumulative impacts of oil and gas development and the threats to the climate and air quality in our larger region. So first, I just would like you to know Boulder County supports and endorses the comments that were submitted to you all by the town of Erie and city of Lafayette. Thank you to them for submitting those. David Frank from Erie brought the Prince 1 well, which is API 5130511 to your attention. It was not only plugged decades before any rules or best management practices regulated the manner of plugging, but it has a history of leaking and causing problems. Those are demonstrated in reports that you all have from your staff in 1995 and 1999, respectively. We fast forward to today. Boulder County owns the lands now where Prince 1 sits and maintains the lands as open space for our community and broader region. We're extremely concerned that the Draco well bores could interact with the improperly plugged Prince 1 well and cause gas or fluid leaks. We would ask that if you do approve this plan, that you require extraction to unearth and replug Prince 1 well in cooperation with our community planning and permitting and our parks and open space departments. As far as the air quality matters are concerned, we've collected significant air monitoring data that demonstrate that our jurisdiction, along with much of the Front Range, is heavily affected from emissions from oil and gas operations in Weld County because of the westerly winds that prevail. As you know, we're in severe non-attainment for the ozone air quality standards and serious non-attainment for the 2015. So in addition to the non-attainment for the 2008. We see this abstract fact playing out with increased health problems and air quality alerts from ground level ozone. My niece personally has asthma and can't go outside and exercise in days when we have these ozone alerts. We have community members all through the community with similar stories. Of course, oil and gas is acknowledged in the state SIP for ozone to be the largest single source of NOx and VOCs in the Front Range. In addition to that data, Boulder County residents and constituents in Erie have contacted us expressing their concerns of air quality and public health with personal public health stories that I'm sure you'll hear about later today. I ask that you first take a very hard look at whether the air quality and other impacts from the Draco project have been avoided to the greatest extent practicable with the proposal, and whether any adverse impacts that won't be avoided are justifiable that could be minimized or mitigated effectively. This plan, this oil and gas development plan that you have today, is the perfect opportunity for you to thoroughly and carefully walk through the hierarchy, the analytical hierarchy that was discussed at length with our Boulder County staff in the cumulative impacts rulemaking. Our community needs you to use it to make clear, transparent findings at each step about why we're not avoiding the negative impacts by relocating, downsizing, or denying this project in the first place. And if we're not capable of doing that, why are we allowing negative impacts that aren't avoided to be fully minimized with conditions of approval? And then how would any proposed mitigation measures protect Boulder County residents from worsening air quality and climate conditions? I want to underscore and reiterate this opportunity to use the analytical hierarchy for our community to consider how to avoid the negative impacts of this project. But if you do find yourself in a place where you must approve the OGDP, I adamantly urge you to add a condition of approval that would require excavation and replugging of Prince number 1 well. My staff is happy to work with you to ensure that this happens. Thank you so much for your care and attention to this matter this morning.
Thank you, Commissioner, for being with us today. We appreciate your public comment. Moving down the list, we now will hear from David Frank.
Good morning, Commission. Thanks so much for the lengthy and all-inclusive acceptance of public comments on this OGDP. The town of Erie is extremely appreciative. I'm David Frank, the Director of Environmental Services for the town of Erie, as well as the as well as the LGD. And I'd like to raise a few issues here in addition to my previous written comments. First, I think it's poignant and relevant to bring up cumulative impacts. First, the Colorado Front Range has been found in violation of the Environmental Protection Agency's air quality standards for ozone 40 days, 40, in the summer of 2024 alone. The Regional Air Quality Council cites increased oil and gas production within and adjacent to the non-attainment area, such as the Draco proposal, as one of the primary factors which continue to stymie the state's efforts to reduce ozone concentrations. Excuse me. The area surrounding Erie, that's to say within 2,000 feet of our municipal boundary, is already host to 434 active wells, 141 of which are within the town. At those wells, in the last 12 months, we've seen 29 spills reported within 2,000 feet of the town, including 17 within the municipal boundaries of Erie. We've been operating a pretty comprehensive air quality monitoring program within the town that's in addition to the state's air quality monitoring efforts. And SUMA canisters collected and analyzed by Ajax Analytics and CSU have recorded benzene concentrations of up to 112.8 parts per billion near existing oil and gas locations. That's a pretty short-lived plume of only about 10 minutes. A 1 hour estimate of exposure comes to about 17.2 parts per billion, just to be compared with the acute health guideline value of 10. From a report issued by Boulder Air, our other contractor doing air quality monitoring, Erie received approximately 10 times as many benzene alerts compared to neighboring sites. A remarkable finding at the Erie Community Center site is the frequency of occurrence of elevated VOCs at concentrations that are approximately 100 times that of typical background levels seen in clean air. The relatively higher occurrence of elevated levels of air pollutants raises concerns about the cumulative effects of exposure on the health and well-being of Erie's residents. Second, the town would like to publicly acknowledge and commend the efforts of the adjacent property owner, Southern Land Company / Erie Land Co., the developer of the westerly neighborhood immediately west of the Draco proposed location, for their efforts to negotiate protective measures with extraction. They have been a great ally to all current and future Erie residents in their efforts to protect their health, safety, and well-being. And the town of Erie urges the commission to acknowledge and incorporate the mitigation measures agreed to by Extraction and Southern Land Company if it chooses to approve the Draco OGDP and Form 2A. Third, I'd like to list briefly the necessary conditions of approval that the town finds necessary for your consideration. The OGDP should be conditioned on the execution of access agreements, transportation impact analysis, and other local permits as required by the town of Erie. The town requests, and Extraction has concurred, that the provisions of the previously abandoned well soil gas surveys and monitoring presented as Exhibit A in the town's written comments be incorporated in the OGDP and Form 2A for the Draco pad and acknowledged by the commission as a condition of approval. And third, it is reasonable and necessary that the commission include a condition of approval that would limit without exception the duration of drilling and completions activities to 3 years from the date of OGDP and Form 2A approval. If this condition is not included in the OGDP in Form 2A, the town would urge the commission to evaluate Draco and its associated impacts based on the 77 RBUs, which will be present within the 2,000-foot setback from the pad within 3 years, and not the currently existing 5. Furthermore, the town would encourage the commission to undertake a minor rulemaking in the future to impose a reasonable limit on pre-production occupation at all current and future oil and gas production facilities in the state of Colorado. Lastly, Erie would like to thank the commission for their continued work to protect public health, safety, welfare, the environment, and wildlife resources. I'll be present and available throughout the hearing, and am very willing to answer any questions or address any comments from this commission. Thank you very much.
Thank you, Mr. Frank. Commissioner Messner?
Thanks, Mr. Chair. Just a question, I guess, to you as chair. I do have questions for Mr. Frank. I'm happy to wait until the after the applicant's presentation, if you think that's more appropriate. I guess I'll leave it up to you, but I do want to acknowledge that I do have some questions for Mr. Frank.
Yeah, no, I appreciate that. And I think maybe what we'll do is, as we deal with Weld County and Jason Maxey as the relevant local government, we can deal with Mr. Frank as the proximate local government and have questions for the two local governments at that time. I think I've heard Mr. Frank indicate that he's going to stick around. So if you could be available either right before or right after Mr. Maxey, then we'll do all local government questions at one point in time. And at this point, we'll continue forward with public comment. And Commissioner Messner, appreciate the point raised right there. And hopefully that is acceptable. Okay.
I'll be here all day.
Next, we will hear from Sammy Carroll and then Jenny Thamer.
Hello, my name is Sammy Carroll, and I represent Flatiron Meadows Oil and Gas Monitoring Group. Flatiron Meadows is one of 26 impacted neighborhoods in the town of Erie. The last 10 months have thrown many of us into an area and level of activism that we could not have ever predicted. We've learned a lot about the power of community. We've learned that common sense and regulations do not always align. We've learned a new vocabulary with phrases such as cumulative impacts and density of sources. We have collaborated with people and groups from throughout the world who have helped us navigate the world of oil and gas. As you may know, Erie is somewhat unique in that it has two counties, Weld and Boulder, polar opposites in many aspects. In fact, 42% of Erie residents live in Boulder County, where public health and safety is fully protected from oil and gas development. Weld County has welcomed oil and gas with open arms. It is a dichotomy for sure, and I believe that extraction has taken the opportunity to exploit that fact. Flatiron Meadows Oil and Gas Monitoring Group rejects the idea that other alternative location analysis were not viable due to rezoning requirements. We reject the idea that these minerals cannot be extracted in a less impactful manner. We reject the idea that fracking under homes with untested technology is something that Erie should be put at risk for, with nearly 1,000 new homes planned within the proximity of this site and over 10,000 homes already existing within the DSU. We reject the idea that extraction can be a trusted community partner in Erie. They have not demonstrated so in any manner. Erie has seen 40 well spills in the last 4 years. 57% of those are owned by Civitas, and 47% of those Civitas spills were just this year. It is unfortunate that the director's recommendation came out before the 511 petition was granted. How would Director Murphy's decision changed if she had heard the comments at the public hearing, if she had considered what you've heard here this morning? Whether or not there is precedent for ruling against the director's recommendation, today we ask that you prioritize the 418 people who made comments during the 2A period, the 271 written comment submissions on the public record, and the 41 speakers at the public hearing, and uphold your commitment to public safety and well-being. We ask that you recognize that a thriving community is built on more than what's beneath the ground. It's built on trust, mutual respect, and a commitment to the safety of all residents. Erie is more than land for drilling. It is our home. It's time to think about Erie differently. Let us stand together for what matters most. We ask this commission to prioritize these things in your decision today and to deny the Draco OGDP proposal. Thank you.
thank you for the comment and for being with us this morning. We now will hear from Jenny Thamer.
Thank you, commissioners. Our family lives in Erie. Our home would be located in the drilling space unit. We have a student at Meadowlark Elementary, which is approximately 500 feet from an existing well that has been flagged as a well of concern by the town of Erie. Erie has seen 15 spills at existing wells since March, and nearly 75% of these wells are owned by Civitas. The proposed well bores have the potential to compromise the integrity of more than 80 existing wells. Extraction has stated that it will wait to plug at-risk wells until after it drills its proposed horizontals. The town of Erie raised its concerns about the, quote, potential for wells to communicate to the surface when they are disturbed by horizontal completions nearby, end quote. Considering the location of dozens of these existing wells in residential neighborhoods, at the entrance to our school, in the yards of homes, and increasing incidents of spills at Civitas wells, extraction has not provided a viable plan to prioritize safety and protect public health. For this reason, I ask the Commission to deny extraction's application. If it is inevitable that the Commission will move forward, I urge you to put strict, clear conditions on the permit. The concessions proposed by extraction lack detail and are based on a presumption of good faith, which the operator has not earned. I ask the commissioners to include the following conditions for all, and I mean all at-risk wells identified by the town of Erie and all existing well sites within 2,000 feet of residences, businesses, and schools. And there are a considerable number. Plug and abandon at-risk wells prior to drilling. Provide site-specific plans with a design to plug each identified well, protocols for monitoring the well sites, and a site-specific incident response plan. Hire a third party to install optical gas imaging monitors, collect samples before drilling starts, and collect samples quarterly for the duration of operations. Install ambient air quality monitors, commit to responding expediently to incidents, increase financial assurance and liability coverage requirements to address the costs of response and mitigation. The scope of this project has no precedent in Colorado, and standard state financial requirements are insufficient to address the potential risks. Develop a detailed plan for retiring any non-productive assets, including non-producing, low-producing wells. I recognize the challenges of continuous lease restrictions and ask the Commission to consider creative options because drilling without first mitigating high probability, high impact risks at known wells of concern is negligent. I understand the costs associated with these conditions. Extraction may feel that the cost of mitigating and monitoring public health hazards will cut into their ROI. Respectfully, the profitability of this project is solely the operator's responsibility, and the cost to tens of thousands of residents are much greater. Thank you.
Thank you, Ms. Thamer, for presenting and being with us this morning. We now will turn to Skylar Weitzel. I probably don't have your last name. Go ahead.
Weitzel, you're fine. My name is Skylar Weitzel. I've been an Erie resident since 2004, 2 full decades before this proposal, and I live directly above the project zone with 6 wells under my neighborhood of 181 homes. I'd like to thank the ECMC once again for holding this hearing to give the appearance that the Commission is sincerely and honestly considering the concerns of those who will be directly affected by this project's likely approval. At the last meeting on October 28th, we heard from 41 Erie residents. Among them were engineers, scientists, oncologists, and other healthcare workers that reminded us of the negative impacts from fracking. 38 public comments fully opposed, 1 in clear support, and 2 who asked for, quote, strong enforcement of regulations. We heard from several residents whose lives have been directly and negatively impacted by fracking. It wasn't until that meeting that I started to wonder if my own non-Hodgkin's lymphoma diagnosis in 2021 is not because of how I've lived my life, but rather where I've chosen to live most of my adult life. I did 8 months of IV chemotherapy in 2022. I do CAT scans every 6 months, blood work every 90 days, and I'll be taking oral chemo meds for the rest of my life that would cost me $15,000 a month without insurance. We already know that fracking has negative impacts on the environment and wildlife resources, along with the direct and detrimental effects on the health, safety, and welfare of those that live, work, or attend elementary school near oil and gas projects, so I won't repeat the facts that are already part of the record. What makes the proposed Draco project so outrageous is the audacity of Civitas and their blatant attempt to circumvent the Boulder County restrictions on fracking by simply drilling into Boulder County through horizontal wells from fracking-friendly Weld County. Trespassing is defined as, quote, the act of entering or remaining on another person's property without their permission, end quote. Breaking and entering, also known as B&E, is, quote, the act of entering a building or other property without permission, usually with the intent to commit a crime, end quote. It can involve using force, such as breaking a window or door, or using deception or trickery to gain access. My question for you on the commission: if someone wanted to break into your home and they wanted to try an untested and experimental method of burglary by drilling from your neighbor's basement, under the street, and into your home from below your basement, would that make it any less of a crime if they didn't specifically enter through a door or window? I ask you to remember the ECMC's mission statement when you make your decision. If you choose to approve this project, it would be in direct contradiction to your very mission and a slap in the face to everyone whose lives will be jeopardized along the way. It would sadly reveal the commission entrusted with protecting us is instead prioritizing the interests of oil and gas companies over the well-being of our communities and the environment we depend on. You must deny this project and say no to Draco. I beg you, please keep the health of Erie residents protected and your conscience clear by doing the right thing. Thank you.
Thank you, Mr. Wetzel. We now will hear from Don Colacino.
Thank you. Erie residents have been disproportionately impacted by oil and gas extraction projects over decades. Drilling pads have been constructed near homes and schools, polluting our air and aquifers. Our neighborhoods are dotted with wellheads from past projects, with increasing risk of pollution in high-density neighborhoods due to leaks from aging equipment. As 18-year residents of Erie, my family and I moved here in the belief that new oil and gas extraction projects were a thing of the past. Certainly, the population growth, infill, and density should be reason enough to keep new polluting projects out of our community. Drilling from just over the county line does not change the fact that extraction is taking place beneath our homes. Residents impacted by environmentally threatening projects should not be disenfranchised from decisions that affect our well-being. The Draco pad is a project of unprecedented risk in Colorado, especially in residential neighborhoods with 5 miles of horizontal bores. It's got a lateral drilling project of this length that has never been attempted in Colorado history. The 27 bores will be drilled under a large swath of homes, schools, and healthcare facilities, and adjacent to 28 existing wells. What could go wrong? Fracturing of rock is not and cannot be precisely controlled. Despite assurances by Civitas, this novel project poses a high risk of accidents and leaks that Erie residents will be forced to bear for years to come. This was not something we were prepared for when we built our home in Erie. Civitas, as I understand it, is admitted to non-compliance with 5 Colorado oil and gas regulations on this project and applied for waivers of responsibility. Experience shows that there's a history of oil and gas non-compliance in Colorado, with wells being abandoned, not properly plugged, and leaking. It was only in 2017 that the explosion occurred near a residence in Firestone due to that type of oversight. Drilling a grid under our neighborhoods only increases the risk of something like that happening in Erie, perhaps years in the future when Civitas is long gone from Colorado. Now, I'm sure that Civitas has provided assurances that these risks are overstated, but Erie residents deserve to know who provided the expertise to set the standards and evaluate Civitas's assurances, who monitors the active projects, the wells, the entire grid of bores under our neighborhoods in the coming years, and most importantly, who pays for those resources, and is there any conflict of interest between the money and the resources? Finally, in an already unaffordable housing market, Boulder County homeowners have experienced a surge in insurance costs recently, and insurers recently cited risks from wildfires and high winds in this area. Will the risks of hydraulic fracturing cause the next spike in insurance costs? Will we lose equity in our home if this area becomes unattractive due to the concentration of oil and gas wells? Please do not approve the Draco Pad project. Erie residents already bear enough risk. Thank you.
Thank you for being with us and presenting. We now will hear from Sandra Dugan, followed by Dr. Garrett Matthews.
Hello.
Hi.
Bear with me. I have a toddler behind me if you hear her. Commissioners, thank you for your time and attention. I want to personally thank you for attending and or listening to our recent town hearing. My name is Sandra Dugan. I'm an Erie resident who has been disproportionately impacted by fracking. 541 million gallons of water. The Draco monstrosity would utilize 541 million gallons of water. They will not be recycling that water. That's 541 million gallons of water. According to, as of October 29th, approximately 35% of Colorado is under drought condition. Extraction has signed a contract with a local ditch company, FRICO, to provide the water for Draco. How can we justify this alone? We all know that oil and gas is a bad neighbor. That's why we're all here. We also know that Civitas is a particularly bad neighbor in Erie, as you heard from Sammy Carroll. Standard fracking operations are torturous, loud, unsightly, and inherently toxic. We have evidence that these activities are dangerous to public health, the environment, and the climate cycle. According to the Compendium of Scientific, Medical, and Media Findings demonstrating risks and harms of unconventional gas and oil extraction, as fracking operations in the United States and abroad have increased in frequency, size, and intensity, a significant body of evidence has emerged to demonstrate that these activities are dangerous in ways that cannot be mitigated through regulation. Threats include detrimental impacts on water, air, climate stability, public health, farming, property values, and economic viability. But this is not a standard proposal. This project is like no other before it. From the Erie Protectors website, the longest lateral wells we've ever seen in Colorado are 4 miles long. The vast majority are less than 3 miles. The 5-mile lateral wells proposed at Draco are 25% longer than the longest lateral ever drilled in Colorado. And the proposed well borings are 70% longer than any wells completed before 2024. For these reasons, residents gathered at Erie Middle School earlier this month. They gathered to beg you to consider the scope of this project and the certain consequences it would have on our community. You heard Mr. Frank assure you that the town is doing everything they can to make sure Draco is safe, and I don't deny them that, but I assure you that no fracking operation is safe, let alone a massive monster like this one. The least impactful route is to deny this OGDP entirely. Anything short of that is an invitation to poison, traumatize, and exploit our community. Finally, I ask you, if this horrific project doesn't meet the requirements for denial, what will? I remind you of your mission to regulate the development and production of the natural resources of oil and gas in the state of Colorado in a manner that protects public health, safety, welfare, the environment, and wildlife resources. Thank you.
Thank you very much. Appreciate you being with us this morning. Mr. Matthews?
Thank you. My name is Garrett Matthews. I have a PhD in mechanical engineering, and I'm currently a senior research scientist at the University of Colorado. I develop sensing technologies to monitor gases and aerosols produced through various processes, including oil and gas extraction. I'm also a resident of Erie, and one of the proposed wellbores is located almost directly under my home in Boulder County. I would like to use this last opportunity to urge the ECMC to deny the application for this proposed development. Like hundreds of residents you have heard from, I have numerous concerns. First, the Draco pad has been strategically located to circumvent regulations and oversight from Boulder County and the town of Erie. Civitas has denied residents this regulatory input through our local government officials with an obvious circumvention of regulations in the extraction area. In their FAQ document, Civitas also makes misleading and dismissive statements about community concerns. This includes statements on water quality impacts, statements on fracking fluid, and a vague commitment to offset air quality impacts by plugging legacy wells, but with no specific timeline or guarantee. I do not trust, and the ECMC should not trust, a company to hold up their promises to mitigate negative health impacts when they already work to circumvent local regulations and they tailor their public discourse to distort or hide important risks. Next, the Draco pad has the potential to reduce property values in Erie. While the public comment consideration memo states that the ECMC does not have the power to dictate the value of a property, the negative impact of fracking sites on nearby property values is well documented. Approval of this project will likely reduce property values in Erie, and the ECMC will be allowing a direct transfer of wealth from hardworking families in a growing community to an oil and gas company providing no benefits for these families. Finally, I must re-emphasize the health impacts of the Draco pad. Numerous studies have shown an increase in cancer risk in children and other health effects for homes nearby oil and gas extraction sites. As a senior researcher in sensing technology for air quality, I can assure you that the Draco pad will have a negative impact on the air quality and increase the concentration of carcinogens in the vicinity of the extraction pad. We've seen this already with the Erie air quality alerts, and Civitas admits this when they state their intention to purchase offset credits. This does not help our community. This is Civitas acknowledging they will make our air quality worse and pay to improve the air quality elsewhere. As someone who has lost my younger brother to cancer when he was 17 years old after a long, hard-fought battle, I cannot overstate the impact that this has on one's life and the lives of everyone close by in the community. The potential this project has to increase carcinogens in our homes through multiple pathways is unacceptable, especially when there is no benefit to our community. We look to you, members of the ECMC, to protect the health of our families, to protect the value of the community we love, and to protect us from an untrustworthy company who does not have our best interests at heart. It is the stated mission of the ECMC to regulate this sector in a manner that protects public health, safety, welfare, the environment, and wildlife resources. We hope you see that the proposed Draco pad will be detrimental to the citizens and the town of Erie in all of these areas. Thank you.
Thank you, Dr. Matthews, for being with us. We now will hear from either Paul and or Norma Ventol. If they're not with us, Jennifer Hannon. Ms. Hannon, go ahead.
Hello.
Hello.
Hello. Hello, commissioners. I'm Jennifer Hannon, president of the HOA at Meadow Sweet Farm in Erie, also a parent of a student at Meadowlark School in Erie. Our neighborhood is on the Boulder County side. Unfortunately, many of my neighbors could not attend this meeting. I was lucky enough to be able to pull myself away from work today, but I know many residents that would have liked to comment on this project, some who have not commented at all yet. I, like many of my neighbors, have been volunteering our time in local, state, and national elections. We were so wrapped up in those issues that we only found out about this project recently. We also received no notification by mail or email that this project would impact our neighborhoods. If it wasn't for outreach from citizens, I would not have been notified. And unfortunately, many people are still in the dark. So I would like to know why residents of Erie have not been properly notified about this project. The scale of this project should require notification by mail or email to every resident. Until that happens, I believe the process should be postponed. We'd also like to know how Erie residents are benefiting from this project. We have not seen an explanation of the benefits to our community. We are aware that our home values may decrease, and we also know that new buyers have already looked elsewhere after hearing about this project. Since we will be facing potential environmental health and noise impacts, we need to know what the residents are really getting out of this. We have not seen the risk management plan as well as the risk versus benefit analysis, especially since construction has already been limited in the past due to mine shafts in our area. How can our community receive a copy of this? I'd also like to know what financial documents are available. What are the revenues that will be profited from this project? Who will receive them? How much will go to the city of Erie, Weld County, and Boulder County? How will those funds be used? Would they be used to repair any damage that this project creates, making this profit unavailable for other community needs? People have compared this project to the Aloe Fiber project. It was a horizontal boring project that went a few feet underground. And with this project in our neighborhood, we had damage to our sprinkler systems and our landscaping. Our HOA board spent much time just to get Aloe to take responsibility for this and to pay for some of the repairs. We never received 100% reimbursement for those damages. I'm very concerned that this would even be harder for our communities to remediate any problems with a project of this size. How will you assure the communities that full responsibility will be taken if there are any problems? Most people accept that oil and gas are an integral part of our America's energy production. What they cannot accept is that extraction practices can be a risk to health safety to our communities. There are other places that fracking can be done without these personal risks. I ask that you deny the project, or if you cannot do that, at least postpone it so that our communities can fully participate. Thank you for your consideration.
Thank you, Ms. Hannon. Appreciate you being with us. We now will hear from Paul Van Tol.
Thank you for skipping over me as I was trying to figure out my video and audio. Good morning, commissioners. Thank you for the opportunity to speak with you. My name is Paul Van Tol. I'm a 22-year resident of Erie with my wife, Norma, and I speak to you today as both a family nurse practitioner concerned about the health and wellness of my community, and to the owner of 2104 Amber Court that I recently, 2 weeks ago, found out has an abandoned and capped well named Young 1-23 in our backyard about 20 feet from our house that is not on the community plat, nor is specified on any of the property title documents. First, speaking as a nurse practitioner, I make house calls in Weld and Boulder counties, and a significant focus of each house call is on preventive and healthcare measures. Not only do I discuss vaccinations and health screenings like mammograms and colonoscopies, but I take a deep dive into the chronic illnesses like COPD and asthma with my patients to encourage healthy behaviors, including avoidance of environmental triggers in order to minimize risks of acute exacerbation and slow the progression of chronic respiratory failure. You are all aware of impact of oil and gas on respiratory conditions, and I request your help today in advocating for all our community members in Boulder and Weld counties with lung disease that are advised on more and more days to stay indoors due to ozone action days. The decisions by this commission, the decision this commission makes to mitigate variables outside of individual patient control can support the preventive health measures that I recommend and reduce the impact on the quality of life and freedom of our patients and community members to exercise outdoors. Back to my property, I also ask that the commission consider the impact of the Draco project on the well on my property as referenced in the meeting on October 28 as having questionable long-term stability of the plug, which may increase the risk of damage or impact from any interception from horizontal drilling. So I urge the commission to mandate comprehensive real-time air quality monitoring systems for this project to ensure transparency and immediate response to any harmful emissions that might impact those with respiratory conditions. And I ask the commission to require an independent geological assessment and a detailed plan to address risks from existing wells, including the one in my backyard, and the geohazards, including monitoring the soil for methane and VTEX before project approval. In conclusion, I ask this commission to postpone or deny this project until these issues are fully addressed, and our community deserves answers to unresolved questions in order to reduce the very real risks that this project brings. Thank you.
Thank you, Mr. Van Tol. Appreciate you being with us. We now will hear from Tona Danzy.
Good morning. My name is Tona Dancy, and I'm a father of 3 very young children, and I've been a proud Erie resident for the past 10 years. I'm here to speak on the behalf of our community's concerns over the proposed Draco pad and the partnership that Civitas would like to enter into. To begin, the proposed drilling pad is conveniently placed to be legally permissible, but will then require a 5-mile lateral. It violates the spirit of the laws and regulations that were passed to protect people from fracking operations and leaves our community fighting to protect itself, as you've heard. This procedure and its scale has never been attempted, and for good reason. It will require a staggering 541 million gallons of water. To provide a visual, that is enough to fill 820 Olympic-sized swimming pools. That amount of water to use for a single-purpose fracking operation in a state prone to drought is illogical, unjustifiable, and frankly, unethical, the impact of which extends far beyond our community. That water would then be polluted with toxic chemicals and become immediately unusable. Although Civitas says they will capture and safely dispose of that water, that is a nearly impossible task, which would then need to be executed perfectly to avoid environmental ramifications. As soon as the drilling starts, we can expect health risks to impact our communities. Long-term conditions such as asthma and cancer are linked to the chemicals used in routine fracking operations, and they disproportionately impact our most vulnerable populations, comprised of seniors and our children. As Civitas will be extracting so much value from our community, they will be well positioned to protect themselves legally and absolve themselves from any accountability or wrongdoing in the future. We will be left behind with the short and long-term health issues and that their dangerous operation will leave behind. Finally, our community has seen incredible growth. Many people have come to Erie to start families, businesses, and to lead happy and healthy lives. Fracking operations, especially ones of this magnitude and risk, will stunt our growth as people choose to prioritize their health and well-being over the potential profit of a singular drilling company. We will see our home values drop, businesses decide to open elsewhere, our reduced tax revenue will lead to less funding for our schools, and our reduced economic growth. The proposed relationship that we are being presented with can only be described as parasitic, and our community will have our overall health, environment, and economy drained by and for a single beneficiary. I strongly urge you to reject this proposal and prioritize the safety and prosperity of our community, our children and elders, and those unable to advocate for themselves today. Thank you.
Thank you for being with us and presenting. We now will hear from Jeff Powell. Good morning,
Commissioners. First off, I wanted to thank the ECMC for hosting today's meeting. It's only recently that we learned of the existence of the ECMC, and in learning that the mission of the organization is to regulate the development and production of oil and gas in a manner that protects the public health, the safety, welfare of the environment, and wildlife resources. With that stated mission in mind, many of us chose to live in Erie as an ideal place to put down our roots, to raise our kids, and to be part of a beautiful community. Like so many of us, we only learned about this project, of Civitas's plans for the Draco pad, and the reality of what this is going to mean for our community as a whole as they plan to drill and frack directly under multiple neighborhoods. As homeowners, there was literally no way for us to obtain any type of insurance to protect against such a thing. It's just not something that's available to us. And therefore, this could potentially make our homes uninsurable and take a hit in the real estate market price-wise. Many of us chose specifically to live in Boulder County because of their position on fracking and the effects on the environment. And since the invention and introduction of fracking, there's many documented studies on the long-term health consequences of living near and around active fracking sites and the long-term human suffering that can come from that. My primary concern here is focused on the potential consequences of taking one of the fastest growing towns in Colorado and approving a project that will forever tarnish the reputation of our town, the health of our neighborhoods, and most importantly, just our collective health overall. All the while, we receive nothing in return from this. Consequently, approving this project will likely tank the real estate market locally, making many of our homes unsellable or greatly reduced in value for the price that we pay to live in such a town as this. We refuse to potentially sacrifice our health, and as a result, we've already contacted a real estate agent and looking at putting our recently purchased home on the market. With the cost of real estate fees, taxes, capital gains, all that, we're looking at a net loss of $100,000 in just under a year of being here. This is what we considered our forever home. Ultimately, the oil and gas extracted from this project does not even stay in Colorado, and we've received no benefit from doing so. So how will all this hardship and loss and potentially significant health issues benefit us in any way other than the further enrichment of an oil and gas company? With that in mind, I strongly encourage you to reject this application. Thank you for your time.
Thank you very much. I appreciate you being with us. We now will hear from Anil Pesarimella. Butchered that name, I'm sure.
Yeah, it's Pesaramelli, Anil Pesaramelli. Hi, good morning, commissioners, and thank you for giving me this opportunity. I also appreciate that the commission came to Erie and listened to the concerns of our citizens, and it gave us a bigger picture of what everybody is going through, and you got to hear from them in a first hand, and hear the health concerns and all the other concerns that they have. So I am here to request you to deny the proposal for the following three reasons. One is the high risk that this project brings to Erie, considering the lack of the process or the tested approach. This is the first of its kind where the fracking is happening under the homes, and it proposes like a huge risk, and which is not needed at this time. And we are asking a question: why now? And what are the benefits of doing it right now? And second point is, we moved to Erie for the quality of life and the open spaces and the good schools and the parks. So this project brings, like a decline in air quality and climate concerns. This is bringing to the next level where we need to consider quality of life for the citizens, public safety, putting into the front line and having, giving it importance, because this is about citizens and their quality of life. So the third point is the negative impacts in terms of house pricing and economic viability, loss of businesses, loss of people. Now, Erie is one of the fast growing town, and we need more plans into it to keep it that way. And this project will become a huge stop to that. So just wanted to reiterate that please consider denying the proposal, and as process, if you can improve like strong enforcement of regulations, that would be great. Thank you.
Thank you very much. Appreciate you being with us. We now will hear from Emily Bear.
Good morning, Chair Robbins and Commissioners. My name is Emily Bear. I'm a council member in the town of Erie, but I'm speaking to you today as an impacted resident and mom of children who have suffered grave health impacts from oil and gas development near our home in Erie. First, I want to thank you for coming to Erie, for listening to our residents and our concerns with this application. It's hard to raise your hand as an impacted person, and I'm really moved by those who have shared their lived experience. That's really brave vulnerability. This application is unique in that it proposes to drill beneath the entire width of the fastest growing town in Colorado, affecting 36,000 people at lateral lengths never seen before, through dozens and dozens of plugged and abandoned wells. The slides from Director Frank's presentation at the hearing on the 29th are jarring. Those sites are in backyards and under driveways and rose bushes. There were no measures in place, no reverse setbacks, no safety considerations at all to protect from future development that would explode through plugs and allowed for surface impacts from drilling originating from miles and miles away. The safety for these people must be assured. This application demonstrates that our protections for people fall short. They are inadequate and need revisiting before this kind of development is ever allowed. With the proposed 5-mile laterals, the distance between sea level and the tip of Mount Everest, we cannot presume to know what all the risks to the good people of Erie are, and therefore we cannot have done everything to ensure their safety. There is precedence for this commission to pause this application approval process and apply cumulative impacts rules. Applications were paused after Senate Bill 181 passed and held to the director's objective criteria. I encourage this commission to pause this process, consider the cumulative impacts of air quality and water impacts. With those considerations, this application cannot move forward. I humbly ask that you demonstrate your care and concern for the good people of Erie and our beloved community. Please do not volunteer us as test subjects for this unproven drilling. You can stand on the Commission's rules to deny this application, and I am asking you to do that. Thank you so much.
Thank you, Ms. Bear. Good to see you again. We now will hear from Steve Nelson. Followed by Justin Clark. Mr. Nelson, Mr. Clark, followed by Katrina Stroud.
Mr. Nelson is here, but the host has stopped my video, so.
Well, hold on just a sec. Let's see if we can get that fixed. There you go. We can see you, Mr. Nelson.
Not much to look at here. First, I'd like to thank the commission for holding the hearing and for being open to the concerns of the community. I am a grandfather, a retired educator who moved to Erie in 2017 with my wife to be near our two small grandchildren. I may not take my entire time because so many of the points I hope to make have already been made and no need to reiterate them. I do want to start by saying that I responded to a comment made by a local resident about what's in it for us, and my somewhat cynical comment was, what's in it for us is to contribute in a small way to the catastrophic circumstances that are producing irreversible climate change on the planet. I don't think that's an admirable thing for us to accomplish. I also noted with a chuckle that my friend Skylar talked about the horizontal drilling being akin to someone breaking into homes from a distance. My own metaphor was that it was more like someone drilling beneath the ground to rob a bank, and while they're at it, they're going to rob all the branches too. I think the way of avoiding the regulations in Boulder County for the health and welfare of Erie residents is irresponsible and unethical. I also wish to raise a couple of points regarding the global impacts, even though I know it's beyond the Commission's reach. This project, as I read about it, has at least a 20-year production timeline. I imagine that the corporate leaders have a very careful calculation of return on investment because the investment is certainly considerable. That means that the production, in order to be profitable, is going to go on for at least 15 years beyond the Paris Climate Accord guidelines to reduce greenhouse gas emissions by 43% by the year 2030. We're going to reach that in 5 years into this project, and our little town or our combined counties are going to be contributing to the gases that are emitted into our atmosphere for at least 15 years after the UN guidance for reduction of those. And finally, I think it's important to note that my grandchildren live in this community. We moved here to be near them, and we happen to be at the bookends of high risk. And my wife and I are deeply concerned that the community we joined to be near our grandchildren is now going to undertake something that will pose a significant health risk to us and to them. Several of these 5-mile horizontal bores are going to go directly beneath their house. I think it's unconscionable that we would agree to do that, and I join my neighbors in asking that the commission deny this application. Thank you for listening.
Thank you, Mr. Nelson. We now, second call for Justin Clark, Katrina Stroud, or Bobby Mooney. And we now will turn to Leslie Gumpf.
Hi. All right. That was faster than I expected. I am Leslie Gumpf. I live in Erie, and I'm a member of the Flatiron Meadows Oil and Gas Monitoring Group. I'm here to remind you of the concern of subsidence hazards from abandoned coal mines. I wrote the appendix on regulatory errors regarding the geologic hazard plans for our 511 hearing request. Briefly, I found problems with the submitted geologic hazard maps, including using the map scale that the Colorado Geologic Survey has stated is beyond the limits of their mapping accuracy. This is especially alarming because Civitas has been told that the maps were made before mining operations at the Eagle Mine were finished. They chose to show an older, less detailed geologic hazard overlay that does not show potential fault lines in the immediate area. Bedrock faults do exist. They did not submit a geologic hazard plan as required, despite knowing that the Draco site was within a severe subsidence hazards area. They also did not formally ask for or receive a waiver. Civitas pretended to address these concerns, and their words were enclosed with the director's recommendation dated August 16th. Some of the misleading statements in this are, there were no geologic hazards that were identified within a mile of the Draco location. This is based on their view that there is no risk to their pad and operations. They do not address the overall subsidence risk to the community. Of course not. They are not liable for damage. The Draco pad location and wellhead locations will not intersect with any existing coal mines. Unless I misunderstand, wellheads are above ground and mines are below ground, so of course they don't intersect. The third quote, the wells will be drilled and completed at a depth exceeding 7,000 feet below the deepest point of any nearby coal mine. They cannot get from the surface level down to that final depth without drilling. How close to the mines will the well bores be on their way down? Sorry. As you have heard from others, these are not the only ways that Civitas has attempted to deceive the commissioners and the public. As you listen to Extraction's response to these comments, please keep in mind their history of giving irrelevant and misleading information instead of addressing the actual concerns. I'd like the commissioners to take a step back from the business of oil and gas and think about this as though it were a standard building project. If you were looking to hire a builder who proposed to do something never done before, used misleading numbers and words, and misdirected rather than answering a question, avoided a study which might reveal significant problems, if every rating you could find is 2 stars or less, what would your gut be telling you? If they promised they would adhere to best practices, does that make up for all of your concerns? Would you hire them? Thank you.
Thank you, Ms. Gumpf. We appreciate you being with us. Hearings Manager Thomas, there were 3 folks on the list that we weren't able to find. Does that remain an accurate statement?
Yes, that's correct. We were unable to locate Justin Clark, Katrina Stroud, and Bobby Mooney. If any of those individuals are in the attendees list, please raise your hand and we can elevate you to.
All right. So with that, let's take a few minutes and get ready to hear from Mr. Maxey and also re-elevate up David Frank from the town of Erie. It is 11:22. Let's return at say 11:29. That's 5 minutes out. All right, welcome back, commissioners. Docket 2401-00004, the Draco Oil and Gas Development Plan. Hearings Manager Thomas, did we hear from anyone else relative to the public comment sign up?
We did get one hand raise, Mr. Chair Robbins. We're elevating Ben Hemphill now, and in hopes that that's one of the 3 individuals that was not able to speak.
Right.
So,
okay.
Hi, my name is Ben Hemphill. I wasn't on the sign up list, but I'd like to make a public comment if you want to set up the timer again.
Yeah, go ahead, Mr. Hemphill. You got 3 minutes.
Okay. Thank you for your accommodation and thank you for this meeting. Again, my name is Ben Hemphill. I'm a resident of Grandview in Erie, which is above the extraction area. And I'm also a licensed professional mechanical engineer. 3 weeks ago, I asked Civitas about their experience drilling these laterals, and I still haven't received a response. I urge this commission to evaluate Civitas's technical capability to perform drilling at this length. The drilling is challenging enough under unpopulated lands without other wells to dodge, and this application is proposing doing experimental drilling under 10,000 plus residents of Erie. I won't rehash my complete comment on October 29th, but I will reiterate that the site selection just outside the town of Erie's boundaries to prevent direct compliance with the town that will be most affected by the drilling operations. In my line of work in the nuclear sector, we routinely utilize risk matrices that evaluate project risks and possible mitigations. This risk matrix compares likelihood of a failure with the impact of the failure. This commission should require such a risk analysis for this project. I suspect there are multiple likely risks with critical harm and possible risks with catastrophic outcomes. In my opinion, approval of this application is directly opposed to the ECMC's stated mission of protecting public health, safety, welfare, the environment, and wildlife resources. I encourage this commission to reject this OGDP based on the technical risk. Thank you.
Thank you, Mr. Hempel. Okay, that concludes public comment. Moving along in our agenda, we next will hear from Jason Maxey, the Director of the Weld County Oil and Gas Energy Department. Mr. Maxey.
Thank you, Chair Robbins, and good morning to you and the other commissioners and to everybody joining this hearing this morning. My name is Jason Maxey. I'm the Director for the Weld County Oil and Gas Energy Department. Thank you for the opportunity to speak before you regarding the Weld County 1041 WOGLA process and extraction oil and gases Draco OGDP that is in front of you today. Before going any further into our prepared comments, for the record, I do want to say that Weld County did attend the 511 hearing, and we appreciate being able to observe and be there. I do also want to reiterate for everybody the fact that Weld County's oil and gas permitting process deals specifically with land use items, things such as lights, traffic, noise, waste management, etc. We do not permit anything downhole. Additionally, through our process, we specifically defer certain items to other jurisdictions that are experts in their field, such as CPW or CDPHE. With that being said, Weld County's Oil and Gas Energy Department, or OGED for short, held a pre-app meeting for the Draco pad on August 30th of 2023, at which several alternative sites were discussed. Attendees included Weld County staff, extraction staff, ECMC staff, CPW staff, and the town of Erie. CDPHE, BLM, and Boulder County were invited to this meeting but did not attend. All attendees and invitees, regardless of if they attended or not, did receive a copy of those pre-application meeting notes so that they had record of what was discussed and the alternates that were discussed. The initial 1041 WOGLA application was received November 7th of 2023. And following further discussion with my staff and with Extraction and their consultants to clarify and enhance certain items, the final application version was submitted to us on December 21st of 2023. For the record, case number 1041 WOGLA 230062 is assigned to this location. The application that we reviewed included an analysis of 4 alternate sites, which were reviewed and discussed in detail with Oil and Gas Energy Department staff. At the 1041 WOGLA hearing, the Weld County hearing officer reviewed and discussed these 4 alternate sites with the applicant, and the Draco pad was determined to be the best location. There are 7 Weld County defined building units within the 1041 WOGLA zone. And I feel it necessary at this point to expand on that comment and say, for everybody's benefit, remember that the 1041 WOGLA zone inherently is a larger zone, measuring out from the oil and gas location, the ultimate boundaries of disturbance, compared to the 2,000 feet that the ECMC measures out from the working pad definition. And so we inherently notice more people about this application through Weld County than goes through the ECMC process. And I think that that's important as we get through future comments that I will make. Weld County sent notices of our hearing to 24 different parcels, which make up 15 different property owners. Throughout this process leading up to the application hearing, we did not receive any applications for public intervention into our process. We did not receive any comments from the actual notice parties within the 1041 WOGLA zone. We did receive 5 public interactions through email, all being residents or businesses within the town of Erie. None of these 5 commenters owned a building unit within the 1041 WOGLA zone. All 5 of these public comments were made a part of the record, and anybody can look at them through our online system. Referral requests to multiple agencies were sent out on December 22nd of 2023. Responses were received from multiple Weld County departments because, as you know, we refer to other departments for their review within Weld County. But external agencies that received a referral request included the Town of Erie, CPW, ECMC, CDPHE, St. Vrain Valley School District, the Community Ditch, or in other terms, the Farmers Reservoir and Irrigation Company, or FRICO, and the Colorado Geologic Society. Whether it was a comment from the public or comments from a referral entity, either our staff or Extraction replied. In some cases, including examples such as Southern Land Company, the Town of Erie, or FRICO, Extraction not only replied, but additionally committed to increased BMPs, which was prior to the 1041 WOGLA hearing or any formal questioning from the Weld County hearing officer. All comments received by oil and gas staff at Weld County, whether from the public or a referral entity, are again a part of our public record for this case. The 1041 WOGLA hearing for the Draco pad was held on February 29th of 2024. The hearing officer considered testimony from OJED staff and Extraction at the hearing. The Town of Erie and FRICO were attendees at our hearing and provided testimony. No other referral parties participated. Again, no members of the public requested to participate in the hearing, but any comments received from members of the public were responded to and made a part of our record. The hearing officer found the application compliant with Weld County code requirements and approved the permit. The final order has been recorded with our Weld County clerk and recorder as per our requirements in our code and was noticed in the Greeley Tribune on March 16th of 2024. Approval of Extraction's application creates a vested property right pursuant to Article 68 of Title 24 under Colorado Revised Statutes. The approved permit is valid for 3 years. Construction has to commence within that time frame, or an extension must be requested and approved, or the permit will expire. The approval of Weld County's 1041 WOGLA permit and Extraction's commitment to best management practices outlined in the application, in our opinion, will protect the health, safety, security, and general welfare of the present and future residents of Weld County and Erie, while also protecting both the environment and wildlife. From a land use perspective, commissioners, this is a good location. It is close to other oil and gas development, and it's intermixed with agricultural and commercial uses. There is another active WOGLA location within the 1041 WOGLA zone, along with the Crestone Oil and Gas Hub, as it's called, which was permitted as a use by special review permit through Weld County Planning Department about 10 years ago. Additionally, Front Range Landfill is directly to the south of this location across County Road 6. 2A comments were submitted to the ECMC on August 11th of 2024 and are included in the director's recommendation. Due to the fact that Extraction has completed the WOGLA application process and that a final order has been issued, recorded, and legally published, Weld County has no additional concerns with the pending permit before you all, and we agree with the director's recommendation supporting approval of this permit. I'd like to round out Weld County's comments by voicing my concern over some of the comments heard today, or that were submitted during the 2A comment period. It is specifically concerning to me when a proximate local government, such as the Town of Erie, was a full participant in our 1041 WOGLA process, from start to finish, pre-application, literally through the hearing. They were a part of it from start to finish. They were proposing or requesting certain things be addressed through the 1041 WOGLA process. And we have an applicant who is willing to address those items, all of which is on record, but then turn around during the ECMC process and say they have significant concerns while also proposing additional considerations that were not mentioned through our process. I just have to be honest, this is extremely frustrating. The same general comment can be made for the Southern Land Company. They did not request to participate in our hearing, but they did submit comments for our review and inclusion into the record. Our staff and Extraction acknowledged the comments, and Extraction agreed to additional BMPs that were not initially part of our recommendation. However, the 1041 WOGLA final order and the process works. It stipulates that Extraction must meet with the town and developer to continue addressing any concerns regarding this development. I am aware that Extraction has continued to evaluate their development, consider comments, and work with reasonable requests. In general, we are also agreeable to allowing changes to the 1041 WOGLA permit because, as you all know, enhancements and plans to utilize the latest technology is always a good thing. However, it certainly would be nice to acknowledge that our process works, commissioners. We encourage reasonable dialogue between the county, the applicant, the public, referral agencies, and state agencies. We incorporate certain recommendations that we feel are reasonable and applicable to the application at hand. My closing comments are not meant to disparage anyone, the town or Southern Land Company, but rather they're intended to bring attention to the fact that through involvement with WELD's process, we listen. We incorporate items into our final orders, and in this case, the applicant listens and has agreed to enhance BMPs and additional conversations. The process works. We simply request that people who participate maintain consistency from our process to yours, and don't make it seem like we don't listen or that we're unwilling to address reasonable requests or concerns. Commissioners, thank you. We appreciate the time you take to listen to these oil and gas plans in front of you all, and for considering the time that we've taken to review the same permit at the Weld County level. We appreciate our participation in your process, and as always, I will always do my best to answer any questions you might have. Thank you for your time.
Okay, commissioners, questions for Mr. Maxey? Commissioner Cross?
Thank you, Mr. Chair, and thank you, Mr. Maxey. And I wanted to make sure that I was clear on a couple of the points there. So Erie did attend your comment process, but Southern Land Company did not. Is that correct?
That is correct, Commissioner. So just to be very clear, the town of Erie was at our pre-application meeting. They participated in the referral process, meaning they submitted written comments and had recommendations through that process. And they also were an active and participant and active at the actual hearing. They were there. Now, they were there remotely, like I'm doing right now with you all, but they were a participant at the hearing. All of their requests were listened to. Their requests and a lot of their recommendations were incorporated into our final order. My statement is meant to draw attention to the fact that it's a little concerning to see how many additional things were then submitted a few short months later during the 2A comment process and now today at this hearing. To us, that does not show consistency. That does not show good communication between agencies, especially when they knew about this and were a part of the process from the very beginning. Southern Land Company submitted comments. We had dialogue with them. Their comments were reviewed during the hearing, and they are also mentioned in the final order as well, as far as needing to have further coordination with Extraction. However, they did not request to be a participant in our hearing.
And then the other thing that I wanted to try and get some clarity on as well is you talked about, you said in your opinion, it is the proposed location is the best location for this. And you mentioned a couple things: close to other development, close to the landfill. You said, and the two things that I wanted to try and elicit a little bit more detail on was, number one, you said there's other active development within the WOGLA area, and also it was part of the hub. And if you could provide a little more detail on those 2 points, I'd appreciate it.
Yes, thank you, Commissioner. So let's talk about the active development first. There is an active WOGLA site. Please make note that it's not a 1041 WOGLA site. This was before your mission change happened with Senate Bill 181. This was before this department was formed. But it is a WOGLA permit that is on a parcel that, from my measurements, the approximate distance from this proposed new location to the existing producing WOGLA location that is on record is literally less than 750 feet. So it is well within the 1041 WOGLA zone, which, as you know, is 2,000 feet from the edge of disturbance. So that activity is close. The other activity that is close is what we refer to as, and it's simply a name only that I'm familiar with, but it is not only directly south of the proposed Draco pad, it literally is on the same parcel as the Draco pad proposal, and that is the Crestone Hub. And I would have to defer to what activities actually happen on there, but it is a oil and gas, what we call an oil and gas support and service location, meaning it had to be permitted through our planning department through a use by special review permitting process, which went through the Board of County Commissioners for review and approval. And it is in essence an oil, I would call it kind of like an oil transfer hub to where product comes in and product leaves. And so that is a very much so a commercial use, so much so that it had to go through the use by special review process through the planning department. And then the landfill is directly south of both of those items that I just referenced.
Okay, thank you. And for the active development, do you know which direction the wells in that active development go?
I do. Those well bores leave that development and they go straight north.
Okay. Thank you. I think those are my only questions. Appreciate it.
Thank you.
Other questions, Commissioner Messner?
Thank you, Mr. Chair. Mr. Maxey, I was reading the local government, I can't remember what it's called, the order, but in there it seems to indicate that in your process, the applicant indicated that they cannot commit to drilling all wells in one occupation. Understanding your process, and that while at least when it went through your process, 6 of 7 RBU owners within 2,000 feet had informed consent, and I think that was a consideration in your determination, but also understanding at least that the applicant was not committing to one occupation, which having a known subdivision, adjacent to this, or certainly within the WOGLA zone, which at least I'm hearing in testimony could have 2,000 feet from our measurements could have 77 RBUs associated with that. How does that play into the determination of whether or not the application meets your standards when you're looking at maybe over 80 RBUs within 2,000 feet versus 7 with 6 having informed consent?
Thank you, Commissioner. And I think that's a great question for discussion to have. It is extremely hard to do local land use planning when things are unknown, when things are just planned, when things are not concrete. Point being, when this development went through the Weld County process, property mapping did not show the latest filing of lots being approved for the town of Erie. When I look at my mapping now, there are additional lots that have now come online through our mapping system that shows that an additional development plat or something has been approved through the town of Erie. So things change, but until things actually start happening or are approved, you can only look at what is real at the time. I'll reference also the referral response from the school district. Their referral response said that they are in negotiations for land, which they expected to be concluded within the next year at the time of our process happening. However, their referral response also stipulates that they would be looking potentially at a possible school site sometime into the 2030s. That's not a very concrete anything for us to go off of. It's a possibility. It's a maybe. There's a lot of factors that go into that. So we have to look at what is true in front of us right now, which is why we look at property divisions. And as you know, we don't just look at what's currently built being the building units that are currently there. We look at property ownership and lots. And so if this plat that is now showing on my, or if the most recent filing that is showing on my mapping system would have been approved at the time of our process, our records, to your point, would have shown much more property ownership potential due to those lots being platted. We would have sent notice to those lot owners. In this case, it's the exact same owner. It's the developer that would have gotten notification, and in fact did get notification during our process. So I hope that answers your question about how we look at it, about what is real and true at the time, and how we look at compatibility and land use from our perspective, and how, going back to the time frame that you stipulated, as far as wanting to specify a 3-year time period or drilling all in one occupation. Those were comments that we received both from the town of Erie and Southern Land Company. They were discussed at our hearing. I'll defer to the applicant when they come up in front of you today, but I know that there has been conversations that they are more inclined or more able to definitively answer that question today than at the time when they went through our process a few months ago, they were able to determine. That's why our hearing order, final order, did not specifically restrain them to a very specific 3-year window. So I hope that addresses that. If not, please let me know and I'll try to clarify.
No, I mean, it helps me understand. It does highlight the importance of, looking at reasonably foreseeable future development. But I think what I'm hearing you say is that you were making a decision based on land use, known land use, but did acknowledge that drilling and completion activities could happen at almost any time in the future, right?
I would say yes, your statement is accurate. And it's not, I want to clarify though, and also expand on that by saying it's not that we don't want to consider the potential future land use, but being a former county commissioner yourself and knowing land use, you know that usually until something is solidified and is moving forward with an actual development plan, I could say I want to do something with my property today, and there's an idea out there, but it's not concrete. It's not actually happening. And so you have to look at what is actually truly out there as far as land use and compatibility and how this fits into the surrounding area compared to what a plan might be that you have no definitive information about when it may or may not even happen.
All right, thank you. I think that's my only substantive question. I had a couple other questions, but I don't know if they're relevant. So thank you.
Thank you, sir.
All right. Other questions of Mr. Maxey? All right. Seeing no further questions, thank you, Mr. Maxey. Appreciate you being with us and for providing the Weld County perspective on this proposal.
Thank you, Chair Robbins. If I may just quickly note, I will hold on also. I do have a 1 o'clock. I understand that maybe there might be some questions for Mr. Frank with the town of Erie. I can hold on until about 10 till 1. If you need me after that, please just contact me as you've done in the past, and I will step out of my meeting and rejoin if I need to, okay?
Yeah, sounds good. I know how to reach you.
Thank you.
Let's turn to Mr. Frank next before we take a lunch break. Mr. Frank, thank you. You testified earlier today during public comment, noted that at least one commissioner had some questions for you. So if you're available, let's go ahead and recognize Commissioner Messner with whatever questions he may have had.
I'm available.
Thank you, Mr. Chair. Hello, Mr. Frank. And actually, this is kind of a question for Mr. Maxey and Mr. Frank, because I mean, I'm hearing some conflict between jurisdictions here. That's not unusual between counties and municipalities. I'm wondering, besides the WOGLA process, is there a 3-mile plan or a plan between your jurisdictions that kind of lays out how the two towns interact when land use is occurring at the borders of each of your jurisdictions? It's a pretty common thing for municipalities and counties to have 3-mile plans or transition area plans, something like that. Is there something that occurs between your two jurisdictions?
Mr. Frank?
Not that I'm aware of, Jason. If you know of a document that maybe predates me and my efforts to town, please let me know. But that is certainly something that the town would be very interested in entertaining. We can certainly look toward some sort of an IGA, certain radius, to come to some, agreement on how these should be handled in the future.
Mr. Maxey?
Thank you, Chair Robbins. Thank you, Commissioner Messner. Mr. Frank is correct from what I am looking at right now with our active, we call them CPAs, Coordinated Planning Agreements. Those are with our Department of Planning Services, and that is for those types of developments. But regarding a specific answer to you, right now, from what I see, no, the town of Erie does not have a CPA with Weld County. I do know that future direction from the Board of County Commissioners to the Planning Department is to actively pursue updated CPAs with all of our 32 municipalities within Weld County so that we can have better coordination regarding land use. Now, take that with a grain of salt, because specifically in 1041 WOGLA code today, oil and gas development is not a part, that we're our own department. We are not a part of the planning department. And so at this point in time, oil and gas development is not a part of the CPA agreements. It does not adhere to the 3-mile radius that you alluded to that is typical in those types of agreements between jurisdictions. So I just want to be clear about that.
Okay. Go ahead, Commissioner Messner.
Yeah. So, Mr. Frank, I've got a few questions for you.
Before you get into your questions, I do want to address Director Maxey's expressions of frustration and just give you a sense of the timeline over which Draco was brought to our attention. I met with Civitas on August 15th to discuss potential oil and gas development in and near the town. There was no mention of Draco at that meeting. 6 days later is the first time I had heard the term Draco, and that's when I was informed of the pre-hearing meeting by Weld County staff Jennifer Teeters. Bear in mind, this is the third meeting I'd had with Civitas in as many months, so it's not an issue of trying to communicate with the operator. We were discussing one of the alternative locations to Draco, which they chose not to pursue. But that gave me basically 9 days to review the WOGLA application. I mean, that's the first time I heard of it, Jason. And so that's very little time to come up with a comprehensive list of comments and concerns. So, over the next year plus, as I had a chance to dig deeper into it, other things came to light. And as you'll see in the presentation by the operator, we've worked diligently to work through all of those concerns and address as many of them as possible. I don't know how many times we've met. I think they have a thorough list. It's like a dozen. So just wanted to throw that out there.
All right. Thanks for that additional comment. Commissioner Messner, questions?
Thanks. So, Mr. Frank, just an overarching question here. I mean, I've read your written statements. I heard your testimony at the 511 hearing, heard your testimony today. I also heard a number of city council members at the 511 hearing provide testimony. I heard at least one city council person provide testimony today. I'm still not exactly sure I'm clear what the overall disposition of the town is on this application. Has there been a formal position that has been taken by the town of Erie on this application?
Well, I'll say this. This is a country of law, not of justice. If the town saw a clear place where this oil and gas development plan violated local or state statute, ordinance, rule, or regulation, then we would probably have a firmer stance. As it is, compare it to, if I want to build the world's ugliest shed, as long as I comply with municipal code, my neighbors might not like it, but I have land rights. I have rights to use my parcels as I see fit. And I think that's kind of where Draco falls. It's obviously extremely impactful to the town. The town sees no tangible benefit beyond the plugging and abandoning of 22 wells at 18 locations. I can imagine it's probably pretty frustrating for Southern Land to have been in a process over 7 years to build a neighborhood, to see in the last year of those efforts an oil and gas plan proposed and quite quickly approved that directly impacts their ability to sell homes to buyers. So I think the town's overall position is we don't have firm footing on which to oppose things. I'm not interested in coming to the commission here and saying I'm against this because I don't like it. I think that's a ridiculous position for a local government to take, and I think it's not productive. Instead, the position the town has taken has been to meet as often as possible with the operator, to engage the stakeholders, be those members of the public, adjacent landowners, and try to reach as many consensus points as we can to try to make sure that if this operation is permitted, that it is as protective as possible, and as least impactful as possible.
Okay, thank you for that. I wonder if you could expand upon the town's concern. I mean, my understanding, at least in the application, and understand, also acknowledging we haven't heard the applicant's presentation yet, but that the applicant is proposing a well completions deadline of May 13th, 2028. And I think I also understand from your testimony that you still have concerns about that. You feel like there's that's still a problem. I wonder if you could just highlight that again for me so I better understand.
Yeah. So when I started working for the town 3.5 years ago, one of the very first things I did was update the portion of our municipal code defining reciprocal setbacks, how close you can build a home or other building to an oil and gas facility. And one of the things that I included in that ordinance was that if we have an application before the town, the state, or one of the counties, that until that application is either finished and not approved, or until every well in that application is in production, that residential lots cannot be platted within 2,000 feet. Now, obviously, you have to have a start date to any new rule, and Westerly was well into its permitting process when we adopted that. So those revised municipal codes don't apply to them. So once we heard about Draco, we went to the developer, Southern Land, and said, "Hey, obviously, we can't force you to comply with rules that didn't exist when you first proposed your application. What can we do voluntarily to get as close to our current code as is acceptable to your plans for your land?" After a lot of negotiations, what we came to was an agreement of 3 years. We thought that was pretty reasonable time frame to get to get Draco into production, and that's what our development agreement with Southern Land reflects. 3 years from either. We didn't know when this hearing would take place. It looked like it was going to be in August at the time. So we said 3 years from 2A acceptance, or I believe it's October 14th, 2027. Obviously, this has been delayed about a month out past that. We were grateful for those concessions. I think that speaks a lot to the character of the folks at Southern Land to voluntarily make a commitment not to build those homes in that time period, to phase their development appropriately. They're not interested in renegotiating that development agreement, and I certainly don't blame them. So what we're left with is a circumstance where there's sort of a 7-year gap between what the town and Southern Land has been able to negotiate and what Extraction has agreed to. So
7 months.
What's about 7 months between October what'll it be? October 2027 and May 2028.
Okay, so it's that 7 months. So you're advocating for October 14th, 2027, applicants proposing May 13th, 2028. Is that fair to say?
Yeah, and you know, I understand the necessity of certain force majeure clauses, but I'm a bit concerned that there are too many off ramps that could extend that currently May 2028 deadline out even further, where folks would be presumably moving into their brand new dream home while rigs are still up or fracking engines still running.
Okay. Thanks for that. That helps me better understand your position on that one. And then just so I understand, was negotiated between Southern Land and the applicant, and I think you're okay with it, but I want to confirm this, some soil monitoring for the 7 sites that Erie is concerned about. Is that correct?
Yeah, so those are conversations that have happened between the town and Extraction.
Okay.
We're both quite happy with the language we've mutually come up with. I hope Extraction here in a few minutes testifies to that. We would both mutually just like that included, in permits granted by the state, and have the state recognize that agreement or that language. The reason for that is it allows an additional layer of enforcement. It prevents us from having to waste a lot of time and effort getting lawyers involved to draft up a legal agreement, which would probably then necessitate litigation in the case that we disagree with how that was enforced. Of course, that's always an option, but never a road you voluntarily want to just go down.
Okay. Thanks for that. Confirming, and I think I know the answer to this, but I just want to confirm it for my notes, that you're indicating that 77 RBUs are proposed that would be inside 2,000 feet from the proposed development, not constructed yet. I understand that, but are being proposed as part of the development. Yeah.
Well, 72. That's 77 counts the 5 in unincorporated Weld County just to the east.
Okay. Thanks for that. And those cannot be constructed, I think, based on your previous testimony. Construction couldn't start on those until October 14th, 2027, or 3 years from the conclusion of this hearing. Is that right?
Close. What we were able to negotiate with Southern Land is that they've agreed not to apply for, and we will not grant any certificates of occupancy. So we can ensure no one will live in those homes, but they might be built.
Okay. So they could be built prior to October 14th, 2027, but they can't get a CO.
Right. And again, that's because we're not trying to protect residential building units. We're trying to protect residents.
Well, that helps me better understand a timeline, because it could take certainly up to a year to build a house. And so that's also helpful. So the applicant has indicated that in their alternative 4, I think both in the WOGLA process and in the application before us, that there's no path to permitting there. Is that true?
No, I disagree with that completely. We met, like I said, 3 times over the summer of 2023 to discuss what was then called the Josephine location, which is ALA number 4. We explained what we saw as the necessary steps to seek permitting, starting with rezoning. In that last meeting, August 15th, we said, hey, schedule a pre-application with the planning department to lay out the steps of how you're going to go about rezoning that parcel. Never heard back.
Okay. So if they were to proceed with trying to permit an oil and gas location at that location, can you walk us through the steps of that?
That's a bit outside my department, but I can take a stab at it. So the rezoning process is I'm going to guess it'd take, on the order of 9 months. It would have to go through both our planning commission and our town council. with public notice, public hearing, public comment, etc. There would have to be reviewed adjacent land uses. That parcel is currently zoned agricultural, and so there would be those sorts of considerations. I think the language in the alternative location analysis.
I'm going to stop you 1 second,
Yeah.
Mr. Frank. So you indicated that it's currently zoned agricultural?
Yes.
There was some testimony somewhere that seemed to indicate that it was already being contemplated as residential.
There was a residential development proposed called Red Tail Ranch. The town council rejected that proposal, citing environmental concerns, namely the current and former landfills in the area, as well as the 5 active oil and gas pads on that parcel.
Okay. So I didn't mean to interrupt you.
No,
you want to continue, go ahead. I was getting confused there for a second.
The alternative location analysis uses language that was parroted in the director's recommendation that requiring rezoning does not make it more protective. I don't see it that way. Making sure that an oil and gas facility is zoned for industrial usage, and then that zoning necessarily restricting what could and couldn't be done on adjacent parcels probably makes it more protective, not less. It is a slightly more, difficult and publicly transparent permitting process, which may not be convenient, but again, is likely more protective.
Okay. And I think you indicated, and I read in the ALA that alternative 4 location is in proximity to a landfill. And I also I may be asking you something that's outside of your area of expertise, but most land use codes would contemplate land uses similar to things around it, and so does landfills and industrial go together?
In my opinion, yes. I'm not a planner, but I will say that our town council has decided that residential usage of that parcel is not appropriate. And as I said, there are currently 5 operating oil and gas pads on that parcel. So it's certainly not incongruous with the current land usage out there.
Okay. Thank you. That's helpful. And then I wonder if you could provide any context on any schools that are being proposed as part of this new development. And I know that you're not the school district, but I assume that there's some land use process that school has to go through as well. And I'm still a little gray on where the school is being perhaps proposed and when.
Sure. I'm going to have a hard time answering you on the when part, but it's basically directly north of the Draco pad. Just a second. I'm trying to measure on my map here. I'm working on the fly. Probably about 1,500 feet to the north. If you look at a map where the Frico ditch is running basically due north and then makes a right-hand dogleg of about 90 degrees and then curves back to the west, that C shape that the ditch makes, that's the parcel being considered by St. Vrain Valley for a future school location. I have no idea their timeline. It's my understanding it's a decade plus before they'll need that school in Erie. They're of course an extra governmental agency. They can do what they like regardless of Erie's municipal code or Weld County code. And so if they choose to purchase and use that land, that'll be their prerogative. And whether or not Draco affects their potential usage there is strictly their purview.
Fair enough. Just so you know, you do have location and extent review on those, but
somewhat, yeah. But when a school says we want to put a playground on top of a plugged-in abandoned well, and I tell them no, they tell me they don't care.
Right. Thank you, Mr. Frank. Those are the questions I had for right now. Appreciate you being here.
Yeah, thank you, John. I think Jason has his hand raised, Chair Robbins.
Yeah, give me just a second. Let me I recognize Commissioner Oath first.
Well, yeah, I have a couple of questions, but and I'm happy to go. I don't know if Mr. Maxey was wanting to respond to one of those items.
Mr. Maxey, do you want to weigh in on something?
Thank you, Chair Robbins, and I appreciate the consideration. In a case like this, in a case like any of these that you review or that we review, I firmly believe that facts matter. And I am not wanting to assume anything from what Mr. Frank said here, but I would really like the consideration if we could be on the same page with one thing that I heard him say that I was shaking my head at, and that is the time frame. I just want to make sure that the commission has the facts straight about the time frame that the town of Erie had. And if Mr. Frank could confirm or deny this, I would appreciate it. So that's the reason I wanted to clarify that for your benefit so you knew the time frame. Would that be okay?
Sure.
Okay. So Mr. Frank alluded to earlier that he had 9 days to review the application. The time frame was Mr. Frank attended our pre-application meeting on August 30th, which is the start of our process. Weld County did not receive the application, and it was not deemed complete until December 21st of 2023. In between his participation at the pre-app meeting and our receipt of the actual application in late December, Mr. Frank and the town of Erie were recipients of another required notification, being the 1041 WOGLA notification of a pending application submittal. That carries with it a 30-day mandatory code required time frame to allow any further discussions from any notice parties with the operator or with Weld County. In addition to that, when Mr. Frank receives a referral from Weld County, he has a 28-day code stipulated referral period that he has time to review the full application and then submit his comments back to us. And in addition to that, there is a time frame after the referral leading up to hearing that Mr. Frank has a time to prepare other comments. I just wanted to clarify his comment about 9 days to review the application because that is why I was shaking my head. That is not factually true. And I think that the time frame matters when we're talking about review of an application to this significance, such as in front of you right now. So, Mr. Frank, can you confirm that or?
Yeah, absolutely. I appreciate that, Jason. Yeah, you know, you're completely correct. I don't disagree with any of that. And I apologize if my words were unclear, if I misspoke there. I simply meant 9 days from the first time I'd heard of it until that pre-application. No, there was yes, as you stated, the required time periods for me to review the application between then and what was it, February 29th was the actual hearing. So
correct. Okay. Thank you for confirming that because I think that matters.
Absolutely. Yeah,
Okay.
I apologize if I was unclear on that.
All right, Commissioner Oath.
Thanks, Mr. Chair, and appreciate that Commissioner Messner covered almost all of my questions. Just have a couple follow-ups on a number of those topics and then one separate area. So in terms of the alternate location number 4, Mr. Frank, I know this may be a bit outside of your purview, but do you know and can you share for me what is the standard by which the council evaluates whether or not to approve an application for rezoning?
Well, I'm going to be way out of my lane here.
Okay.
I think it's primarily first they go to the comprehensive plan, right? What the future proposed usage is for a parcel, and I believe yeah, ag residential is what's in our comp plan, though we're currently revising that comp plan, but that's the first place they're going to look. Both the planning commission and the town council. And then the next thing is what are the adjacent land uses currently? And is the proposed zoning consistent with those current and future land uses?
Okay, thank you. And to your knowledge, it sounds like there was an application submitted for a rezoning to residential, which was not approved. Do you know, even if it's a rough estimate, how long that process was between kind of the submittal of that application and a decision?
Ooh, like a decade. The initial Red Tail Ranch proposal, part of any land usage, we're going to do an environmental review And in that environmental site assessment, there was uncovered, I won't say unlicensed, but sort of forgotten about dump in the ravine there, where the IBM Corporation had disposed of, I think it's on the order of 37,000 drums of various solvents involved in the chemical manufacture of materials back in the 1960s. That led to a whole subject that is way too long for this hearing. But basically, 2018, those drums were exhumed, and the site was identified as a Brownsfield site. It's been rehabbed. It's been remediated. We've got sign off from EPA and CDPH&E that site is cleaned up and is in a sort of a hold and monitor period. But that kind of put the brakes on the initial application. They resubmitted 2-ish years ago. Don't hold me to that. A year or two later, or from the current day. Sorry, a year or two ago. Said, okay, now that the New Howard landfill is cleaned up, let's proceed. And obviously, in that interim, there's been a lot of oil and gas drilling out on that parcel. The Pratt site, the other Pratt site, the Waste Connections site. And so the town council deemed, between the closed landfill, the previously unknown landfill, the active landfill, and these oil and gas pads, residential is just really not appropriate for this parcel anymore.
Okay. Thanks for that. Appreciated the questions and answers on the potential school. I had some questions trying to better understand that as well. It seems like there's just been some speculative conversation of a potential site about 1,500 feet or so away, but the district what I gathered was the district doesn't have any concrete plans and has not yet even purchased this parcel.
That's my understanding, unless things have changed from the last time I talked to St. Vrain, which is possible. It's been many months.
Okay, thanks. This one is kind of a different one. During the 511 hearing, we heard a number of comments related to concerns about impacts to water. A lot of it had to do with quantity of water, but there were also some comments with just sort of an unknown concern to potential impacts to the town's drinking water supply. I have not heard or seen anything from the town expressing similar concerns. I assume that you have familiarity with the source of the town's drinking water supply. So just want to confirm that the town does not have concerns about potential impacts to the drinking water supply.
I mean, we're concerned about the quantity and quality of our water regionally, but no, the town does not utilize groundwater sources for its drinking water. We were one of the original signatories on the Big Thompson project. A good chunk of our drinking water comes from essentially Rocky Mountain National Park via the reservoir just outside of Loveland. We are in the works to employ some shallow alluvial wells within the Boulder Creek flow to pull some of the subterranean water out of Boulder Creek to add to our drinking water supply. But that's, I'm going to say 6 miles from this location. And obviously that would be a catastrophic spill. So no, the town is quite secure that our drinking water and our water quality that we provide to our residents wouldn't be impacted.
Thank you. And then my last question is turning back to those 72 homes that are planned within 2,000 feet, but not yet constructed. I think I'll save one of my questions for the Southern Land Company, but I guess my question for the town is there something in your process when those homes are sold that indicates to a potential purchaser proximity to this location?
Our current
About
code
the
certainly
location?
has, yeah, our current code certainly has notification provisions. I think it has to be in excess of 30 days before closing, because that's not the sort of thing that you want to. I mean, we've all closed on, those of us that have closed on a house, you're just handed a huge stack of papers, and that's not really the time to do this sort of due diligence. But Southern Land Company has very graciously agreed to provide ample notification. It's clearly spelled out on the Westerly Development website, not only the Draco location, but other nearby oil and gas infrastructure, including the liquid handling hub and other well pads. So again, props to Southern Land going above and beyond and making sure that residents moving into their new homes are well aware.
Okay, thank you. That's all my questions.
Other questions for Mr. Frank? Commissioner Cross?
Thank you, Mr. Chair, and thank you, Mr. Frank. I just wanted to ask kind of a more 50,000 foot question. I know we've talked about some of the vertical wells that the town has expressed concern over, some of the residents have expressed concern over. Can you give us an idea of the number of horizontal wells that are under the town of Erie?
The whole town?
Yeah. Do you have an idea of how many there are, and have you had some concerns with them with respect to fracking?
I can pull up your GIS page. It's a huge chunk of the town. Yeah, has been horizontally drilled under and fracked, including my home in Old Town. Basically the entire eastern half, I would say. Everyone outside of Boulder County has had the minerals under their home produced. Since I've been working for the town, we've had 2 OGDPs come before my desk. There was Costlet East about 2 years ago, and now Draco. The Costlet East, though the production facility was just outside of Erie, the drilling and spacing unit was actually mostly in Broomfield, and so I didn't do a thorough review of the old verticals in that area. So, had I been doing this job for the last 20 years, absolutely, tons of concern. But this is really the first time I've been in the capacity to raise that concern.
Okay, I appreciate it. That's my only question. Thank you.
Other final questions? Really appreciate you being with us, Mr. Frank.
Oh, my pleasure.
And you too, Mr. Maxey. All right, seeing no further questions, I think what we'll do is take a lunch break, and then we'll come back to hear from Southern Land and the applicant. It's 12:30. Let's return at 1:15, say 45 minutes. All right, welcome back. This is the Energy and Carbon Management Commission. It is 1:15 on November 13th. We're taking docket 2401-0004, oil and gas development plan entitled the Draco by applicant Extraction. We've had public comment. We've had comment from Weld County. We've had comment from Erie, and I believe next on the agenda is a presentation from the Southern Land Company. So whomever is doing that, go ahead and visualize yourselves, and we'll hear from you.
Thank you, Commissioner Robbins, and thank you, commissioners. I really appreciate getting the opportunity to be here today to speak to you all. My name is Heidi Majerick. I am a vice president and general manager with the Southern Land Company. I have been a longtime master plan community developer in Metro Denver. I had the privilege of working for Forest City on the redevelopment of Denver's former airport, Stapleton, now known as Central Park, for 15 years of my career. And I've now had the honor and privilege of working for the Southern Land Company, developing our master plan community Westerly for the Southern Land Company for the last 6 years, and I've also had the honor of working with the town of Erie to bring this community to life. And so I just wanted to, before I get into my official presentation, wanted to take a moment to respond to the comments I heard from Mr. Maxey. And just wanted to let you know that we did provide written comment to Weld County. I'm going to take some ownership that I'm learning these processes with Weld County and with the state, and that, you know, we are real estate developers. That's our area of expertise. Oil and gas permit processes is not our area of expertise. So I thought by providing written comment to Weld County, I was participating in that hearing. So, and, you know, just you heard that the time frame for when that permit was received to when it was heard was about 2 months. And so while our comments did not change, they did expand. And that, you know, it took us a little bit of time to get the right team in place to gear up to really digest an application of this nature. So we'll, you know, own that a little bit slow getting to full understanding of the application. I do want to let you know that amongst that team that we got put in place, and that we're working with now, you know, we have air quality specialists, engineers, and then we do have 2 attorneys with us in this hearing today, in case you have questions for them. We have Holland Hart, Allison Alteris, and then we to build the team and find specialists in oil and gas. So we have Howard Boygan on our team. He's here today, which I think some of you know. And so they are available to speak to any questions. And I do want to thank this commission for your willingness to work with us in extraction and give us the time we needed to get to an agreement, a mitigation agreement that addresses the, you know, the concerns that we've had and our community has had. And just know that everything we've done has been in the best interests of our community and their health and safety. And so we thank you for giving us that time. And we thank Extraction for working diligently with us and negotiating with us in good faith to get to this point. They will be presenting in their presentation the mitigation agreement that we came to terms on with them, that we think, you know, it gives us the best possible outcome we can get in terms of mitigating impacts of these wells to the community. And so we are asking that you include Exhibit A in their permit, and they will speak to that as well. So is it all right if I share my screen? Because I just wanted to throw up a map that I think will address, that'll help with some of the questions I heard.
Yeah, we do lots of screen sharing. Go for it.
Okay, so here we go. Can y'all see that?
Yes.
Okay. So I want to talk overview a little bit of Westerly, the community we've been talking about. So this is an 800-acre master plan that's mixed use, walkable, high quality architecture, landscaping, extensive community programming, and exceptional amenities. At build out will be 3,000 homes, 400 apartments, and 200,000 square feet of commercial development. What you're looking at right now is just the southern 400 acres. So this is Erie Parkway, County Road 7, County Road 5, County Road 6, and this is the proposed Draco working pad site. And the other 400 acres is north of Erie Parkway. So I just kind of zoomed in for you here. And where we have started construction is in this area right here. This is where we're working. And so just forgive me, I'll come back to it in a minute. I just wanted to go through just a few other details for you. We acquired this land in 2017. We've been actively developing ever since. We have had experience with the oil and gas companies negotiating relinquishment of surface rights and plugging and abandonment of wells. You know, we've heard loud and clear everybody's concerns. So we have gone above and beyond what we see in our profession from other communities in our efforts to negotiate no future drilling sites within our community. So we spent several years and over $1 million to assure that the mineral rights owners would never drill any wells within the boundaries of Westerly and would plug and abandon our 2 wells. There are 2 historic wells, and they've both been plugged and abandoned. So, we've heard that. We're doing everything we possibly can in our power on our property to protect our homeowners. And as I said, this is where we've been building out. We have about 100 homes occupied right up in this area. Inside this black line, that's our first filing. That's about 300 homes. All of that infrastructure is on the ground. So like I said, 100 homes occupied, over 50 homes are underway. We have probably over 250 residents, and this is our amenity center, our $8 million amenity center that just opened last month. We also have all the infrastructure for filing 2 on the ground, which is this area here. That's another 200 lots. And then our third final plat, which is what you heard Mr. Frank talk about, that is within this blue boundary. That's our third final plat. We are currently just started infrastructure construction on this block, these 2 blocks, and this block. So you can see from this map, this is the line. That's the 2,000-foot impact. And so everything that's in blue, those were kind of those 70 lots you were hearing about. Those are the ones that we made agreement with the town to do voluntary compliance with their 2,000-foot setback. Because like the town, we don't want to have any homes occupied within that 2,000-foot setback. And this is why the 3-year dialogue starts to become really important. And that we even though we could have said to the town, yeah, we don't want to agree to that. We want to go to hearing because we have rights. We didn't want to do that. We don't want those residents inside that 2,000 feet. But you can see where our development is. We're coming right up to it. So that 3 years kind of our time frame of how much buffer we can give off of this site and the development needs of the community. So I just want to give you a little context to why that 3 years is important. And then filing 4 is everything over here, basically. That's all filing 4, which includes these lots impacted in the red. And when you look at the highlighted areas that are outside the line, that's because there's infrastructure implications as well. Everything's kind of connected, like all our water, sewer, roads. So, we can't really build the rest of this block, right, without this road and this infrastructure. And then the school site you heard being talked about is right here. We are obligated by our annexation agreement with the town to provide this school site to St. Vrain Valley School District. And we are currently working on a minor subdivision of this school site, which by the town of Erie, you need a subdivision plat to convey. You can't convey with meets and bounds. So we have to get that minor subdivision approved to be able to meet our obligations to the town of Erie under our annexation agreement, which is to provide this school site to St. Vrain Valley School District. And I do just want to note that with all of these applications that you're hearing about, final plats, minor subdivisions, Weld County is that Mr. Maxey was talking about, that was in process when Weld County had their hearing. But it was not, as he said, it was not approved till after that hearing. But just know that our entitlement process prior to that is annexation, rezoning, preliminary plat, and then final plat. So we have been in process for years and years and years leading up to this approval of a filing 3 plat just after that hearing occurred. And so, like I said, we've obviously had concerns with this pad site, and we've worked diligently, as has Extraction, to mitigate those impacts. And like I said, Extraction will talk to that, but just really quickly want to go through those with you. They include that 3-year time frame, which quickly the details of that is 3 years from whenever their drill ready permit is in hand and pooling because of the new legislation we've had regarding pooling. So it's 3 years from mid-May of next year, giving them time to get pooling orders in place and get their permit ready. 3 years from that time frame, from May of next year, or if they get pooling and their permit earlier, then it'd be 3 years from that earlier date. Some pretty stringent air monitoring requirements. The site is adjacent to what is regional open space for the town of Erie. I think you saw some of their comments on that. So we agreed with those comments. So Extractions agreed to enhanced landscape buffering. And then also County Road 6 is not paved. And so they have agreed to pave that to protect our residents' HOA from having impacts from any kind of sediment that comes off that dirt road into the community's drainage system. And then routine meetings between SLC and Extraction to share information while they're working on, their drilling. And so the details of that, I believe, are in your packet. I have both of our attorneys are happy to speak to the details of that if you have questions about detail, as well as I'm sure Extraction. And, we respectfully request that you adopt these terms of the mitigation agreement as conditions in Extraction's permit as BMPs. We're all here available to answer your questions. And again, thank you all for supporting us in our efforts to protect our community and giving us that time that was necessary to negotiate with Extraction to try and protect our community. So thank you.
Okay, thank you very much for the presentation. Ms. Alturas or Mr. Borgen, did you want to add anything at this point?
I have nothing further to add, Chair. We appreciate the opportunity to present. We're just here to answer questions about the agreement that we've entered into with Extraction. I guess I would like to echo Ms. Majerik's comments about our appreciation for Extraction. Extraction's willingness to address our concerns and to enter into the agreement that we've reached with them. It was interesting to talk with them about the impact of the new pooling statute, which was my first encounter with the potential implications. And so that's kind of a twist on this situation that we all had to come to terms with. It does inject an element of uncertainty into timing, but we appreciated Extraction's willingness to agree to the concept of having a hard deadline on getting wells drilled and completed. That's a tough ask of an operator, but they're willing to do it, and so that helped us really get over the hump here.
And Mr. Borgen or Ms. Majerik, talk to me a little more about the pooling piece and the uncertainties that brings in. And is it your position that the time frame would run 3 years from the date of receiving pooling or May of 2025, whichever is sooner?
Yeah, I mean, our initial request was that the clock start when the 2A is approved. And that was of concern to Extraction because of the new statute that said they can't commence drilling until pooling is completed. And so they could have their 2A and still be sort of stuck in the mud for some indefinite period until pooling is done, even though I think they don't anticipate any significant issues with pooling, but it's a time-consuming process and stuff happens. So we had discussions around that, and we agreed to give them some flexibility on having a sufficient time to get pooling done, but we wanted an absolute cutoff date. So they did agree to that, so that the clock would start basically 6 months from now, regardless whether they've finished getting their pooling done or not. So that at that point, it's their risk. It's on them to get it all done, but the 3-year clock is running.
All right. Excuse me. So the panel is open for further questions from commissioners if anyone has questions. Commissioner Messner?
Thank you. And thank you for being here. Appreciate you sharing the information that you did. I have a few questions. First question is regarding the open space that's a buffer here. What's anticipated to go in that open space? I mean, is it truly open space, but is it trails? Is it playgrounds? Is it, what type of open space is that?
Sorry, Commissioner, when I shared my screen, I could no longer find my unmute button. So apologies for that. It is everything that you just said. The open space is trails. It's it's all kinds of landscaping and the town of Erie's ethic for open space is that it's a reclamation of the High Plains Prairie. So the landscape is going to be a lot of the High Plains Prairie, and we're underway on that right now. Something that's important to point out about that trail, let me just see if I can get this back up. Hold on. Okay, it looks, oh, there it is. Hold on, sorry. Okay. So this trail system, what's of note is it comes through this is a regional trail. So this comes through the community and goes under. This is a pedestrian underpass that we'll be building under Erie Parkway and continues on north. So the negotiation with the town over the annexation of this property, this was extremely important to them. Number one, that we protect this ridgeline. Number two, that we get this big regional trail system under this and build this underpass to build out their trail system. And then I'll just note that the proximity of this 10-acre park, neighborhood park, that'll be more highly programmed. That'll be sports fields and active recreation, playgrounds, all of those sorts of things.
And so some of these areas are certainly being contemplated as, I guess, areas where people would concentrate.
Yes.
Okay.
Yes, it's a regional trail, right?
Yeah.
So they'll be moving through the space. And then this is the more active area. This part of the open space is more passive with just, the regional trail. And this is the more active part of the open space system.
Okay. And will that development of that area, is that not planned to occur until after, I don't remember the date for the town, it's October something, 2000?
Of 2020, yeah, 2027. Yeah. So yeah. This piece of the open space right here is under development. We have all of this trail already in. As a part of the approval of our first neighborhood, we're required to provide open space to the town as we go. And so it's not phased. We're already under construction on this because it is a reclamation project to rebuild the High Prairie. It'll take us a couple of years to really finish that space out, but the trail is in through this section right here. It is not in here yet. This is future.
Okay. And I guess I'm really, I think, more curious about the areas where you see concentrations of people, right? So whether that's the ball fields or the playgrounds or things like that, would that be able to be occupied before October of 27?
So this neighborhood park, I would have to defer to the town as to whether they would allow.
And I'm not asking because I just kind of trying to get the lay of the land, right? So I'm not saying it should or it shouldn't. I'm just asking whether it's just so I better understand the lay of the land.
I mean, our preference would not to have people, aggregating in that neighborhood park until we hit that 3-year time frame. But technically, by town's code. Could they be? I'd have to, I'm sorry, I can't answer that. I'd have to defer to the town.
That's okay. And then the school site. Help me understand. You were required to provide the school site because of town code or the size of your development. Is that right?
That's correct. So
Yeah.
development needs to pay for its own way, which includes expansion of educational systems that are necessary to support the residents. And so there's St. Vrain Valley School District has an IGA with the town of Erie that allows for one of two things, either a land dedication or cash fee in lieu. In this instance, both the school district and the town were wanting land, and this is a specific location for that school that has been in the town's guiding plan documents, their comprehensive plan and other types of plan guidance that they have. That this, even before the company I work for purchased this land, even before we purchased it, this was always contemplated in the town's plans as a future school site.
Good. That's good to know. Thank you. And then you have been in this process since 2017, I think, and so it's been pretty well known. I mean, even if you didn't look at the comp plan, because you've been in the process and since 2017, and as you indicated, which is accurate, you've probably gone through, sketch plan and preliminary plans and final plans and platting and all the steps that you've taken, like as you've indicated. This has always been indicated as a school site through that whole process, has it?
That's correct. That's correct. The first action that we took as a company on this land, the first application, was an annexation for this. And in that annexation agreement, it shows the school site.
Okay. And how far away is that from the pad?
So that is, I'm going to estimate here. This is our 2,000 foot. And this is our 1,500 foot. So this is the 500 foot radius. This is the 2,000 foot radius. So, that's probably 12 to 1,500 feet.
Okay.
From here to here.
Thanks for that.
Sure.
Mr. Boygan, this is probably Commissioner Boygan, because once commissioner, always commissioner. I have a couple of questions for you about the agreement. I'm assuming, although I guess you should never assume, that the agreement would preclude multiple occupations to drill wells, or is this just talking about the first tranche? So let's say they go in and they drill their first tranche. They decide at some point in the future to occupy this site again and drill additional wells.
So I'll answer that in a couple of ways. Thank you for the question, Commissioner Messner. First is there is no preclusion. Let me back up. The agreement requires that they drill sequentially in batch drilling, that they drill their wells and then they complete their wells. So they're not going to leave the site with ducks, with uncompleted wells, come back at some later time. They have to do it all. They could, I suppose, drill and complete one batch of wells and come back and do another. Not sure that would be economically feasible, but they could theoretically do that. What we were concerned about was that they not be able to, if their permits ran out, apply for new permits, new Form 2s, to give them more time to come back and drill more wells. So it's a hard cap. If they don't get all their wells drilled and completed by the end of that 3-year period, they're done. They can't get relief, at least contractually, and they've agreed that they can't go back to the commission and try to get an extension or new permits to drill the wells, because Rule 311, I think it's 311, doesn't really put a firm deadline on drilling. It does say, the permit has a 3-year duration, But then if they drill at least one well, as I read it, one well on that site, then the location lasts as long as that well is there. And it's nothing to preclude them from going back to the commission and asking for new permits to drill more wells. And so there's not really a hard cap, a hard deadline on drilling and completing wells. And as far as the Erie setback is concerned, my understanding, reverse setback, my understanding is that it's tied to, as Mr. Frank said, putting the wells into production. So we required that the wells be drilled and completed within that 3-year period, so that the restrictions on occupancy of the affected lots would be lifted. So
Okay.
I don't know if that fully answers your question.
Yeah, and I didn't ask a question very clearly. The question really is, the applicant is asking for a certain number of wells in this OGDP. If they come in and they do 80% of the wells, your agreement in the way that you understand it would preclude them. I mean, they could come in 2 occupations within that 3-year time frame, but after that 3-year time frame, they're done. They can't come back even if they don't complete all of the wells prior to the end of the 3 years. Is that fair to say?
Yes.
Okay. All right. That's the way I understood it, but I'm also not a lawyer. So, Mr. Chair, I think those are my questions right now. Thank you.
Good questions. Thanks for the answers. Others with questions for the panel? All right, seeing no further questions, we'll let you go, but I'd rather you not leave completely. We may have more questions for you later on after we hear from the applicant. So if that's the case, you can unvisualize, but stick around.
Thank you, Chair Robbins. We will be here.
Thank you. Ms. Fulcher, do you want to raise your witnesses so that we can get them sworn in?
Yes, Chair, thank you very much. To the extraction panelists, you want to go ahead and visualize yourselves. And then I imagine Ms. Mercer will be here to swear you in.
Good afternoon to the panel. I believe most of you are familiar with the drill. We'll just go one by one, and I'll ask you to state your name and raise your right hand, state your name, and that you swear to tell the truth. I'll begin with Mr. Flanagan.
Tom Flanagan, I swear to tell the truth.
Thank you. Mr. Annable?
My name is Jeff Annable, and I swear to tell the truth.
Mr. Schleba?
Aaron Slaba, I swear to tell the truth.
Thank you, and apologies for mispronouncing your name yet again.
No problem at all.
Mr. Boiteau?
Ooh, you got it. Nice job. My name is Claude Boiteau. I swear to tell the truth.
Thank you. Mr. Bresnahan?
My name is Bob Bresnahan. I swear to tell the truth.
Thank you. Mr. Bennett?
Good afternoon, Nathan Bennett. I swear to tell the truth.
And Mr. Van Wyck?
Good afternoon. My name is Andy Van Wyck, and I swear to tell the truth.
Thank you.
All right, Ms. Fulcher, the panel is yours.
Thank you very much, Chair. And we do have a presentation for you today, but before we share screen, I'm going to begin with some opening remarks, and we'll just keep the share screen off while I go through those. First of all, good afternoon again to the Commissioner, to the staff, and to members of the public. My name is Jill Fulcher. I'm a shareholder with Beatty and Wozniak, and with my colleague Ryan McKee, we represent Extraction Oil and Gas in docket 2401-00004, which, as you know, is the application for the Draco Oil and Gas Development Plan. Joining me today to present the application are Jeff Annable and Claude Boiteau. We also have a panel of experts here to answer your questions today. I do want to maybe say at the outset that our presentation is maybe a little bit lengthier than the customary oil and gas development plan. You've heard a lot from the public today. You've heard from local governments. You've heard from ELC. So we want to make sure that we are providing you with a very comprehensive presentation today and addressing some of what you've heard in our response. And hopefully that also answers some of your questions. Sustainability, safety, innovation, integrity, and community focus are the 5 core values that guide Civitas and its subsidiaries in its business practices each day. With respect to sustainability, Civitas believes it is its responsibility to implement and follow aggressive sustainability protocols that protect air, water, land, wildlife, and the communities in which Civitas lives and works. At Civitas, safety is valued above all else, and an unwavering commitment to safety and the well-being of Civitas's employees and communities are at the core of every decision and action. By valuing innovation, Civitas continuously seeks and implements state-of-the-art practices for the safest, most sustainable, and most efficient operations. And finally, operating with integrity and listening to community voices, finding solutions, and working closely with stakeholders helps Civitas plan business in a manner that ensures its neighboring communities thrive. So these are the core values of Civitas and its subsidiary companies like Extraction. Like Civitas, the Commission has its own core values as defined by statute that guide you in making decisions on whether to approve oil and gas development plans. And those can be found in what is often known as the mitigation hierarchy, referenced first in section 3460, 103, 26 A and B of the Colorado Revised Statutes. And under this hierarchy, the Commission understands that minimizing adverse impacts means, to the extent necessary and reasonable to protect public health, safety, welfare, the environment, and wildlife resources, to avoid adverse impacts from energy and carbon management operations, and minimize and mitigate the extent and severity of those impacts that cannot be avoided. The record before you and the presentation today will show that both Civitas's core values and the ECMC's mitigation hierarchy are accomplished through approval of the Draco OGDP. The Draco OGDP requests approval of a single oil and gas location located in and approved by Weld County for the drilling of up to 26 horizontal wells in a 3,931 acre drilling and spacing unit. The Draco pad is sited as far as possible from residential building units, is outside of high priority habitat, avoids all disproportionately impacted communities, and is more than 4,400 feet from any high occupancy building units, schools, or designated outside activity areas as defined in your rules. The wells proposed under the OGDP demonstrate Civitas's commitment to innovation and sustainability by unlocking almost 4,000 acres of minerals for development while significantly reducing surface impacts through best-in-class pad and facility design. What you'll hear today is that following interim reclamation, the Draco pad will be limited to just 5.24 acres of surface disturbance. This represents 0.001% surface disturbance over the minerals being developed. All production equipment will be electrified through highline utility power, and all oil, gas, and water will be piped from location, eliminating thousands of truck trips, which will significantly reduce air emissions and evidences Civitas's goal of sustainable operations. The Draco pad also meets ECMC's mitigation hierarchy by avoiding impacts to wildlife and disproportionately impacted communities, and minimizing the extent and severity of impacts to relevant and surrounding communities through the design of the smallest single surface disturbance possible for development of 4,000 acres of minerals. Civitas understands that pre-production activities can be disruptive to communities. To minimize pre-production impacts to residents and communities around the Draco pad, Civitas is committed to aggressive protocols, and some of those that you'll hear include using utility-powered electric drilling rigs. This will drastically reduce air emissions. Planning the use of 2 drilling rigs at the location to cut drill time. Using 640 feet of existing access roads to eliminate construction and land disturbance. Using Tier 4 equivalent or better engines during completions, and we're very excited to announce today utilizing partial utility power for completions. This is another innovative first in Colorado and will result in at least 10% further reductions to air emissions from completions. These pre-production elements of the Draco OGDP not only demonstrate adherence to Civitas's core values, but work to minimize and mitigate the extent and severity of impacts to the public and environment in satisfaction of your mitigation hierarchy. Civitas has been engaged with all nearby residents to the Draco pad, the relevant and proximate local governments of Weld County and Erie, which we'll discuss, and the Erie Land Company, as you heard. And as you've heard today plenty about Erie Land Company is the developer of the Westerly community. Through this direct community engagement, the following has occurred. First, obtaining informed consent from all of the residents that are coming within 2,000 feet of the Draco working pad surface. Also committing to the requests of the town of Erie regarding soil gas surveys for 6 previously abandoned legacy wells, and we are going to make sure that the record's correct on that, because I think Mr. Frank said 7 and 6 are identified in his letter. Committing to notification and engagement with the town, conducting a transportation impact analysis, and paving relevant portions of County Road 6, as you heard from Mr. Frank. In addition to the commitments by Erie, we've been engaged for months now with the Southern Land Company or Erie Land Company, and we appreciate Ms. Madrick's comments here today. And we've agreed to additional measures with ELC to further minimize and mitigate impacts to the future Westerly residents. You're going to hear this multiple times throughout today's presentation, but to summarize some of those, we're committing to additional berms and fencing to minimize potential impacts to viewshed for future residents over and above existing topography, paving County Road 6 prior to the commencement of drilling operations, contributing to the cost of landscaping along that future Westerly walking trail. And that's going to further minimize impacts, not just from the Draco pad, which obviously not built yet, but also the existing landfill, the hub, and the existing pad that's out there already by another operator that will contribute to mitigation there. And then finally, and as you've heard already a little bit, establishing an aggressive deadline by which all wells on the Draco pad will be drilled, completed, and production equipment installed to ensure Civitas is in and out before the majority of those homes and residents are in existence. Again, especially part of those residents in the southern part of the development. These additional commitments to stakeholders demonstrate Civitas's goal of operating with integrity and community focus, and also, again, evident satisfaction of your mitigation hierarchy. Approval of the Draco OGDP will also result in beneficial impacts to the public and environment. Among these include accelerated plugging, abandonment, and decommissioning of numerous wells and locations that are within the OGDP lands. Many of these, as you're going to hear, are very close to receptors. The removal of these legacy wells and locations will actually eliminate 4.86 tons per year of VOC emissions and 11.8 acres of land disturbance. So what you're going to hear is, in fact, approval of this OGDP will result in a net decrease of surface acreage used for oil and gas operations in these lands, as well as a net decrease in VOC emissions per year because of the decommissioning of those wells and locations. Extraction has tracked the written comments received from citizens throughout this process, as well as reviewed all of the comments that were made during the Rule 511 local meeting in Erie. And so our presentation today will aim to address those application-specific questions and concerns, including questions we've heard related to lateral length, offset well evaluation and safety, air emissions, and water use. And finally, from me, I want to note that the director has issued that recommendation for approval of the Draco OGDP, and that was issued on August 16th, finding that the OGDP complies with all applicable requirements of your rules and also recommending approval by the commission. We heard from Ms. Carroll today a comment that it was unfortunate that the Rule 511 hearing came after the director's recommendation, as perhaps the director would have altered the recommendation in light of the Rule 511 comment. I don't want to speculate on that point, but I do want to point out for the record that the Rule 511 request was submitted by Flatirons after the director issued the recommendation, so that really wouldn't have been a reality here anyway. And also there were 75 or upwards of 75 public comments filed prior to the issuance of the director's recommendation. Many of those comments were related to the same concerns that we did here as part of the Rule 511 hearing, and those were addressed by Extraction and also considered by staff prior to the issuance of the recommendation. We want to thank Weld County and Erie for its participation today, and ELC for its comments. And especially I want to thank Mr. Maxey for the time that he took to review Weld County's WOGLA process. So with that, I think we'll hand it over to Mr. Annabelle to walk us through the presentation And Ryan, I think you can go ahead and start sharing screen. Thank you.
Thank you, Jill. Good afternoon, Commissioners. I appreciate your time and attention as we present our Draco OGDP. I'm Jeff Annable, Manager of Well and Location Permitting at Civitas Resources, parent company of Extraction Oil and Gas. Next slide. Today we'll cover the following key topics: Draco OGDP general location, procedural background, relevant local government disposition, and alternative location analysis. Then we'll jump into development plan timeline, cumulative impact mitigation and beneficial impacts. From there, we'll address public comment and conclude with a summary and request for approval. Next slide. I will be joined by Claude Boiteau, Asset Development Engineer. We will also have the listed experts available for any questions you might have after the presentation. Next slide. The Draco OGDP consists of one new oil and gas location, the Draco Pad, which is located in the northeast quarter of the southeast quarter of Section 21, Township 1 North, Range 68 West, and adjacent to County Road 7 and County Road 6. The relevant local government, Weld County, has approved the 1041 WOGLA for this location. This location is proximate to the town of Erie, and the working pad surfaces within 2,000 feet of 5 residential building units, the closest being 1,011 feet away. All 5 of these RBUs have signed informed consents. One ALA criteria is triggered as a part of the location siting. Criteria number 1, a residential building unit is less than 2,000 feet from working pad surface. The OGDP covers a total of 3,951.25 acres, which includes a surface location and one new spacing unit containing 3,931.8 acres. This spacing unit will be developed by 26 wells. The project received extensive public comment that we are prepared to address later in our slideshow. Next slide. Next, I would like to cover the procedural background for the Draco OGDP. Before you is a list of regulatory milestones that we have completed thus far. The OGDP was filed on January 4th of 2024. Shortly after, on February 29th, we received local approval of the project. Completeness was determined on June 18th, and the hearing was scheduled for August 28th. Public comment period ended July 19th, followed by the petition deadline on July 29th. 2 petitions were filed, both of which have since been withdrawn. The project then received a 511 public hearing request on August 15th. Shortly after, the director issued a recommendation of approval on August 16th. The public hearing request was heard on September 3rd, which was granted and resulted in a public meeting with commissioners on October 29th. All of this resulted in a final hearing date of November 13th. Next slide. Next, I would like to briefly cover the relevant local government process. On August 30th, 2023, a pre-application consultation was held with Weld County, which was attended by ECMC staff and the town of Erie. Boulder County, BLM, CDPHE were invited and did not attend. On February 29th, the 1041 WOGLA permit hearing was held. No applications for intervention were filed as a part of this process. During the consultation, the following concerns were raised: a suggestion to use County Road 6 for drill cuttings as it was the most direct route, which should ultimately be paved to reduce dust concerns. The development timeline related to the offset town of Erie development, and a road maintenance agreement with the town of Erie for their use of their roads. These concerns resulted in the hearing officer adding an order to work with offset developer and the town of Erie on landscaping options and haul routes. The discussion that occurred both before and after this hearing will be covered in subsequent slides. Next slide. Next, I would like to go over the alternative location analysis. Next slide. Before you is an overview of the 4 alternative locations, the proposed Draco pad, and the mineral development area. Next slide. Now let's take a closer look at alternative locations 1 and 2. Alternative location 1, depicted on the left-hand side of the screen, is situated north of the proposed pad and was ultimately not pursued for 3 key reasons. There are 28 residential building units within 2,000-foot radius. It would be in closer proximity to a school, and it would require an additional location to achieve full mineral development. Now moving on to location number 2, depicted on the right-hand side of the screen. This would be an expansion of an existing location south of the proposed pad. However, we decided not to pursue this option for two primary reasons. The proposed location has fewer RBUs in its vicinity, as well as this location would require an additional location to achieve full mineral development. Next slide. Now let's examine alternative locations 3 and 4 in more detail. Alternative location 3, depicted on the left-hand side of the screen, is situated west of the proposed pad. Location was not pursued due to its proximity to a substantial number of receptors within a 2,000-foot radius, which includes 266 residential building units, 1 high occupancy building unit, 2 school properties, and 1 school facility. Next, let's look at alternative location number 4, depicted on the right-hand side of the screen. This alternative is located southwest of the proposed pad. There was substantial dialogue and coordination regarding this location with the town of Erie, but the site was not pursued for 3 main reasons. There was no clear line of sight to obtain permit from the relevant local government, including a heavy industrial rezoning application of property adjacent to residential zoning. When asked if they could provide standards for a heavy industrial rezoning application, they said they did not have any. Further, Erie's Unified Development Code is silent on any and all zoning criteria, including but not limited to setbacks, district dimensional standards, lot standards, and use-specific standards. In addition to this, there's a much higher concentration of existing homes within a 2,500-foot radius than the proposed location. There are mapped wetlands immediately adjacent to this proposed alternative. And finally, there was an additional environmental concern as there was industrial waste dumped that has since been remediated but is in monitor status, which would have been adjacent to the proposed location. Next slide. In addition to the 4 alternative locations identified, extraction search for viable alternatives contained within the town of Erie and Boulder County. Our search for viable alternatives faced significant challenges due to restrictions on oil and gas development from these local governments. In Boulder County, we encountered 2 main obstacles. Locations are not permissible within 2,000 feet of a residential building unit, and oil and gas development is not allowed on county-owned land. As for the town of Erie, we face different constraints. Firstly, as I mentioned earlier, the town requires locations to be on properties zoned as heavy industrial, but no such properties exist within the town limits. Secondly, the town prohibits siting within 2,000 feet of any property containing a residential building unit. These regulatory restrictions in both of these jurisdictions effectively eliminated all potentially technically feasible alternatives in both areas. Now, I'd like to hand the presentation over to Claude Boiteau, Asset Development Engineer.
Thank you, Jeff, and thank you, Commissioners. Good afternoon. I'm Claude Boiteau, an Asset Development Engineer with Civitas Resources. I'd now like to review the community outreach and coordination that has occurred associated with the Draco OGDP. Extraction pursued a robust notification and engagement effort associated with the Draco development. As part of the 1041 WOGLA process, notice was provided to all surface owners within 2,000 feet of the proposed disturbance area. Residential building unit owners located within 2,000 feet of the working pad surface were personally contacted. This process resulted in the universal acquisition of informed consents. Additionally, Extraction established and has maintained an informational Draco OGDP website. The website has been provided to Weld County, the town of Erie, to the Erie Land Company, and individuals who contacted Extraction. Thank you. Communication with the town of Erie has been extensive and ongoing. For the benefit and consideration of the Commission, I would like to provide this engagement history with the town. These communications, which began early in our development process, represent a robust level of engagement and have been regularly occurring for multiple years. As reflected here, the town has been provided with extensive opportunity to understand and discuss Extraction's development plans as they were modified, and refined. These conversations provided notice of what is now called the Draco development and included extensive discussion of the surface location described by Mr. Annable as alternative location number 4. Extraction provided the town with potential transportation routes, discussed possible well abandonments, reviewed best management practices, and hosted the town representatives on field tours of existing sites to demonstrate how the described operational advancements are put into practice in a post-production environment. Extraction anticipates continued engagement with the town during pre-production activities of the Draco development and has committed to a recurring meeting schedule to ensure optimal collaboration and continued information sharing. Next slide, please. Thank you. More recently, and as a requirement of the 1041 WOGL process, Extraction has coordinated with the town to address ongoing development-related concerns associated with the proposed Draco development. As a result of these communications, Extraction is proud to report that it has committed to provide recurring project updates with the town, conduct a soil gas survey program for select previously abandoned legacy wells, complete a transportation impact analysis to be finalized prior to commencement of construction activities, and to facilitate the paving of the unpaved portion of County Road 6, which, as you have previously heard, has been a direct ask made by the town. Community engagement has not been limited to the town of Erie. The westerly development, as the commission is likely aware, is being constructed to the north and west of the proposed Draco development. During pre-production operations, all ongoing construction will be greater than 2,500 feet from the working pad surface. In fact, the anticipated Draco development timing will ensure that no home construction occurs within 2,000 feet of the working pad surface until after pre-production activities have concluded. Concurrent with the OGDP permitting process, Extraction has engaged in extensive conversations with the development entity Southern Land Company, known locally as the Erie Land Company, regarding the ongoing westerly community development. Through these collaborative engagements, Erie Land Company has requested and Extraction has delivered a suite of additional best management practices. We are pleased to share these BMPs with the Commission and are requesting that the Commission incorporate them as conditions of approval to benefit future residents of the westerly community. I will now discuss these BMPs in greater detail. To ensure that the existing construction is not impacted by pre-production operations, Extraction is committed to utilize 3 continuous ambient air monitors around the Draco pad. These monitors will be maintained throughout the early and pre-production activities. Monitoring results will be submitted monthly to CDPHE. Extraction commits to work with CDPHE to incorporate appropriate operational changes if emission readings indicate the detection of elevated VOCs. Additional air monitoring technology will be discussed in later slides. Sightlines to the Draco facility will be mitigated by the construction of a soil berm around the north and west boundaries of the working pad surface. As a result of discussions with the Erie Land Company, Extraction is committed to increase the size and footprint of the berms to improve the shielding of post-production equipment. This modification will be highlighted in a future slide. Berm construction combined with a planned privacy fence will provide effective viewshed mitigation of future post-production equipment. The location layout depicted on the left, in the left image, highlights the previous soil berm design, while the location layout on the right depicts the updated soil berm design stemming from our engagement with the Erie Land Company. Please note the increased footprint and height of the planned berms. Next slide, please. Thank you. Extraction is committed to pave the unpaved section of County Road 6, connecting County Road 7 with County Road 5. The paving of County Road 6 will improve a substandard section of local roadway infrastructure, removing existing sources of stormwater contamination, and will provide long-term benefit to future westerly residents as well as existing regional residents and businesses. Extraction is excited to provide this community benefit as part of the Draco development and credits the Erie Land Company for the inclusion of this BMP as an aspect of the recently completed mitigation agreement. Extraction will facilitate the paving of County Road 6 prior to the commencement of drilling operations at the Draco pad and will only utilize County Road 6 and County Road 5 to haul drill cuttings during the drill phase of the planned operations. Next slide, please. Finally, Extraction has agreed to concrete development timing commitments to ensure that pre-production operations will be completed expeditiously prior to the most of the future construction and resident occupancy of the westerly community, especially prior to residents occupying homes planned for the southern portion of the development. Under ECMC's operative permit expiration rules, wells can be drilled from a pad beyond the 3-year term of the Form 2A. The well completions deadline agreed to by Extraction aggressively limits the window of time for which drilling and completions will occur on the Draco pad. Specifically, the timing commitment provides that all wells in the Draco pad will be completed, including hydraulic fracturing and the installation of production wellhead equipment, no later than 36 months from the date on which the OGDP, Form 2A, and Form 2s have been approved by the ECMC, and all other orders related to pooling, if necessary, are entered, or 36 months from May 13th, 2025, whichever occurs first. While we are aware of the town of Erie's request for a more restrictive development timeline, I would like to note that Extraction and ELC worked closely on this language to ensure that it provided a meaningful endpoint to drilling and completion operations for the benefit of future Westerly residents, but also provided Extraction with the time necessary to obtain other regulatory approvals, including Form 2s, APDs, and time to safely and effectively deploy all agreed upon mitigation measures and drilling completions safety parameters. Next slide, please. Thank you. Now, for the benefit and consideration of the commission, I would like to share a viewshed animation that highlights the existing topographical benefits. Oh, hold on a second, Ryan, if you don't mind. Thank you. Start her over. Thanks. That highlights the existing topographical benefits of the proposed Draco development location. We're excited about this, so I can see why you wanted to roll it fast. Please play the animation, Ryan. Thank you. The viewpoint originates to the northwest of the Draco development near the previously discussed Westerly development and proceeds southeast towards Draco. You'll immediately notice the large topographical relief shielding most of the Westerly development from the Draco location. As the viewpoint crests the nearby rise, you'll initially notice Creststone's existing gathering hub. As we move closer to the Draco pad, the screening berms come into view. You'll note the limited sight lines to the planned Draco facility equipment. Please pause, Ryan. Thank you very much. As the view shifts to the southwest, Oxy's existing windsock facility and associated wellheads come into view, framed by the Front Range landfill rising in the background. Each location labeled in this animation currently exists near the proposed Draco location. Please continue the animation, Ryan. Thank you. The view now shifts to the west. Begins to gain elevation, providing an enhanced view of the elaborate soil berms planned for the site. The final berms will incorporate an 8-foot chain link privacy fence that is not included in this animation. The view now shifts to the east and begins to recede to the west towards County Road 5. As the viewpoint gains distance from the Draco location, you'll notice that the planned soil berms shield nearly all sightlines to the Draco facility. The animation ends at County Road 5, near the southernmost extent of the future Westerly community. The proposed Draco development is located to maximize the benefits of existing topographical relief. Combined with the planned soil berms on the north and west side of the working pad surface, sightlines to the Draco facility are effectively mitigated. Thank you, Ryan. Next slide, please. I'd now like to review the anticipated Draco development timing. Next slide. Thanks. Pad construction is anticipated to commence in March 2025. The dual occupation electrified drilling rig deployment will commence in April of the same year, followed by completion activities later that year. The wells are anticipated to be open to the facility in early 2026, with reclamation activities to follow later that spring. I'll now hand the presentation back to Mr. Annable to discuss cumulative impacts and additional best management practices.
Thank you, Claude. Next, I am excited to present the amazing cumulative impact mitigation best management practices that we will employ during our operations. Next slide. First, I would like to cover location, siting, construction cumulative impact mitigation that follows a three-pronged strategy: avoid, minimize, mitigate. Let's discuss our avoidance measures. We have cited our location to be outside of high priority habitat areas and greater than 1 mile from the nearest disproportionately impacted community. Moving on to minimization efforts, we strategically positioned our site to be over 1,000 feet from the nearest residential building unit and more than 4,400 feet from the closest high occupancy building unit, school, or designated outdoor activity area. This careful siting also enables us to utilize 640 feet of existing access road and connect to a three-phase takeaway, allowing for a tankless design, significantly minimizing surface disturbance. And finally, the mitigation strategies listed below allow us to further mitigate potential impacts to soil resources and receptors, both existing and future. Next slide. Now let's delve into our cumulative impact mitigation measures for drilling phase. We've implemented several key strategies to minimize and mitigate potential impacts. Starting with our minimization efforts. Firstly, we've committed to using a utility-powered electric drilling rig or rigs. Secondly, if available, we will employ 2 drilling rigs simultaneously at the location, substantially reducing the overall time required to drill all proposed wells. Lastly, we've committed to using the use of Group 3 drilling mud, minimizing the possibility for potential odor impacts. On top of these minimization commitments, you can see our mitigation strategies that we will employ during drilling operations, further mitigating potential for impacts during the drilling phase. Next slide. Now let's turn our attention to the completion phase, where we've implemented several innovative strategies to minimize and mitigate cumulative impacts. In terms of minimization efforts, we are taking important steps to reduce truck traffic by installing temporary lay-flat water lines, and our commitment to air quality is evident in our commitment to utilizing Tier 4 equivalent engines or better and routing flowback through the permanent production equipment. Showcasing our dedication to reducing cumulative impacts regarding water sourcing, we're excited to announce that we'll be utilizing approximately 42,000 gallons of water, recycled water each day during completion operations. And in a groundbreaking initiative for the basin, we're introducing partial utility powered completions, which are expected to reduce emissions by approximately 10% during the completion phase. It is important to note that while we're enthusiastic about this commitment, it is essential to recognize that this best management practices relies on various factors for successful implementation and may not be feasible for every project. In addition to the minimization commitments, please see the mitigation strategies that we will employ during the completion phase, further mitigating the potential for impacts during completion. Next slide. Lastly, I'd like to highlight our cumulative impact mitigation strategies for the production phase, which demonstrates our long-term commitments. Let's start with our minimization efforts. We'll be installing both oil and produced water pipelines to the location prior to first production, which reduces air emissions associated with truck traffic, oil offloading, and storage tanks for both oil and produced water. During maintenance operations, we'll utilize a pressurized maintenance vessel, which eliminates gas that would otherwise be vented to the atmosphere, further reducing our emissions footprint. Next, I am very proud to commit to our cutting-edge 3-phase meter bulk separator facility design that allows us to drop our facility separator count from 26 to just 5. Substantially minimizing our physical footprint. Additionally, we will also be electrifying our permanent production facilities, further reducing emissions. Would also like to point out that as a result of leveraging drilling technology, our ratio of surface disturbance, permanent surface disturbance, to the mineral development area is remarkably low. We'll be using only 0.001 acres, or about 43 square feet, the average size of a bedroom, of surface area to develop 1 acre of mineral development area, greatly minimizing surface impacts. Now let's look at our mitigation strategies. Claude mentioned this earlier, but we're very mindful of visual impact. We'll construct a visual screening berm planted with native grasses. This will be complemented by an 8-foot tall chain link fence with privacy slats on the north and west sides of the site. This, combined with our capital contribution to the developer's landscaping, further minimizes visual impacts. These strategies for the production phase, combined with our pre-production commitments, underscore our unwavering commitment to responsible operations. Next slide. I touched on this briefly on the previous slide, but I wanted to show the impact of our updated facility design at the Draco pad. This commitment cuts our production emissions in half, as well as reduces the separator count 26-5. Next slide. Before we transition to discussing beneficial impacts, I'd like to highlight one final crucial commitment that Civitas is proud to implement. We're installing a state-of-the-art continuous leak detection system at this location. This advanced system utilizes a permanent optical gas imaging camera that performs a comprehensive inspection of the entire site every hour, 24 hours a day. Next slide. As you'll see, okay. Now I'm proud to showcase the beneficial impacts of this project that will undoubtedly change the landscape around hundreds of homes within the town of Erie. While there might be some temporary impacts while we perform the operations that generate these beneficial impacts, we're confident that these benefits will greatly benefit the community. Next slide. As a result of our development, we will be decommissioning 22 wells across 18 different locations. This is a significant step in reducing the overall footprint of oil and gas operations in the area. These reclamation operations will result in the removal of 24 oil tanks, 13 produced water tanks. This not only reduces surface disturbance, but also eliminates emissions from older vintage wells and facilities to the tune of 4.86 tons per year, contributing to improved air quality. Additionally, this will also result in a reduction of 2,652 annual vehicle trips, which significantly reduces traffic and emissions. Finally, if you take a closer look at the locations that will be reclaimed, we're going to be removing oil and gas wells at facilities that are in sensitive areas. 17 of the 18 locations are within 2,000 feet of a residential building unit. 14 of the 18 locations are within 2,000 feet of 10 or more residential building units. And finally, 6 of the 18 locations are within 2,000 feet of a school facility or property. In total, we'll be reclaiming approximately 11.8 acres of land. In summary, this project will reclaim 6.56 acres more land than what will be permanently disturbed at the Draco pad, and it will generate 3.82 fewer tons per year of VOC emissions than the sites reclaimed. Next slide. Now I'd like to provide a depiction of a few pads that will be reclaimed and the benefits that will result from the proposed decommissioning. First is the Young 523. As you can see on the map, this location is within 2,000 feet of 27 high occupancy building units, 491 residential building units, and Meadowlark Elementary School. Next slide. Next is the Young MC 26-5D. This location is within 2,000 feet of 61 high occupancy building units and 545 residential building units. Next slide. Our next decommissioned location will be the Coal Creek pad. This location has 2 wells and is within 2,000 feet of 67 high occupancy building units, 641 residential building units, Blue Mountain Montessori School, approximately 700 feet away, and the town of Erie outdoor recreation area. Next slide. The last location that I would like to cover is the Lummery pad, which has 4 wells and is within 2,000 feet of 21 high occupancy building units, 658 residential building units, and 2 schools, the Red Hawk Elementary School and the Erie Elementary School. Next slide. Extraction listened to the community regarding concerns about the impacts of the decommissioning operations. To address these issues, I'd like to outline our operational commitments regarding the legacy well abandonments. We will work closely with the town of Erie and any relevant local government to ensure that our planned operations are well coordinated. This includes holding a pre-abandonment kickoff meeting with the town of Erie, followed by quarterly meetings to discuss progress and coordinate ongoing activities related to the abandonments. Additionally, we will obtain all necessary municipal permits and arrange on-site meetings at each abandonment location with town staff to ensure potential impacts are being appropriately addressed. Now, I'd like to hand the presentation back over to Claude. Thanks.
Thank you, Jeff. And I'd like to provide additional Draco development details that are pertinent to public comment. Thank you. Common concern flagged during public comment was the anticipated lateral length at the Draco wells. Civitas and its family of companies have consistently demonstrated the ability to safely and efficiently extend drilled lateral lengths in the DJ Basin. Civitas companies were the first to drill 3 and 4 mile wells and to bring these wells online. Extended lateral length wellbores allow for consideration of surface locations further from neighborhoods and sensitive surface resources. The incorporation of extended lateral lengths in Colorado allows for increased mineral development in a manner that reduces surface impacts by locating pads further from neighborhoods and schools. Civitas has listened to our neighbors. These wellbore designs are a testament to that stakeholder engagement. Specific to the Draco development, I'd now like to share a simple comparative visualization of the planned Draco wellbores. For the Commission's benefit, please draw your attention to the blue and orange wellbore representations. The blue line is representative of the longest successfully drilled wellbore associated with Civitas developments in the Watkins operational area. The orange line is representative of the longest planned Draco wellbores. You'll note that the lateral portions of these wells are quite similar, with some of the Draco wellbores planned for a slightly greater total measured depth. While some of the Draco wellbores are planned to incorporate a slightly longer lateral, success in drilling and completing analog wells like the Watkins wells supports Extraction's drilling program in Draco. Existing drilling practices and technology support the wellbore designs contemplated by the Draco OGDP. I'll touch on these technologies and best practices in the next slides. Public comments also questioned the impact of the proposed new Draco wells on the existing wells within and adjacent to the proposed drilling and spacing unit. Existing offset well evaluation protocols provide multiple layers of protection to producing and legacy abandoned wellbores. Prior to planned operations and as part of the existing regulatory review process, Civitas reviews offset wellbores and well records within 2,000 feet of the proposed new wells. The result of these wellbore reviews are shared with the ECMC, who performs an independent review of offset wellbores and well records within 1,500 feet of the proposed new wells. The results of these wellbore reviews are correlated, and well improvements are dictated by the ECMC. These well improvements may include the upgrade of surface wellhead equipment at producing wells or the re-entry and re-abandonment of previously plugged legacy wells. The review of these offset wellbores provides important data points that are incorporated into the design of the proposed new wellbores. This offset well evaluation associated with the Draco development will be submitted to the ECMC as part of the Form 2. Extraction will comply with any requirements made by the ECMC that result from the review of the offset wellbore analysis. While offset wellbore reviews establish the condition and location of existing wellbores, standard drilling technology allows for their avoidance. Measure well drilling technology, known to the industry as MWD, allows for nearly real-time geospatial bit awareness. MWD technology provides the ability to incorporate minute, high-accuracy bit position adjustments to the drill string during the drilling process. The ability to adjust the path of the wellbore in nearly real time allows for a high level of consistent and reliable collision avoidance. Civitas has utilized this best-in-class drilling technology to successfully drill hundreds of wells in the DJ Basin. In fact, the Civitas family of companies has never collided with an offset wellbore. Next slide. Thank you. While MWD technology is utilized to control the path of the wellbore, standard measurable parameters are used to monitor and manage the operational integrity of the drilling process. Examples of these parameters include, but are not limited to, pump rate, weight on bit, and the rotational rate of the drill string. Drilling parameters are dictated by the capabilities of the drilling rig and supporting surface equipment and are considered the foundational components of a safe drilling program. Throughout the process of drilling a well, drilling parameters are monitored to ensure downhole and surface conditions remain within a safe and effective working tolerances for which they were designed. Established drilling parameter ranges are never exceeded and are consistent across all wellbore lateral lengths. These standard drilling parameters ensure that operational risks are controlled and mitigated. Next slide. Thank you. Concerns for legacy well abandonment and reclamation were frequently noted by commenters to the Draco development. The abandonment of legacy well infrastructure made possible by the development of the Draco OGDP will be planned in conjunction with the town of Erie or other appropriate municipal jurisdiction. Extraction will collaborate with the town and adhere to the municipal permitting requirements and regulatory oversight throughout operations and will provide timely notification to ensure that residents are aware of planned operations prior to their commencement. Extraction has successfully abandoned hundreds of legacy locations throughout the nearby neighborhoods without issue and is excited to remove additional offset infrastructure associated with Draco. Next slide. Thank you. Finally, commenters often noted the water usage associated with the proposed Draco development. Jeff mentioned this previously. As previously stated, Extraction is excited to commit to offsetting 42,000 gallons of daily water usage with recycled water during the completion operations phase. This water will be transported to location via pipeline from nearby existing infrastructure. Next slide. Thank you. Now I'll hand the presentation back to Ms. Fulcher to provide closing commentary.
Thank you very much, Claude, and thank you, commissioners, for your time today. Let's go to the next slide, please, Ryan. As we close our presentation, I want to first reiterate for the record the specific mitigation measures that we are requesting be made part of a final motion for approval today of the Draco OGDP. So those measures are contained on this slide and the one that follows. I won't walk you through them again, but I did want to just point out that they are here in slides 50 and 51. For ease of reference, whenever it comes time to make that motion. I do also want to let the commission know that Extraction did take the liberty of providing these specific measures to the OGLA staff, so that should you approve the application today with a motion that is conditioned on these measures being included in the final Form 2A, the staff does already have these in hand for hopefully a little bit easier incorporation to the final Form 2A. As you heard, these mitigation measures were drafted in consultation with Town of Erie and the Erie Land Company, respectively. And again, we very much believe that these are appropriate additional measures for the final Form 2A to further minimize and mitigate potential impacts to the public. And so let's go ahead and go to the next slide, please, Ryan. One more. We understand that significant attention has been given to the Draco OGDP, both from citizens of Erie, citizens several miles from the Draco pad, but near to the proposed drilling and spacing unit, and from members of the public that may reside further than the proposed operations, but are otherwise not supportive of oil and gas operations generally. We hope that this presentation has helped at least some members of the public understand what's before you and the myriad of ways that Civitas has worked to design a best-in-class development plan here. As you deliberate, we would ask that you objectively consider the plan and the record before you. This slide contains some of the examples of the ways in which the Draco pad, the Draco OGDP avoids, minimizes, and mitigates potential adverse impacts from oil and gas operations. Again, you heard the Draco pad will be just 5.24 acres of disturbance after interim reclamation, will actually disturb fewer acres than the total acreage currently being utilized for oil and gas operations in these lands today. This is also true for emissions, with fewer VOCs per year for the Draco OGDP than the VOCs associated with the legacy wells to be plugged and reclaimed here. In past years and past proceedings, a recurrent statement is often heard that operators should drill longer laterals to avoid or minimize surface impacts to citizens. The Draco OGDP is an example of putting this feedback into action and taking the learnings of all of Civitas' success with extended reach laterals, including the Watkins wells, which were successfully drilled to 29,000 feet of total measured depth, and deploying that drilling technology in this area with diverse land uses like this one. Next slide, please. As you deliberate on this docket, please remember a few key points on the Draco OGDP. First, it is recommended for approval by the director. It is also sitting here today uncontested, with the petitions of the Erie Land Company and Titan being resolved and withdrawn, and no petitions were ever filed against this application by any local government, including the town of Erie as a proximate local government. This application includes reasonable proposed conditions of approval to protect future residents of Westerly and the town of Erie, as I just described. And this application also includes robust protections to minimize and mitigate the extent and severity of potential impacts and satisfaction of the mitigation hierarchy. With that, we respectfully request approval of the Draco OGDP and the associated spacing application, subject to the mitigation measures agreed upon by ELC, the town of Erie, and extraction being included in the final Form 2A. Again, we very much thank you for your time today. We know this was a lengthier presentation. And with that, we can stop the share screen and we are available for questions. Thank you, commissioners.
All right. Thank you for the presentation. Why don't we catch our breath a bit and take a short break and then come back for questions to the panel. Let's return at 2:50. It's about 11 minutes out. All right, welcome back. Energy and Carbon Management Commission. It is 2:50, docket 2401, quadruple 04. And we have a panel available for questions from commissioners. Commissioners, who'd like to lead off with any questions? Commissioner Cross.
Thank you, Mr. Chair. Thank you for this presentation. I have a fair number of questions, and I'll say I think a good amount of my questions were at least preempted by the presentation, so I appreciate that. But I was hoping to go into some more detail for sure on some of them, and perhaps it's best to start with Mr. Boiteau, sorry, to talk about some of the latter discussions that you had specifically around the drilling, because obviously during the 511 hearing and within a lot of the public comment, there was a lot of issues raised on things like the lateral lengths, about fracking, potential striking of existing wells, et cetera. And so I'm hoping to go into a little bit more detail on those. The first is you went into a little bit of detail on the Watkins well that you have now, and it just being a little bit longer. Could you provide us a little bit more information on that well, where it is, the number of wells versus the number of wells you're proposing here, number of fracs, comparing the fracs, that kind of information?
Just to be clear of the question, you're asking for additional information on the wells that were drilled in Watkins pursuant to the questions you just asked.
Correct.
Okay, awesome. Thank you. I'll also note that we have Andy Van Wyk on the call as well. And this might be a better, at least to start the conversation for the well details, it might be better in his category. Andy,
Sure,
on the call?
to that, yep.
Awesome.
Yeah, thank you for the question. Last year, third quarter and fourth quarter, we drilled 13 total wells in that Watkins development, all with the 4-mile lateral length. I think the longest measured depth was maybe just shy of 29,000 feet, total measured depth.
Okay, and can you describe where the Watkins site is?
Generally speaking, I think my team could maybe give more specifics on township and range, but that area is roughly east of E470 and south of I-70.
So it's still within the DJ Basin.
Correct.
So it's not a completely different geology.
No, sir.
Can you give me an idea of the number of stages for fracs compared to what you're proposing here?
I don't have that information on hand. We would have to, if you gave me a moment, I could dig that up, maybe while you pursue other questions, but it would be very similar.
Yep.
As the slide that Claude put up showed, I mean, the rough difference in length of approximately 3,000 feet, I want to say would be ballpark 10 to 13 additional stages.
And with the location you mentioned by 470 and I-70 there, does the Watkins pad also go on near any properties?
I will defer to my team to confirm that detail.
Yes, Mr. or Commissioner Cross, it does. The wells drilled in the Watkins area do pass under nearby homes and nearby properties. I'll note that the developed interval is at about 8.5, 9,000 feet below the surface. But the answer to your question is yes.
So not same level of development on the surface in terms of houses, people, et cetera, but it's safe to say you do have experience drilling similar.
Yes, that's correct. Yes. Yep. That is correct.
Yep. And within this geology. Okay.
Yes, that's correct.
That is helpful. And kind of continuing on that line of questions,
yes.
One of the things you brought up was the measure wall drilling, the MWD. Mm-hmm. I think that's a good place to start. Again, you went into a little detail on what that does and how Civitas and its other companies have not hit any existing wellbores to date. Can you give a little more detail on how the MWD process works, what's done to make sure that existing wellbores are missed, kind of how that's done?
Yep. Yeah, absolutely. Thank you for the question, Commissioner Cross, and the opportunity to expand on that topic. Again, I'll probably punt this over to Andy. He has a much more experience on the drilling side. So Andy, take it away if you don't mind.
Yeah, no problem. So
thank you.
Our MWD tool is a part of our bottom hole assembly at the end of our drill string. That tool is communicating with receptors at surface and is providing a signal back to surface with the survey positioning of our drill bit at the time we request that survey. So at a minimum, we are collecting a survey about every 100 feet as we proceed drilling our wellbore. If we feel we're in an area where we need to gather more frequent surveys, we would do so. But drilling does not proceed while we're collecting the survey. Once we collect the survey and we have that data, then we would proceed drilling. It's also worth noting that our directional drilling personnel on location have a software that has all available surveys of offset wells that are near the wellbore we're drilling. So as they receive the survey data, they are populating this software, and they can see the position of our BHA of our drill bit in relation to any and all offset wells, and can ensure that we're maintaining our position and avoiding any collision with those offset wells.
And that's with respect to known and wells being detected as you're going forward?
Correct.
Okay. And about how far away from the end of your drill bit do you have to be from a well, if it's maybe one that's not known, in order to get an understanding of how close you are? Is it detected when it's within the 100 feet you're talking about, or further, or does it get pretty close before you know?
I guess to be clear, maybe I'm not understanding your question. Are you asking if that MWD tool is sensing the presence of another wellbore?
As you're talking about conducting the surveys and identifying where known, and as you said, you have existing surveys that's done in the software. And I want to make sure we kind of paint a picture for everyone listening in as well, because for those that haven't been able to visit drill sites and see some of that software where you can literally see a picture of what it looks like coming up close to wellbores and kind of going around them, trying to make sure that we can provide stakeholders an understanding of what's done to detect wellbores, whether known or not known, and how close you may be getting to them and how you can avoid them.
Sure. Yeah, the software they're employing during drilling operations, again, we populate that software with the surveys of those offset wells. So as we get survey data back and we understand the positioning of the wellbore we're drilling, we're we're evaluating our proximity to those offset wells. And the accuracy is pretty close to within a few feet. Now, if we get extremely close, the MWD tool has it's an electromagnetic tool. If there's nearby steel from the casing of an offset well, we'll start to understand the behavior of that tool because it's sensing a nearby steel product that would give us pause. We don't aim to get that close for that to occur, but that would be another indication that we are approaching an offset well.
So I guess to summarize, in order to avoid colliding with existing wellbores, whether known or not known, you look at existing survey data, you conduct additional survey data as you proceed, and you also have the electromagnetic sensor within the bit itself that's letting you know if you're getting close to anything.
Correct. Yes.
Again, kind of going with the safety of what's talked about, and I know we've talked about this in other hearings, but again, for stakeholders that may not have heard this in other hearings or may not have understood this, we heard during the 511 hearing discussions about concerns that when you frack, it could destroy the foundations of houses. It can connect with water sources, et cetera. Can you give an explanation as to why Civitas does not believe there's a concern for that kind of impact, that kind of adverse impact?
Sure. And I would probably, I think we have some geology representation on the call that could speak to some of the geologic reasons that we believe we would not see communication from the depth of our lateral up. But, again, I'll point to, the offset well evaluation process that we enter into with the ECMC to evaluate all offset wells, and working with that engineering team as we prepare any offset wells that require further mitigation to protect those wells from any communication up to surface. We take the necessary steps to ensure that those meet the requirements of the ECMC. But I think if you want to understand the geologic component of that, I would pass on to our geology representation on the call.
And just to note for the commission, our geology team member is on the call, but has been listening and watching, and has not been elevated yet and has not been sworn in. So if we want to kick any questions her direction, we might need a moment or two to sort that out and have the hearing officer help us out with that. So just want to make that known.
And Mr. Chair, I think that would be helpful to try and get an idea of some of the geological and I'll probably go into some of the engineering aspects with respect to some of the frac.
Sure. Go ahead. Let's get her sworn in.
Yep, Chair, and for the host of the meeting, it's Emily Swanson is who you're looking for to elevate to a panelist. And apologies, she was inadvertently left off. She was listed in our presentation. So Emily Swanson's who you're looking for, and then once she's elevated, Ms. Mercer, I'm sure we need to swear her in.
Ms. Swanson has been elevated.
Ms. Swanson, if you could visualize yourself, I will swear you in. We are not seeing your video. Mr. Chair, would you like me to proceed with swearing her in with no video?
Sure.
All right.
Sorry, Ms. Mercer. I just want to say, Emily, you're also muted. I'm not sure if she's aware that she's also muted.
All right, Ms. Swanson, I will just ask you to raise your right hand, state your name, and that you swear to tell the truth. We can't hear you if you're speaking.
It looks like she just sent a note in the chat, even that her video and audio are not working. Perhaps, Commissioner Cross and Chair, I know we've got a lot of other questions. Let us troubleshoot if we could really quick with Emily, and then we'll let you know when she's up and running.
That sounds good. Commissioner Cross, do you want to go to a different line of questioning for a bit and then we can come back?
Sure. And I'll try and keep it along the same type of lines, but maybe go into petroleum engineers instead of the geologists here. And maybe it would be best to have Ms. Swanson's input on this as well. But one of the other things that I'm curious about is, again, going along with the hydraulic fracturing and the lengths of that, can you give us an idea of what the frac wings are going to be on these different stages? So again, so stakeholders can get an understanding of how big these fracs are, understanding that they're 8,500 feet underground, but how far out are we trying to get these hydraulic fractures to try and expand on the shale?
Good question. I don't know that I'm the appropriate person to speak to that. I strictly manage our drilling operations. So again, I apologize. I think it'd be more appropriate for other engineering members of our team to speak to those specifics. I just don't want to speak incorrectly and provide the wrong data.
Yeah, I think I can go ahead.
So I was going to say, and if that's maybe something it's best left to Ms. Swanson as well to talk about the geology and the length of the fracs as well. The other question I was going to ask about was the monobore.
Yep. Andy, I think you'd probably be a good one to handle the monobore technology.
Sure. Monobore drilling essentially speaks to the wellbore design where we drill our surface hole that is set anywhere in the DJ Basin for our operations, anywhere from 1,600 feet TVD to about 3,300 TVD, again, depending on area and the geologic formations, primarily the water-bearing formations close to surface. The surface hole and casing seeks to isolate those zones. From that point, when we drill our production hole, we are able to drill one production hole from surface to our target depth, and then run one singular casing string and cement that casing string in. So where historically and in this basin and other basins, you might see intermediate strings of wellbores drilled and casing set. Presently, the monobore represents we drill a surface hole and then a single production hole with the casing from that surface all the way to our measured depth.
Okay. And one of the things that you noted on the slide as you were talking about some of these drilling safety concerns, I guess before I go to that question, you talked about the possibility of two drill rigs running simultaneously. Can you give us an idea of, one, would both of those be hooked up to utility drilling? Okay.
Yeah.
And two, what's the likelihood of that happening? And three, if it is to happen, what kind of time would you save by doing simultaneous drilling?
Thank you.
Yeah, go ahead.
Andy, go ahead. If you'd like to go for it, please proceed.
I will just say that, with the expectation, if we were to have the opportunity to start drilling operations on this pad. We would have the 2 drilling rigs that would be contracted to support our drilling operations are both equipped to operate off utility power. We have drilled previous pads in our drilling operation off utility power, so this would not be a new instance where we've performed with this type of power. From a timing saved, depending on the start point of each rig, and where they fall with our schedule, I don't believe they would start exactly at the same period of time, given their work before leading up to starting on this location, but it generally would reduce it in half. Given the length of many of the wells on this pad, to drill that number of wells with 1 rig versus breaking those up with 2 rigs is pretty significant.
And so I know a lot of times, not exact, but if it's approximately 3.5 to 4 days per well, with this length, what kind of timeline are you expecting in terms of?
I would say we measure from a cycle time standpoint, our start of a well to starting the next well, if you will. So that's the drilling and then running the casing string and cementing. So for the 17 wells that represent the longest lateral length on this location, we estimate that cycle time to be about 10 to 12 days, start to start of each well. And then on the remaining wells that are of shorter lateral length, you're closer to 7 to 8 days from start to start of those wells.
And get the next one. So, okay. So potentially saving weeks if you can get both rigs set up.
Yes, sir. Yep.
And then going to the question that I was going to ask you, during that slide, you talked about drilling parameters will not be exceeded. And I was hoping you could elaborate a little bit more on that. I know, again, during the 511 hearing, we had some comments about a lot of commenters describe this as sort of experimental and being different. And we've talked about the Watkins drilling, but can you talk about what you're meaning with respect to the drilling parameters?
You bet. Good question. When we speak about drilling parameters, that refers to how we operate our drilling rig and the various capabilities that the drilling rig can perform and the tools that are assisting our drilling operations, what their capabilities are as we drill these wells. So there is an operational limit that we can safely drill a well, given the capabilities of our drilling rig and the systems that are a part of that drilling rig, as well as the tools that are in the ground. So to maintain and operate a safe operating environment, we don't exceed those operating parameters. So in essence, if we're drilling a single mile lateral, a 2 mile lateral, the operating parameters and how we operate drilling those wells remains consistent. So the point there is, by drilling a 4 mile lateral or a 4.5 mile lateral, we're conducting our operations in a consistent manner, and extending the lateral length does not require us or force us to try to push harder on the operations of that rig and get us into an unsafe environment. Ultimately, if operating within those constraints of those operating parameters, we reach a point where we can't drill further, then we determine that's the max length of our well, and we decide that in order to safely get our drill string and tools out of the ground, that would be the maximum depth of that well. So all that to say, we operate the rig and our tools and the systems on the rig in the same fashion, governed by the same limits, from a single mile, 2 mile lateral to how we would operate drilling these wells.
So no concerns about exceeding pressure, no concerns about exceeding torques, et cetera?
No, sir. Well, I should say there is the chance that torque could present challenges to us, just given the lateral length. But again, if we reach a point where we're exceeding our limitations on where we would drill with the torque in that area, we would make a decision to not continue drilling operations at the risk of creating problems for ourselves and potentially an unsafe condition. So,
and the drilling's usually done by a contractor, not Civitas itself. So is that a decision that's made by the contractor and how they feel about the rig, or is that a decision made by Civitas?
It's collective, but it's we understand working with them as a partner that there are limitations of and the capabilities of what their drilling rig can perform in drilling these wells, and so we ensure that we abide by those limitations and drill our wells accordingly.
Sorry, I'm going to jump back just a little bit because I came across a note here and I just wanted to make sure this was clarified as well. So in terms of missing the offset wells there, and it's not just the MWD that you're doing, but this is also done in conjunction with and planning with ECMC staff to make sure that any regulations related to that, any safety precautions are taken to make sure that you avoid offset wells as well.
Yes, sir. Yep.
Okay. And some of my other notes here are a little bit discombobulated, so I'm going to try and make sure I go into these together a little bit. But one of the things that I asked Mr. Frank, and I hope you were listening at the time, was trying to get an understanding of wells. Are there currently horizontal wells under Erie? And we talked a little bit about it with the Watkins as well, but can you give us a little bit of explanation on your expertise of drilling under developments like is being proposed here, to again try and get an understanding of, as people talked about this being somewhat unique, is this being somewhat experimental, and whether this is, do you believe it's experimental or unique, and if so, why or why not?
Sure. I don't believe and don't feel this type of drilling is unique. Civitas and its legacy companies have drilled in other urban areas within the DJ Basin. It's important to note that when we talk about the depth of the horizontal section of the well ranges, upwards of 7,000 to 8,000 feet vertical depth below the surface. So, since horizontal drilling became a main practice in the DJ, there are other urban areas where we have drilled and successfully executed the drilling operation of the wells that do go under residential developments. And again, reiterate that, we have not had a collision event with a well or had surface impacts during drilling operations in those instances.
Commissioner Cross, if I could jump in really quickly. I know that you're heading down maybe a new line or an additional line of questioning, and I just want to make sure we don't lose sight of some of the questions you raised previously, including the questions about the frac lengths. So if I could ask Nathan Bennett to jump in and answer that question before we move on, I would ask to do so now.
Let's go for it. Mr. Bennett.
Thank you, Ms. Fulcher. Thank you, Mr. Chair, for recognizing me, and Commissioner Cross. Appreciate the question. Typically speaking, our fracture half lengths range between 150 and 300 feet, depending on site-specific geologic conditions, et cetera. There's also a height component to those, and typically that height, that vertical growth is anywhere from 75 to 100 feet above where that fracture is initiated. A logical response may be, well, how do you know? Quite candidly, those assessments or those estimates have been made based on a number of different technologies, including offset monitoring in wellbores, the use of microseismic monitoring, rate transient analysis, which is a series of engineering functions that will provide things like volume and distance, connectivity, etc. And so these are what I will call known lengths, known quantities, and known results when we initiate these types of stimulations in the DJ Basin.
Okay, that's helpful. And I think some of my questions that would probably go to Ms. Swanson, maybe you can answer those as well, Mr. Bennett. When some of the stakeholders, especially during the 511 hearing, during some of the written comments, et cetera, talked about some of the concerns with the foundation, for example, the fracture is not going to reach the foundations of houses. It's still thousands of feet between the homes and between that, correct?
Yes, Commissioner, that is correct. In fact, you may recall from proceedings earlier this year, specifically our Lowry Cap hearing in late July, early August, we had presented a couple of slides on a surface analysis that we undertook in our Watkins area on our Chico Watkins South OGDP, where we monitored the surface during an offset hydraulic fracturing operation and saw no indication at the surface of that activity occurring, well below 7,000 feet, but rather picked up cars driving by on the offset roads or footsteps from folks that we were monitoring walking across the surface. And I have those slides up if that's something you think would be worthy of sharing or not. But I just wanted to remind you that of that presentation earlier this year.
No, I think that's helpful. I don't, unless other commissioners want to see it, I don't think I need to see that. I think that then the question becomes where the concern with some of the fracturing would be is if you do hit those offset wells, correct? Because that would then provide some sort of pathway to the surface, not necessarily for earthquakes or something, some kind of seismic activity, which I think might be best for Ms. Swanson, but with respect to some kind of leak. And could you give an example of how that is protected from?
Certainly, I appreciate the question, Commissioner Cross, and we'll defer to my counterparts that are here on the call as well to fill in any gaps that may exist. So in the unlikely scenario that there is a communication between a newly drilled horizontal wellbore, one that is being hydraulically fractured, and an existing penetration, there's a couple of basic scientific principles that need to be accounted for. And one, I'll say this very simply, is the loss of energy, right? And so one, in order to, or I should say, backing up, in order to impact an offset well, the plumbing, so to speak, has to be there, right? And so there needs to be either an existing conduit between your newly drilled well and the existing well, or that conduit needs to be formed. The way we design our stimulations is to retain the energy from that stimulation into our target interval. In other words, we want, as we are pumping under pressure, right, our fluid under pressure to stimulate that particular stage of that horizontal well, we don't want that energy to go outside that zone. In the unlikely event that it does, that energy dissipates very quickly and loses its ability to grow. And so if you're thinking of something that occurs at 7,500 feet, if we were to intersect an existing conduit, while there may be communication between those two penetrations, it's unlikely that that communication would result in some form of surface manifestation, but rather would lose its ability to grow, so to speak, long before, several thousands of feet below the surface, before it would have any impact to public health, safety, welfare, or the environment, based on my experience.
Chair, if I may, I just messaged Mr. Thomas. I believe Emily has tried joining by phone, so she might be appearing. It's her phone number. If I could.
Actually, we've got Emily online.
Okay.
We can see her. Ms. Swanson, if you want to unmute and raise your right hand and swear to tell the truth, then we've got some questions for you.
I swear to tell the truth.
All right. Commissioner Cross, your witness is available.
Thank you, Ms. Swanson. I appreciate it and apologize that you're having some technical difficulties there. not sure if you were able to hear all the lines of questions we were kind of going into, but I think to try and address some of the concerns that stakeholders provided in written comment and public comment and during the 511 hearing, wanted to try and, as a geologist, try and get your understanding of why you may or may not have any concerns when it comes to things like seismic activity, hydraulic fracturing having any kind of effect on foundations of getting to the water table, getting to water-bearing aquifers, et cetera.
Absolutely. And I just want to apologize for my technical issues earlier. So we have seismic over the Draco section. We have it all the way until the very, almost to the toes of the laterals. So about 3/4 of the wells, we do have seismic over. We have gotten our seismic expert to analyze this. So he has taken a look at 4 different slices. So, you know, a few thousand feet above the Niobrara, at the Codell, and then down below. We've also looked at basement faulting here. And what we find is that in the DJ Basin, where we have basement faulting that goes to surface, we can easily show that on a map. That is at least 3 miles to the west of our toes on the Draco. So we do not expect to hit those like larger basement faults with these wells. Any faulting we may have within the Niobrara is probably going to be on the order of 50 to 70 feet, maybe even smaller, 20 to 30 feet. We have thousands of feet of very clay-rich rock above us. This is rock that is not so easily fracked. This is also rock, it's the Pierre Shale. So it's rock that we do not see in seismic. We do not see faults going through this. We do not see anything connecting from the Niobrara through this Pierre Shale up to surface. And all of the aquifers we're talking about are going to be on the order of, you know, 1,000 to 2,000 feet deep. I know we've talked a lot about this. The wells we're drilling are going to be more like 7,000, 8,000 feet deep. So we do have thousands of feet with no through-going faults and with this thick, we like to call it kind of a top seal, this thick 1,000-foot shale, thousands of feet of shale above us to protect any aquifers or to protect any shallow hazards.
Perfect. I appreciate that. I think those that deal with my questions with respect to some of the drilling aspects, some of the geology aspects. So I do appreciate that. Again, I'm trying to make sure I don't jump around too much here.
Commissioner Cross, this is Claude Boiteau. We do have 2 slides that if additional visualization is necessary, we could pull up, but Ms. Swanson did speak to it very well.
I appreciate that. Again, I don't know that I need to see them. If other commissioners want to, I'm happy to stop and look at them now as well, or look at them in a little bit as well. The other, I'll call it the safety issue that I wanted to address was there was, for example, today, one of the public comments talked about making sure that, and maybe I can get the exact language here, respond expediently to any incidents. And so I was hoping that you could talk a little bit about, you mentioned the remote capability, remote shut-in capability, talked a little bit about some of the monitoring as well. I was hoping you could talk a little bit about how that remote shut-in capability, how some of that remote monitoring works, how repairs are done, how quickly you can get repairs done, and your thoughts on kind of that aspect of one of the things that was talked about stakeholders today.
Yeah, thank you, Commissioner Cross. I appreciate the comment. Just to be clear, your question is directed to the post-production facility at the Draco location? Yeah. All right, thank you. I think initially it probably would be best maybe to toss this over to Aaron Schlaba. He's our air representative on the call, and he can speak to how the Clean Connect system works and how it identifies potential leaks on location. And then if that doesn't fully address your question, we can talk a little bit more about the sensor technology that's on location.
Great. Thank you, Claude, and thank you, Commissioner Cross. The system that we're proposing placing at the facility is an OGI camera system. The OGI camera is equivalent to the same cameras that LDAR teams use. It complies with Quad OA, Quad OB, and it's situated central to the facility on a pan tilt system, and it automatically scans the entire facility. That we break it up into sectors, and it will dwell approximately 2 minutes per sector and then move on to a different sector. And it uses AI technology to look at the frame and determine if there's any emissions present. And then if it does determine that there are emissions present, it sends an automatic email to our operations control room, and then also to our LDAR team.
And for the public, the OGI is the optical.
Yes, yes, I apologize.
Imaging.
It's optical gas
This
imaging.
is like FLIR technology.
Yes, FLIR camera. Yes.
And then, so that's helpful for the emissions. If there was some sort of liquid leak, can you go into some detail on how those are detected and how shut-ins are done?
Yes, as far as the detection goes, that liquid leak is another feature of the Clean Connect system, and it's something right now we've been working with them to kind of refine the methods. We've gone out and done testing where we've used water trucks, and as far as the shut-in goes, the automated alert system, it's designed for our operations control room to review that. We wouldn't want a shut-in happening if say, there was rain and there was water puddling, but it was actually from rain. So that's why we still involve the human element to determine what's actually going on there. But it allows us to respond the quickest out of all the technologies that there are.
And I'll note, Commissioner Cross, that's in addition to our pressure sensing equipment that is actually plumbed into the facility system throughout the facility, ranging from the wellhead to the end of the facility equipment to where the product is leaving pad. And if any of those pieces of equipment notice a pressure drop, they automatically shut the wells in and shut the facility down. And that happens automatically, but also can be done remotely and on site.
And that's helpful to know that that happens automatically. And again, to kind of talk about that public commenters question there, what kind of response time are you looking at in terms of getting somebody out there to deal with the situation, to, as she said, respond expediently to any?
Mm-hmm. Yeah, I appreciate the question. We have field personnel that are dedicated to these areas of our operational field areas, and they're in the field daily. They would be able to respond most likely within the hour, if not sooner, to an event that is identified on location.
That is helpful. And I think building off of the monitoring that was talked about, again, for clarification purposes, the town of Erie talked about some additional soil monitoring that was requested. Civitas is agreeing to that additional soil monitoring that was requested. And similarly, going along with some of the Erie requests, you are going to be working on the wells that were identified by the town of Erie and making sure that those are just monitored and replugged, or what's the plan with that?
Yeah, a good question, Commissioner Cross, and I appreciate the opportunity to add more detail. I'll start with the first part of the question. The soil gas surveys that Mr. Frank has noted and ELC has also kindly noted. We've agreed to perform those on the 6 wells that Mr. Frank identified, and those will be that process that we've lined out will include soil gas surveys prior to drilling, and then again after stimulation, and then another 90 days after stimulation, and then another survey a year after stimulation. Those results will be shared with the town of Erie, and then the town of Erie will likely share those results with the ECMC. If any thermogenic soil gas is identified, we will be sharing those results directly with the ECMC. So that is related to the soil gas portion. I'll pause there for a second to see if you have any additional questions before I move on to the other part of your question.
I appreciate that. And so consistent with what I was talking with Mr. Bennett about, this is an idea of if there is some kind of connection, even if unlikely, with one of those offset wells and there's potential leaking going up, this is a way to make sure that it would be identified and it would be taken care of quickly.
Yep, that's correct. And I think it's important to note that if it is identified post-stimulation where it was not identified pre-stimulation, we've agreed in the language of the documentation that has been supplied to the ECMC that we would work collaboratively with the ECMC to determine, what are the next best steps for that particular well. Moving into the offset work, I think the second part of your question kind of touched on our offset well evaluation protocols. So as we noted in the slides, every well within 2,000 feet of our planned new well bores is included in the offset well evaluations, and then again is included at 1,500 feet with the standalone ECMC procedures. It doesn't mean that every single well, including the 6 wells that we've agreed to monitor through the soil gas surveys, will be re-entered, but it also does not mean that they won't. If those wells are identified as being employing substandard plugging practices to what is currently performed in the basin, they may and very likely will be recommended for re-entry. If they are re-entered, those wells will still be monitored. If they are one of the 6 wells we have agreed to monitor, they will still be monitored for soil gas after they've been re-entered. I think it's also important to add that the offset well evaluation protocol, it's the opinion of Extraction that this standalone protocol is sufficient and has been sufficient in the past to identify wells that are in need of either re-entry, or if they're still producing, wells that are in need of equipment upgrades. And it is not our opinion that these wells also need the soil gas surveys, but we are happy to do so at the request of the town of Erie, and we're excited to perform that work to provide additional details to ensure the public and to ensure the town of Erie that these wells are safe and that the public around them is protected.
And again, for clarification purposes, the 6 wells you're talking about are separate from the 22 wells that are going to be plugged and abandoned as part of these.
In some instances, they are because they are. Excuse me. In all instances, they are because they are previously abandoned wells.
Okay.
Yep.
That is helpful. And then again, continuing with some of Erie's requests, we obviously talked about working with Erie and the Southern Land Company with respect to the timing requests. One of the other requests was about improvements to the road towards the landfill to the south. Can you talk about that a little bit more?
Yeah, absolutely. And stop me at any point if you'd like to focus my comments a bit more. So as part of the engagement with both the town of Erie and with Southern Land or Erie Land, it was identified that the road or the sections of County Road 6 between the planned Draco OGDP pad site and the the closest landfill was unpaved. through ongoing discussions, it was noted by ELC that they felt that this would benefit their development to have this paved, and we agree that it is a positive addition to the Draco development. The road is about quarter to a half mile long. It's currently unpaved, and the timing of the paving effort is going to be delivered prior to drilling activities. So that was laid out so that we could continue moving forward with the OGDP development schedule. And if for some reason paving were to be delayed, we wouldn't have to stop our development plans to allow for paving to commence. But we have committed to not start drilling until that section of road has been paved.
Perfect. I'm looking through my notes. I think, and I want to promise, I think I have 3 more kind of questions coming up. The first, actually, I take that back. 4. The first is some discussion of the water. There was, again, public comment about the amount of the water, 541 million gallons being used over it. Could you go into a little bit of detail? I know during your presentation you talked about, I think it was 42,000 gallons a day would be recycled. But could you go into a little bit of detail on where the water is coming from? What would it be used for if not being used for this? Obviously, as people are talking about drought.
Yeah, absolutely. Thank you for the question. Just to clarify, is your question specific to the produced water only, or are you also asking about the other components of the water for completions, the not 42,000 barrels?
The water for completions, the overall, and again.
Yeah. So I'll address the first part of your question. The recycled water that we're planning to and have committed to utilize during completions is coming from the nearby hub that has been identified throughout this presentation. Otherwise, if it was not used in this this effort, it would be transferred via pipeline to disposal wells. The remainder of the water is purchased from the Front Range water company that has been previously mentioned, ditch company, excuse me, previously mentioned in this presentation, and has already been identified for industrial uses by the state agency.
Okay. So this isn't water that would be used for drinking water, et cetera?
No, that's correct.
Couple other public commenter related issues before I get to my final question. The first one is, again, one of the public commenters today talked about the desire for Civitas to plug and abandon the wells before these wells are drilled. And I think even this commenter understood about it as she talked about creative options for continuous operating. But could you go into a little bit of detail about why you need to drill the wells before you can plug and abandon the existing?
Yeah, absolutely. Thank you for the question. Many of the wells that we are contemplating and have agreed to abandon or are happy to abandon as a result of the Draco OGDP development are contingent on their continued production is contingent on the leases that are held in the areas of the new development. These wells need to stay in production until either continuous ops or specific to the lease, or new wells come on production to produce those minerals that they currently produce. It does not mean that in all cases we have to wait until all of the Draco wells are on production. But we do need to start those operations before we can start plugging those wells.
So to kind of summarize for the people listening in, you would lose the lease that you're trying to drill into if you plugged and abandoned those wells.
That is correct. Yes, thank you.
And as you talked about not needing to drill all the wells and have all the wells producing before you do it. Have you looked into potentially timing and starting to plug and abandon before some of the additional wells are brought into production?
That is possible. We have agreed with the town of Erie and have and plan to have ongoing communications on a regular basis with the town, and have committed to starting those operations as soon as feasibly possible.
And then I think the last public commenter related question I had was, especially during the 511 hearing, we heard a lot of comments about concerns from stakeholders about seeking waivers on a lot of different issues. And I know there was waivers related to noise, waivers related to wetlands, et cetera. And if you could describe why those waivers were sought, I think that would be helpful for stakeholders as well.
Yeah, absolutely. Thank you for the question, Commissioner Cross. I might toss this over to our regulatory department. Mr. Annable might be able to better address this question.
Sure. Thank you, Claude, and thank you, Mr. Cross, or Commissioner Cross, for your question. As a part of our OGDP, we didn't request any lesser area impact exemption requests as a part of our OGDP. We submitted all required plans and exhibits for the OGDP. So in hearing that public comment, I was a little confused as to what waivers we were requesting as a part of our OGDP. So yeah, I was a little confused by that public comment.
Okay. Sorry.
I'm sorry, Commissioner Cross. I was just going to add for the record, I believe the only waiver, and it's noted in the director's recommendation, relates to 1202A3. And that would be the waiver regarding staging, refueling, or chemical storage within 500 feet. And that waiver was presented to CPW. They agreed to that waiver and it was made part of the record. But to Mr. Annable's point, there's no lesser impact exemption requests pertaining to noise or any of the other mitigations contained in the 400 series.
Thank you, Joe. I did.
Thank you. And then I have one final question, and I'll kind of preface this with saying, I appreciate you kind of preempting some of the questions I had with the presentation here today. It's helpful, and going through some of these questions that really are geared towards a lot of the concerns raised by stakeholders throughout this process, throughout the application process. And I appreciate the amount of information that you have in response to these, talking about the lateral lengths, talking about the MWD for drilling to make sure that you're missing offset wells, et cetera. And so one question, and Mr. Boycho, I think perhaps for you as it goes to kind of the stakeholder outreach, did you have any meetings with the public where you went over some of these ciquestions prior to the hearing today to try and talk to stakeholders about what some of these processes are that Civitas uses that this isn't a unique lateral length or something completely experimental, and kind of the protections you use? Did you have any public meetings like that?
Extraction did not host a specific public meeting to review the Draco development, but we did engage with the town of Erie, with the Erie Land Company, and as part of the WOGLA 1041 WOGLA process. And we did post our public website for the public to check on and learn more about our operations.
Okay.
Jeff, maybe Mr. Annable might be able to add to that question as well.
No, I agree with you, Claude, and thank you, Commissioner Cross. Yeah, we did, obviously, as Claude mentioned, reached out to all the residential building units within 2,000 feet. We worked with Town of Erie and Erie SLC as the offset developer. We developed a microsite communicating all of our details of our project to the community. We provided that to SLC, as well as some of the public commenters had reached out to us individually asking for a lot of information. We provided the information to our website, and at that time we heard he referred to himself as a spokesperson for the public within the town of Erie. I believe he's in charge of Erie Protectors. And we informed him of what we were doing. He said their primary concerns were with the offsetting, remediations with the, legacy removals. And that's where we worked with the town of Erie to come up with, all the coordination efforts with the town of Erie to make sure, we're addressing potential impacts and hearing if there are any impacts, as we continue down that path.
And was that a phone call? Was that over email? How did that communication?
We communicated via email. And while we did that, we provided him updates of when we passed completeness, how to provide public comment to the commission, so that could be part of the record, as well as those stage gates.
Okay. That's helpful. And part of the reason I want to ask about this as well is we obviously had the public commenter today, and I believe he also spoke at the 511 hearing, talking about reaching out and asking about some of Civitas's experience with drilling laterals of this length. And he said he did not get a response. And so, especially after hearing about some of the experience today, I wanted to try and make sure we could understand whether responses were being given for that and kind of the opportunities to do so.
Sure. And our apologies to that public commenter if we did miss their request for information. We're more than happy to, reach out and have a discussion with him about these technologies we spoke to today.
And I'll note on to the end of that. Thank you, Mr. Hannibal. As we continue to discuss with the town of Erie, as I noted before, we do plan to continue recurring conversations with the town of Erie through pre-production operations. And we've committed to continue those discussions with Erie Land Company through pre-production operations. If either of those entities identify that there's additional public individuals from the public that need additional information, we're happy to, and we have in the past engaged with those individuals to provide that information.
And those are my only questions. Thank you.
Yep. Thank you, Commissioner.
Thank you, Commissioner Cross, for leading us off with a bunch of good questions. Who has other questions? I can't see everybody. Just pop.
Yeah, I got just a couple quick ones here.
Go for it.
So I think I was following the what Commissioner Cross was talking about and what you testified to around pressure associated with completions and how that may or may not change depend on lateral lengths. But I just want to confirm that I'm understanding here. So are you testifying that the pressure does not change if you've got a 5 or a 6 mile lateral versus a 2 or a 3 mile lateral associated with completions activities?
Thank you for the question, Commissioner Mesner. Just a quick clarification before we jump in or the appropriate person jumps in. When you say pressure, I'm assuming you to be referring to the drilling parameters that we discussed earlier in our slides, and pressure being one of those.
I'm not talking specifically to drilling. I'm talking specifically to completions, right? And so now you're pushing sand, you're pushing frac fluid, water. I don't know if that's drilling parameters as you're defining it or not. I mean, I'm not talking about drilling, I'm talking about completions, but maybe it's the same thing.
Yeah, okay. And thank you for that clarification. I just wanted to better understand that. Ms. Fulcher, we might need to elevate Randy that's not currently in the panel to speak directly to some of our completion design parameters. He was not previously, I don't think, previously elevated.
I think that you're right, Claude, and apologies, commissioners. He is in attendance. I don't think having Zoom issues. It's Randy Fletcher. I think he's our last panelist, so this won't be a recurring issue, but apologies. I think we do need to elevate him.
Yeah. Thank you.
Mr. Thomas, I assume you're trying to elevate him.
He is elevated.
All right. I see he's elevated. Ms. Mercer?
Thank you and good afternoon. If you could just raise your right hand, state your name, and that you swear to tell the truth, please.
My name is Randy Fletcher. I swear to tell the truth.
Thank you.
Mr. Fletcher, did you hear the question?
Yes, sir. I think I did. To me, I guess so. There's two parts to the question in my mind. So the pressure that it takes to break down the rock, whether it's a Niobrara or a Codell, that's a very specific geologic parameter. That part should not change whether it's a 1 mile to a 5 mile well. The part that will change in this process is the friction that is acting against us as we pump down hole. Obviously, more lateral length, more friction, and then less lateral length, less friction. But we're governed by, on surface, our surface maximum treating pressure, which we test to and we do not exceed. So basically, we will lower our rate that we are effectively pumping down hole for our toe side of the 5 mile ish, or if there is a 5 mile, right? A longer lateral will limit our rate because we'll be fighting friction. That answer the question?
That does answer the question. So just to take it one step further, understanding that you've got additional friction at the toe end. Has there been, I guess, problems associated with overpressurizing or that pressure causing problems downhole that may find its way to surface via faults, via plugged and abandoned wells, unknown wells, things like that? That's the type of pressure I think people are concerned about. It's not the drilling pressure, it's not the drilling parameters, it's this completions pressure.
Yes, sir. I think I understand the question. So a couple of things that so no, I guess the quick answer is no, we're not going to go into another well. Some things we do to mitigate these issues. So like a 2 mile well, we normally run 5.5 inch casing on 7 of the 4 mile laterals that are currently in the DJ Basin. We have ran 6 inch casing, and obviously more hole, less friction. So that's one way we do it. And then the last way that we're mitigating all this friction issue is that we change our perf size and effectively our stage size. So we shrink the amount of rock that we're able to effectively treat when we're at this longer sections of the well. For instance, on the 4 mile laterals, instead of our normal 220-foot stage spacing, we shrunk it to like 120 feet stage spacing so that we could effectively treat each section of the rock there.
Okay.
So it's I guess to me, I think about it as the engineering control part of it, that we're trying to mitigate that and not over pressurize something. Right. And then lastly too, so all the equipment is governed on surface. We set kickouts to, and so we cannot overpressure.
Randy, would I be correct in saying that whether it's at the 1st mile or the 5th mile, the pressure leaving the wellbore is the same?
Yes, sir.
But entering the wellbore is different.
We're at the surface.
Right. Okay. Thank you. That answers my question there, so I appreciate that, Mr. Fletcher. Different topic. I guess I'm trying to understand. I appreciate that this application proposes the utilization of 2 electric drill rigs. You, as an applicant, have testified multiple times that it's difficult to get electricity to run 1 electric drill rig, let alone 2 electric drill rigs. And so how is it possible that 2 electric drill rigs are being able to be handled by the grid here when generally I hear the testimony that not even 1 can be handled?
That's an excellent question, Commissioner Mesner. We're in a perfect area for this. There's literally 2 substation feeders that are adjacent to our proposed pad. So we have two separate grids right there at this proposed location that allow us to do two drops to each rig, allowing us to power two rigs with utility power. That's an extremely rare situation where you have two substations joining at that one spot.
Okay, so it's the substation, the proximity to two different subsections. Is that what I'm hearing?
Yep.
Okay, thanks for that. I was just curious. That's a curiosity question. I do have a question for staff about the offset well evaluations. And I can wait until we're done with that applicant here. But I do want to, staff is aware that I have a question. And so I just want to better understand, and I think particularly for the public that's here, what the offset well evaluation is and when it occurs in our process. And so I'll tee that one up. And other than that, I think Commissioner Cross has answered or asked a lot of the questions that I have. I would note that industrial water, at least as I look at produced water recycling, is not produced water recycling. It is not using fresh water in some respects, and I appreciate that, but I hope it's not being reported as recycled produced water on your Form 7s. So.
And Commissioner, I note that we've still got Diana with us if you wanted to go there on that question, or if we want to allow other commissioners an opportunity to ask this panel questions before we go back to staff. Either way is fine.
Whichever you prefer, Chair.
Yeah. Why don't we keep moving with the commissioners and let Diana mull on that for a bit. I had one question, and this is not indicating which way I'm thinking about all this, but appreciate that the applicant and the Southern Land Company, or whatever the company, the ELC, have reached an agreement to try to get these wells in before the homes get certificates of occupancy. But I'm a little confused. We heard from the town of Erie that they wanted a strict 3 years from whenever this approval takes place. And now we're hearing from the applicant that you want 3 years and 7 months or something like that, based upon the drilling and spacing unit, the pooling application, which I've been informed has not been applied for yet, would probably be applied for if this gets approved, and then you're looking at a few months before that gets generated. Do you have comments about that discrepancy that I am finding as I look at my notes?
Thank you, Commissioner.
Oh,
go ahead, Jill.
Sorry, Claude. And of course, I can't see you, Claude, so I didn't know you were about to jump.
Okay.
Chair, I'll start that one. And then if Claude wants to add anything, he can. And then I do think we want to maybe circle back to Commissioner Messner's point on the recycled produced water, because I think there was a little bit of a disconnect between what we're calling recycled produced water, the 42,000 gallons, and then the other water sourcing.
Why don't you do that first, and then hold my question, and you can get to it later, and we'll try to sequentially work through commissioner questions.
That works, Chair. Claude, do you want to go back to that piece?
Yeah, absolutely. Or Mr. Annable, you can hop in whenever you'd like. The component of produced recycled water that we had identified, I just want to be clear, it is not being misconstrued with the remaining water usage that we have purchased in our sourcing from the ditch company. The produced water is coming directly from the nearby hub and is water that has been brought to location from existing oil and gas infrastructure and dedicated water gathering and transport lines. And these are two distinct water sources, although they are both being brought to location through piping as it goes to the produced water, and then temporary lay flat as it relates to the fresh water that's coming to location. Does that clarify for you, Commissioner Messner?
Yeah, and I maybe misunderstood. I thought what I heard is that the 42,000 gallons or 4,200 barrels of recycled produced water was a combination of industrial wastewater and produced water from that hub.
No, sir. No, sir. They're two distinct water sources. And the volume that we gave was in gallons per day
Right.
of water we anticipate to offset.
I think the confusion is the water we're pulling from the ditch is allocated for industrial use.
So
I think that those two got mixed.
That is correct. Thank you, Mr. Hannibal, for clearing that up for me.
Thank you.
So with that, Chair, I think we can maybe circle back to your question regarding timing. And again, I'll start there, and then if Mr. Boito wants to add to it, by all means. This was a point of discussion, and you heard from Mr. Boygan. It's hard for me not to say Commissioner Boygan as well. You heard from Mr. Boygan that this was a piece that was heavily discussed between Extraction and the Erie Land Company. And the reason for that, of course, is that Erie Land Company has every interest in making sure that that they don't have to delay the certificate of occupancy on those homes in the southern portion of Westerly, which we appreciate. But of course, Extraction has a lot more to do to adhere to that well completions deadline. And I don't want the conversation just to be focused on pooling. I mean, just as a reminder, even here today, if we're fortunate to walk away with an approved OGDP, that doesn't mean we have an approved Form 2A in hand today. That often takes weeks, sometimes more than a month. From that point, from that Form 2A, as you know, we'll have to submit the Form 2s. The Form 2s are going to go through the entire Rule 308 process. That will include the offset well evaluation and any of the work that has to result from that offset well evaluation. And then from there, if necessary, we will have to file a pooling application. As you know, SB 185 has made some changes to the conditions on pooling. We anticipate filing that application very soon after what we hope is an approval here today. But again, that's another regulatory step that is needed. And so we walked through all of that very deliberately with the Erie Land Company. And then they also shared their concerns with us, and we heard those concerns about the development and the timing of that southern portion of their land. So with that, we really came at this with what I think is a very reasonable condition that works in the interest of both of these parties, being the operator and the developer specifically. And again, what you heard was we have the deadline of 36 months to complete all well completion operations and get those wells on production. And that timing is either from the drill ready status as it's defined or from May 13th, I believe it is 2025.
Okay, let me ask my question a different way.
Yeah.
In the letter from Erie, they said that Southern Land has voluntarily agreed to delay requesting certificates of occupancy until all wells at Draco are in production or October of 2027, whichever occurs first. Maybe this is a question for Southern Land, but are they willing to not get COs for homes until after you're done? You know, even if it's this additional 7 months?
I mean, I think that you can certainly ask that question of Southern Land, but I think I would say yes. They've inked that mitigation agreement with us, and that Exhibit A, which contains that language, was what they directed us to provide to staff and put forth in the record today. So I don't want to speak for them, but I will say we have a contract.
Ms. Alteris just showed up. Do you want to speak to that question, Ms. Alteris?
Sure, I can answer that in a little bit more detail. So there are two timelines in play here. One is a voluntary agreement that Erie Land Company has already made and on its filing 3 lots that are within the 2,000-foot radius. And that voluntary agreement with the town provides that Erie Land Company will not seek certificates of occupancy for residences on those lots. That's already in place. And that is the timeline that burns off in 2027. The mitigation agreement with Extraction provides for the 36-month window that begins in May of 2024, if not sooner. So there's sort of two different timelines that we've discussed there. And the one that I believe was referenced in the town letter is the timeline that was memorialized in the development agreement for filing 3.
And you meant May of 2025, if not sooner. You said 2024.
I did. I apologize. I'm looking at my calendar and I misspoke. 2025.
Yeah, no problem. All right. Well, that's somewhat more clear. I'll let it sit for a bit and then we can potentially come back to it. I think the commission does have the ability to generate timeframes for drilling and getting it done, provided we make the necessary and reasonable findings. And maybe what commissioners we need to do is once we get through all questions, we make the determination of what that timeframe really needs to look like. But I'll leave that as is. Other commissioners with questions for the panel? Commissioner Oath?
Thank you, Mr. Chair. Just a few more questions. First, I wanted to circle back to the alternate locations, and thank you for going through that in your presentation. And I think perhaps I missed it, but when we heard from the town of Erie, specifically about location number 4, they indicated that there had been some conversation about that as a potential location, that they had, left it in your court as, indicating that they thought there was some potential there. So can you speak to kind of why you have not pursued that further?
Thank you, Commissioner Oath. That's a great question. So, during those discussions, there was a variety of things brought up, and we were trying to figure out a pathway to rezone that property to heavy industrial. And they don't have any heavy industrial in the town of Erie. And no guidance on how to prepare a rezoning application. And we weren't sure the pathway forward in that, especially since at 2,005 feet away, there was a residential development to the south. So we thought it would be highly unlikely that the board with the town of Erie, kind of as Mr. Frank had mentioned, that's why we have our rezoning things is, so we can have a buffer between heavy industrial and residential. So we thought it was highly unlikely that the board would approve a oil and gas location zoned heavy industrial 2,005 feet away from a residential development to the south. In addition, there was the environmental concerns there with, some of that heavy industrial dumping that Mr. Frank had spoke about. Even though it has been remediated, they're still on a monitor and wait approach. And we thought that, we weren't sure what, we would be, getting into constructing a pad in an area where that had occurred. So I hope that answers your question.
Yes, it does. Maybe just one follow-up. In terms of indicating that typically there's a need for a buffer in between heavy industrial and residential. If there's 2,000 feet between that potential site and the residential area, what is zoned in between those two areas?
As it currently was slated, like he had mentioned, there's residential development on that parcel as well that was denied by the town board. That residential development had been in process for the better part of 10 years, is my understanding. So there was residential, and I think their town master plan also labels that as residential.
Okay. Then another follow-up I had relating to some concerns that were raised around kind of the shallow depth to groundwater, right, being only 11 feet and potential impact from spills. Wondering if you can talk about the measures that you will be taking or have committed to in your BMPs to prevent those spills from occurring and containing or preventing impacts to water from spills that do occur. I think in your slides you did note an indication of a polyethylene liner as an additional measure. So if you could provide some more detail about what that is.
Thank you, Commissioner Oath. Yeah, as I mentioned, during both the drilling and completions phase, we line the entire location underneath the equipment with polyethylene liner. So in the case that maybe an accidental spill during pre-production operations happens, while unlikely, that would provide an extra barrier between that spill and the ground, further protecting that groundwater. Additionally, during production operations, as I had shown you, there's no hydrocarbon storage on site. We are using three-phase meter design with reduced separators. While small storage separators do contain a small amount of hydrocarbons, that has been reduced. And on top of all that, we have a robust maintenance plan to make sure that we're maintaining our equipment to prevent leaks. Additionally, we are always inspecting the location, and as Mr. Schlabach testified to, we have that Clean Connect system that should identify any potential leaks immediately, allowing us to jump onto cleaning up that spill as soon as possible.
Okay. Thank you for that. Turning then to plugging and abandoning, I know there's been quite a bit of testimony about that. And I appreciate that. Boulder County indicated a request for the Prince #1 well to be plugged and abandoned. Is that part of, I'm sorry, I haven't had a chance yet to cross-reference that the agreement with the town of Erie. Is that part of the plan with Erie? Would this be an additional action? And if so, do you have does Extraction have access, and do you have a response to that request?
Thanks, Commissioner Earl, for the question. The two wells that you referenced, or at least the one well you referenced, is actually already plugged and abandoned. So at this time, no additional abandonment is planned. However, that well and all the other nearby wells will be reviewed as part of the offset well evaluation process. If that review, and we have looked into this specific well since the last time we spoke with the town of Erie on it. But if that process reveals that this well or any of those wells require re-entry and replugging, we will perform that operation. It's also worth noting, if I may add one more, that then this may be where the confusion is coming from. That well is included in the agreed to soil gas surveys that we have committed to conduct before drilling and after stimulation. We will be requesting to gain access to that well, and since it has been previously noted that the surface owner is Boulder County, we will likely be granted access to that well to install that soil gas survey equipment. So we kind of have two things ongoing concurrently: the offset well evaluation process and our commitment to install soil gas survey equipment.
Okay. Then my last question is, and I appreciate you noting that you all have committed to ongoing meetings and communications with the town. But as Commissioner Cross noted, and as I think we've all certainly have observed, there's a lot of community interest in this. And if it were to move forward, I'm wondering if you all would be open to, kind of more ongoing community engagement, proactive on your part, rather than just responding to individuals who have reached out to the town, and you hear through the town that an individual connection may be beneficial, to provide information proactively about, what the operation is, where you are in the process, what community members can expect kind of along the way throughout the coming years. Just curious if you can speak to what you would be willing to consider in that regard.
Yeah, Commissioner Earl, thank you for the question. Just to be clear, is the question in regards to the planned abandonments that are going to be made possible, or is it in regards to the ongoing pre-production and then post-production operations at the Draco?
Well, That's a great question. I actually kind of meant more about just the drilling completions and production phases, but actually I think also providing information to the community about kind of the implementation of the agreement in terms of plugging and abandoning would also be really beneficial and something that would be great interest to the community.
Okay, fantastic. Let me address the first part of your question to begin with, and then I'll move to the offset well work. So as you noted, Extraction is committed to continued and recurring meetings with the town of Erie, continued and recurring meetings with ELC. Something that may have has been referenced but may not have been pointed out is that the informational website, the microsite that we've made available, that site is updated and will continue to be updated along with the phases of operation. So for individuals that are nearby that are wondering what we're doing, when we're doing it, and where we are in the process, that would probably be the best spot for them to go to first. In the event they have additional questions, we have existing hotlines that they are able to call. That information will also be posted on the website if it's not already there. And then, or they have the option to contact, if they do not feel comfortable calling us directly, they have the option to contact the town and provide that those questions through the town, which the town then can provide to us, and we can engage with them directly or engage with them through the town. So there are multiple options that we see and have utilized in the past to provide those residents with the information and the timing considerations that they may be interested in receiving. As far as the legacy abandonment work in the neighborhoods near the OGDP, it's standard process, and what we have followed in the past follows this process, that before we commence in the abandonment of those locations, we permit our reclamation activities through the pertinent local government. In this most often case, it will be the town of Erie, but it may always not be so. So we engage with the town on that aspect before we begin any on-site work. Also prior to any on-site work, and as a component of both the town's requirements and the ECMC's requirements, notifications are mailed to nearby residents, identifying the well, the location, the general timing of operations, what to expect on site, and what work will be happening on the pad during the plugging and abandonment procedures. In the past, if any additional information is necessary, we've engaged with the town to provide that information. It's also worth noting that before operations, downhole operations commence, and usually before reclamation operations commence, on-site meetings are performed at each location with Civitas staff and with Town of Erie staff, and sometimes with CDPHE staff to review the processes that are planned for the site, the duration of time we plan to stand on the site, and the BMPs that are installed on the site. At that time, if additional BMPs are identified to be necessary, they're installed prior to the commencement of work. And in no case do we commence work before all parties have been satisfied with their concerns and requirements, whether it be stormwater or regulatory based. I'll pause there for a second to give you a chance to ask any questions if I've missed anything or if I've gone off tangent in a different direction than what you anticipated.
No, I don't think I really have a follow-up question. It's
okay.
More just a comment to note, I think all of that is, helpful and important, and not to diminish it, but I do also think that, if you all were to host a public meeting and be available to answer people's questions rather than just say the information's on our website, it would go a long way, I think, for people to be able to have their questions addressed in that type of setting. But I do appreciate all of the other avenues you noted.
And that's not something we're against. I wouldn't say that it's common or has been common in the past, but I'm sure that if that is something that seems to be a benefit, I'm positive it will come up with the town.
Okay, thanks. And that's all the questions.
Okay, thank you.
Commissioner Ackerman.
Thank you, Mr. Chair, and I appreciate the significant discussion that's taken place. I am left with just a few what I think are really just clarification questions in the end. And really, I think I just have 3 left. The first one has to do with the paving of the agreed upon stretch of road. I heard in testimony that extraction will facilitate the paving of the agreed upon stretch of road, and just wanted to ask for a clarification by what was meant by extraction will facilitate that paving.
Yeah, absolutely. Thank you, Commissioner Ackerman, and appreciate the opportunity to add more color to this topic. So it was noted previously that we have a couple agreements that are or a couple operations that are outstanding as far as transportation. One of them is our TIA document. We've submitted our first base assumption document to the town, or excuse me, to Mr. Frank, and we have to submit that to the Public Works Department here shortly. Next, we have a traffic analysis that will be performed to understand. And I know I'm getting a little off topic, but I'll circle back. I just wanted to make sure everything was clear on this. A traffic analysis that's going to be performed to identify if any road improvements are necessary prior to the commencement of our operations. And then we'll also be taking a look through at the condition of the roads now, and then after our operations conclude, taking a look at the condition of those roads after. And this is all done in conjunction through a third-party traffic and transportation expert, through a standalone consulting agreement. As for the actual paving of County Road 6, the language that you're referring to is to allow flexibility for both timing and to allow flexibility for continuing engagement with the town of Erie. If it becomes evident that the town would like to complete this action, we are prepared to remit payment as determined by the third-party traffic expert to the town directly to complete this as they would prefer. If the town would prefer that extraction facilitate that paving through a local contractor that they prefer, or a couple local contractors that they would like us to vet and provide quotes, that is also an option. Basically, what I'm saying is that the language is in the completion of that requirement.
Thank you, Mr. Boytel. I don't know if it was just me, I lost you a little bit at the end there, but just to be very, very clear, from what I gathered there, extraction is committing to bear the costs of this action. Is that correct?
That is correct.
Thank you.
Yep.
My second question also has to do, I think, with the semantics of how it was presented today. And we've talked quite a bit about this, and so we don't need lots of background further, but the documentation has stated throughout that your intent is to employ 2 rigs, well, that you will employ 2 rigs, not that that's your intent, and that those rigs would be electric. But I heard today some use of the language, if available, you would employ 2 rigs. And I just wanted some clarification on that. Is that a commitment first to use electric rigs, which I think I've heard, and second, can you clarify the commitment to use 2 rigs at the same time?
Thank you, Commissioner Ackerman, for that question. To answer your question, Ms. Blunt, we are going to drill with a high utility power, whether it's 1 rig or 2 rigs. Both rigs will be powered by utility power regardless. The mention of if available is if, there's, our rig schedule is highly dynamic. So aligning 2 rigs on our rig schedule to drill the same stuff on the same location might be difficult. So there may be only an opportunity to drill with 1 rig. And as part of our Form 2B, we've provided this caveat to staff saying we'll update the numbers if we do decide to drill with only 1 rig with staff.
Thank you. And I must have missed that in the documentation. Everywhere I saw was a commitment to do 2 simultaneous rigs. So I appreciate that clarification. And I guess that begs the question then, what is the probability? What does the planning look like at this point? Have you currently planned for both rigs to be available based on the timeline that you have projected and proposed?
Thank you for
I can add some color to this.
Sure. Go ahead, Claude.
Thank you, Mr. Hannibal. Yes, Commissioner Ackerman, we are planning to drill this asset with 2 rigs. I think the optionality language that Jeff is speaking to, is to note that there is a possibility that might not be possible. But all our work up to this point is to drill this asset with 2 electrified rigs simultaneously. We've expressed that to Erie Land Company. We've expressed that to the town of Erie. And that is our plan internally at this time. And I don't foresee that to change. To Mr. Hannibal's point, there is a possibility that it could, but that is not the intent of extraction, and I don't expect that to be the case.
Thank you. I appreciate that response. My final question also has to do with utility power. I appreciated from Ms. Fulcher earlier the announcement today that you plan to use partial utility power for completions. I think that's going to be an interesting project to monitor and see. I just wanted to get a little more detail on that. What does partial mean? As this has just come up today, I want to understand what exactly you're committing to with regard to the use of partial utility power for completions.
Thank you, Commissioner Ackerman. That's a great question. As I'm sure you can understand, the completion operation is power intensive. It requires a lot of power to complete these wells. In order to get that amount of power, it wouldn't be possible to get that amount of power purely from the utility service. So as a way to kind of reduce some emissions, we're going to power, whether it be one pump or, some support equipment with utility power. That's what we're planning to do. We're building out a transformer to allow us to utilize that utility power that we've already brought to the location. And that power should offset approximately 10% of our emissions that would normally be associated with using just pure natural gas battery setup.
Thank you. That's helpful. And I realize that you stated 10% as kind of an estimate and not a commitment, but does that mean, just to clarify, that your intent is to run utility power as continuously as possible during completions? Or does that mean that overall you will largely do it through Tier 4 and at some point employ a 10% boost through utility power?
I think our intent is to use as much of utility power as we can throughout our entire completion operation.
Thank you. I appreciate those answers. Mr. Chair, I think that's all I had remaining.
Further questions for the panel? We've had quite a bit, which is good. All right, I'm not seeing further questions. With that, we have the option of moving into deliberations.
Mr. Chair, I had asked staff a question.
Right.
Well, program, and so I want to give them a chance to reply.
Yeah, let's see if we can get Diana back up.
So can we please rephrase the question?
Happy to. I really just wanted to give staff an opportunity to explain what the offset well evaluation process was, when it occurs, because we had a lot of questions about this during the 511 hearing and even today. And so I'm not sure a lot of people know about what the offset well evaluation is and when it occurs in our process.
All righty. So the offset well evaluation is a requirement of the APD. It's been a requirement in the DJ Basin since early 2013. And so the way it's administered is that there's a buffer drawn around the proposed well bores of 1,500 feet, and all existing wells within that 1,500-foot buffer are included in the offset well evaluation. They're done according to the trajectories of the wells. So in this case, I didn't pull it up. If you had two sets, some going east to west and some going west to east, they would have their own separate wellbore evaluations. Again, that 1,500-foot buffer around the entirety of the pad, not singular wells. So the reasoning behind that is that we didn't want someone to sort of move a pad 30 feet so that they could skip remediation. So 1,500 foot, those wells appear as part of the attachment in the APD. So we don't see that until the APD comes in for the individual wells. And then they would each include the entirety of the 1,500 foot, but they have a difference in that the distance from the proposed wellbore for that application for permit to drill would be specific to the well that's being evaluated. The existing wells are evaluated for the isolation of both the proposed producing formation in the newly proposed wells, and then additionally for any water that's in that specific geologic setting. So Fox Hills is traditionally the one that is called out most often, but we also have Upper Pier in some parts of the basin that's a consideration as to where water wells are developed. And so it doesn't necessarily require that that space is completely covered in cement, but that the water is isolated. So that could be through surface casing setting depth, could be through previously set plugs. It could be that there is uphole isolation for uphole intervals. And so the evaluation looks at all those things. And additionally, a recent addition to the offset well evaluation is the Braden head pressure. So if there's ever been an identified Braden head pressure in the offset well, it's also part of the consideration and the review in that offset well evaluation, because we could have a demonstration through logs or cement tickets that the cement was placed, but if it's ineffective and that it's manifested itself in a Braden head pressure, then that well looks or requires more scrutiny to see as to whether or not it's protective of the water. We're not isolating for the NIO, we're not isolating for the Codell in this sense. We are isolating and assuring that the offset wells are protective of the water that's uphole of the proposed formation.
Thank you very much. I really appreciate you being willing to share that with us.
Agreed. All right. Further questions for staff or the panel? All right, then we will thank the panel for being with us and turn it back to commissioners for whatever next steps commissioners believe are appropriate at this point in time. Does anybody have initial thoughts? Commissioner Cross.
I'm happy to go into deliberations, Mr. Chair, if other commissioners think that's appropriate. I know some commissioners have a hard stop at 5 today, but I'm happy to begin deliberations.
Yeah, I do know that we've got a hard stop at 5. I wonder, I'm just a little worried that deliberations are probably going to take more than 20 minutes, given that there's a lot here. And I wonder if it makes more sense to just hold this and continue it and then go to deliberations at another date, or we can get into it. I don't know if this is something we're going to work through pretty quickly or not. What are folks' thoughts?
I can say, Mr. Chair, I don't think my deliberations will be very long.
Well, then why don't we just jump into it? Let's see how far we go, and we'll stop at 5 if we're not done.
Okay. I'll start off by saying I acknowledge my lack of brevity today, but I do think it's important given the amount of public comment and public attention that was surrounding this application. And I appreciate all the stakeholders that came to the 511 hearing, everyone that filed public comments that came today and spoke again with us today. I want to assure everyone that we do hear you. We are listening. I'm just going to kind of read through some basic points here. And overall, I do think that this is a very good application. I think when you look at the location, this is by existing development. There's informed consent. There's no high priority habitat. We had the visual showing with the hill and everything today that, you know, the visual and the noise is going to be blocked by that hill. So from a location standpoint, it's good. The ALA was done well. They're doing 3-phase takeaway. So you have tankless. That means less emissions, less truck trips. That's good. They're going to reduce emissions with the offsets. They're going to reduce the surface disturbance with some of the offsets. They're plugging in decommissioning facilities. I think it's especially noteworthy that 18, I think there was 18 wells, 22 wells, 18 locations, 24 tanks, 13 produced water tanks, all being decommissioned. And of note, they were showing that a lot of these are being done near large numbers of RBUs, near high occupancy building units, near schools. I think these are all very good things. The design is going to have less separators. It's going to make it smaller. It's going to reduce emissions. I think that, again, is good things. Electric drilling, potentially doing 2 to make this go faster, getting in and getting out. I think that's good. The partial utility completions, I think that's a great thing to look at as well. The use of 42,000 gallons per day of recycled water. The remote shut-in and monitoring. I think these are all very good things. And I think a lot of these things all answer a lot of the questions that were raised in the 511 hearing, that were raised in public comments. I appreciate the work that they're going to be doing with that they have done and have committed to continue doing with the Southern Land Company, the work that they've done with Erie, including work on the road, the soil monitoring, the berm, et cetera, the work with Weld County and making sure that this is getting done. I think there's a lot of good things with this. I think when you look at especially a lot of the comments and questions that came up from stakeholders, a lot of it was dealing with the long laterals. And this is one of the reasons I try to hit on this issue a lot, is there was a lot of discussion of this being, I know we heard a lot of stakeholders call it experimental and untested. And when you look at it, when you look at what Civitas has done in other areas, including other urbanized areas, this is not experimental. This is not unique. And in fact, having these longer laterals are beneficial. And this is the kind of stuff that, not to the same extent as what a lot of people at Star wanted with the Lowry Ranch cap, but having this further away from people. And I think this allows that to happen. It allows less surface disturbance, less pads. And I think overall those are beneficial. A lot of the questions that came up as well that I wanted to try and touch on today, there was discussions of many waivers occurring and this being fast tracked. And as we saw, I don't think this was the case at all with this application. And there was also a lot of discussion that I think came down to uncertainty with what was happening in this application. And the reason I finished off my line of questioning the way I did, and I agree with the comments that Commissioner Oath raised as well, is I thought I heard a lot of really good arguments to a lot of the concerns that were raised by stakeholders, by Civitas today. To me, the biggest problem is that a lot of these responses, a lot of this information being provided was not really provided until the hearing. And to me, I think that that's something that Civitas needs to do a better job at. And part of the reason I asked about if there was any kind of public hearings, it's one thing to do individual outreach on questions, but even as we heard with some of the public comments, even some of the public commenters reached out to Civitas and some of them didn't even get a response. And so I think it really does a disservice when you have an application that has all these good aspects to it, and there's so many questions about uncertainties related to this application, it being experimental and untested, when it's really not, but that information is not being presented to the public until the last minute. And so I will say that I am in favor of this application. I do think it's an approvable application. I really encourage Civitas to continue to work with the town of Erie, to continue to work with stakeholders, not just pointing them to a website, but providing the information to stakeholders when they have the question, because I think a lot of this contention could be cut off ahead of time if they provide this information ahead of time. And I will say one final thing. Another thing that came up in some of the public comment was the idea of the analogy of being burglarized and kind of this trespassing that occurs underneath. And I think it's important for stakeholders to also understand that the mineral rights underneath are what's being accessed. And so it's not trespassing, it's not burglarizing anything if you're going through and you're getting to the minerals that you have a right to access. And so I think that's important for the stakeholders to know as well. But in an effort to keep things short and concise, I do think that there are many, many good things with this application. I was disappointed with some of the public outreach done by Civitas, and I hope that they do a better job of that in the future, because I think that could make this process a lot easier.
Thanks for kicking us off, Commissioner Messner.
Thanks, Mr. Chair. I think I'll offer a little bit of a different perspective. I think back to the mission change rulemaking and the different and the concerns that were expressed from the different local governments about this very issue that we're seeing here today. The local governments acknowledged that there was land use jurisdictions within those within their area, but the potential in these situations where impacts associated with the land use that's being looked at here, which is oil and gas development, had the potential to affect people outside of the jurisdiction, and concerns that some counties would cite things at the border of other jurisdictions, exposing potentially those individuals inside those jurisdictions to impacts, but not allowing those proximate jurisdictions the ability to have land use decision making for those particular locations. So I was pretty disappointed to see this location be chosen by this applicant, because this was part of long discussions that we had during the mission change rulemaking about this. And it was interesting because certain local governments indicated that that wasn't going to be the problem, that they wouldn't do that. And I'm not sure the reality played out, that they weren't, but we're in the situation that we're in now. And so we did create the ability for the proximate local government in the mission change rulemaking to have some influence over what occurred in our process. And I'm glad that the town of Erie and Boulder County have chose to engage in our process and be a part of this hearing. I think there's a lot of good things about this application, and I do think that Commissioner Cross has shared a lot of those. I mean, dual electric rigs, I don't think I've heard of that before. Electric production facilities, Group 3 drilling mud, recycled produced water. But the reality here is that even though there's so many good things that are associated with this, the mitigation hierarchy that is required to be followed as part of our rules, I don't believe has been followed. And so I want to go through just a few things here quick to get on the record some of the things that I'm utilizing in my decision-making process to make a determination on this application. The definition of avoid adverse impacts means to differentially select alternative locations so that those operations will not cause quantifiable, direct, indirect, or cumulative adverse impacts to the potentially affected resource. Avoidance may include a no-action alternative. CRS 3460-103.5, which indicates that minimize adverse impacts means to the extent necessary and reasonable to protect public health, safety, welfare of the environment, and wildlife resources. To number 1A, or to A, avoid adverse impacts from oil and gas operations, and then B, minimize and mitigate to the extent and severity of those impacts that cannot be avoided. We go on to look at, on page 70 of the statement of basis and purpose, that the commission recognizes that understanding cumulative impacts requires information about past, present, and reasonably foreseeable future developments, which is particularly relevant in this situation, and that legacy plugged and abandoned wells may contribute to cumulative impacts to subsurface resources such as groundwater or as groundwater. There's the sections in the statement of basis of purpose starting on page 62 that talks about Rule 304C19 and the requirements of cumulative impacts plan to clearly show how the operator is evaluating and addressing cumulative impacts of their proposed operations. There's page 172 of the 1200 series statement of basis of purpose that talks about how the mitigation hierarchy applies both in the 1200 series and throughout the rest of the rules, as it utilizes a lot of the same language and same intention in both that section and in previous sections. There's Rule 304B7F, that talks about, certain access roads and proximity to homes of access roads and how these things end up being important. There's a statement of basis of purpose, page 219, that talks about the 2,000-foot setback and why this commission determined that a 2,000-foot setback was required. And this is a long section that goes 3 or 4 pages, and I'm not going to read it, but it doesn't say that we should develop a 2,000-foot setback only for pre-production activities. It indicates that we need to have a 2,000-foot protective setback from oil and gas operations. And so I think it's really important that we don't limit ourselves to evaluating the potential impacts of oil and gas operations that we're looking at permitting to only pre-production activities, but to the life cycle of the well and the life cycle of the operations that are being proposed here. So to summarize my concerns here, I don't believe the mitigation hierarchy was properly followed. The mitigation hierarchy requires that we first avoid impacts. Avoiding impacts is best done through the alternative location analysis. The alternative location analysis is cited all through the rules, all through the statement of basis of purpose as the primary tool for avoiding potential adverse impacts. Alternative 4 is available, and the applicant did not meet its burden to indicate why they did not choose to utilize alternative 4. We had testimony today from the town of Erie that clearly indicated that not only was it available, but it's zoned agriculture, it's in proximity to landfills, and the town of Erie indicated that it would potentially be compatible to stick industrial next to landfills. And so that is in direct opposition to what the applicant has indicated, that it was not a clear path to permitting. And so alternative 4 was not in proximity to homes. There was no homes inside 2,000 feet. We understood the situation, and it was in the jurisdiction and where the potential impacts would be associated, and so gave that jurisdiction the ability to have land use authority over that particular piece. To me, that's really important consideration. I would indicate that the proposed location is not protective. There's proximity to at least 77 homes. There's proximity to a known school that is going to be located there. I mean, these are reasonably foreseeable things. They're not even reasonably foreseeable. They are known things that are going to happen there. There is going to be 77 homes in 2,000 feet. There's going to be a school there. There are playgrounds and outdoor recreation concentration areas. And I don't see that I don't see why we are making this consideration or why we're being asked to make a consideration of whether or not they're built if we know that they're going to be built within the next 2 to 3 years to me, they're built, and it still creates proximity to an oil and gas location that's inside 2,000 feet. And so, and I think this was clear to the applicant, even before they submitted this application. It was in Erie's comp plan. There was 7 years of a review process that was in process through, the Erie Land Use Planning Department. The state school requirements were all known. They were reasonably known and needed to be considered and addressed in this application, and they were not. Rule 304C19, the cumulative impacts plan that was provided was a boilerplate plan. It's the same plan that they've tried to, submit in multiple applications. It didn't address site-specific measures on how this application evaluated and addressed cumulative impacts, particularly with the quantitative and qualitative evaluation around public health impacts as required and identified by the Form 2B, but also required to be identified and addressed in Rule 304C19 cumulative impacts plan. And so I don't think that they really looked at the potential public health impacts associated with this application. And I also am a little concerned about the consultation with CDPHE and find that it lacks credibility. CDPHE didn't attend the pre-hearing meeting. They misunderstood the application in the first review. They didn't adequately address the number of RBUs that could be inside 2,000 feet, even in their second consultation, and then indicated that they didn't see any concern associated with proximity to RBUs or schools or outdoor play areas, even though we're looking at not only just 5 RBUs as they initially thought, but now at 77 RBUs, a school and a playground. And so I'm a little concerned about the level of review that occurred with that consultation. And so I don't feel like this meets our rules or the requirements of the act. I'm certainly leaning towards supporting a denial of this application. And I'm doing that primarily because I don't think that the mitigation hierarchy has been properly implemented. I think alternative 4 created an opportunity. I don't think the proposed alternative is protective, and so didn't avoid potential adverse impacts. So that is where I'm sitting right now, Mr. Chair. Thank you.
And Commissioner Messner, you continue to have a hard stop at 5, just making sure I've got that.
Unfortunately, I do. I mean, I got like a 5-minute little window there, but a buffer, but I don't have the ability to continue to 5:30 or something.
Yeah, no, that's fine. We all have our things. All right. Well, it's 4:57. I wonder, given that we've got 2 commissioners that are kind of looking at this from 2 different perspectives, I think it's going to take more than 3 minutes to get to an end result. And I don't want to hurry things. So I would suggest that we halt and continue this matter to the next meeting in which we're all available, which is in early December, the 4th, I believe it is. Mr. Thomas, do I have that right? Or is it the 11th?
December 4th is correct. That is the first hearing in December. That is
Okay.
not a meeting, excuse me.
That's one commissioner's idea, and I'll turn it into a motion. What do folks want to do? Commissioner Ackerman?
Mr. Chair, thank you. Just for clarification, if that is a relatively, I don't want to say significant period of time, but a good couple of weeks, 3 weeks, does that also give opportunity for the operator to work with the town and the counties to try to address the issue that were raised today, or or will we continue to deliberate exactly as has been presented? I'm just looking for kind of procedural clarification.
I mean, I think it can be whatever we decide. I mean, if the operator desires to do something more, that's their prerogative. They've heard from commissioners with regard to questions, et cetera, today. And I'm sorry that's 3 weeks out. I am out of the state next week, dealing with some family matters, and so I cannot attend next week. We don't have a hearing the following week because it's Thanksgiving, so that gets us to December 4th. So that's just the way the calendar's set up.
Thanks. I will second your motion, Mr. Chair.
Commissioner Messner?
Mr. Chair, I don't know if we have to continue it to a date certain or not, so I don't know the answer to that, but I would acknowledge that you have to go out of town. There is Thanksgiving in there, but if we can look at dates that are not Wednesdays, I'm certainly open to that as well, because I don't know if we have to be held to Wednesdays or not. But
we don't. Mr. Thomas or commissioners, do you want to? I think that hearing is actually kind of loaded. Is that right? Well,
yes, December 4th is not only quite full, but also in the middle of the Class 6 rulemaking schedule.
Goodness
so
gracious.
it is quite a week. I'm happy to look at non-Wednesday dates before then, if possible, if that works for commissioners.
Yeah, there's just not many. I mean, if you look at the calendars, we've got Class 6 before and after, and then we've got produced water after that. What about the 9th? Monday, December 9th. Or Tuesday the 10th.
What about tomorrow morning?
I'm not available tomorrow morning. I apologize. I've got to get up to Denver for meetings. Hold on, I'm just looking at calendars here. What about Friday morning, the 15th?
Mr. Chair, I'm okay with that. That works for me. But I did just want to say, since I didn't have an opportunity to deliberate today, understandably, as we're pressed for time, that some further work between the operator and the jurisdictions and potentially the citizens would likely benefit their cause from my perspective, which I don't know that can be done in 2 days. I don't want that to drive the process. I just wanted to get it on record.
No, I appreciate that. And I think we all need to be heard on the matter. And I think it probably makes better sense if we can do it Friday to do it Friday. And then we might be giving direction to the operator. I don't know exactly, where the majority of us are going to come down on this. But if everybody can do Friday at 9 a.m., let's just continue it to Friday the 15th at 9 a.m. and just continue deliberations with, and Commissioner Ackerman, that might be some suggestions, et cetera. But, again, due to time constraints, we've all not had a chance to get heard.
Thanks, Mr. Chair. And if that's your motion, I certainly will second Friday at 9 a.m. and have some thoughts to share at that time.
Are the other commissioners available on the 9th or on the 15th at 9 a.m.? Thumbs up. All those in favor of the motion signify by saying aye. Aye. We'll see everybody on Friday, the 15th at 9 a.m.